ahead and go on the record and reconvene the hearing. The thing I'd like to know before we begin any cross-examination today is if there are any procedural matters that need to be addressed.
Yes, Presiding Commissioner McKissick.
Yes.
How are you? Good morning. Kamal Robinson with Duke Energy Progress. So I have two preliminary matters. So first, on Monday, Presiding Commissioner McKissick, you issued an oral excusal of the EP witness, Brian Sykes. Therefore, at this time, we would ask that the direct testimony of Brian Sykes, consisting of 16 pages and two direct exhibits filed on November 20th, 2025, be copied and entered into the record. The supplemental direct testimony of Brian Sykes, consisting of 7 pages and one supplemental direct exhibit filed on February 26th, 2026, be copied and entered into the record. And the rebuttal testimony of Brian Sykes, consisting of 18 pages and no exhibits, filed on July 24th, 2026, be copied and entered into the record.
Without objection, your motion is allowed.
Thank you. And then my second matter, we would ask that the third amended comprehensive revenue requirement agreement and stipulation of settlement filed yesterday, August 12th, 2026, be copied and entered into the record. We do note, Presiding Commissioner, that the third amended version of this comprehensive settlement contains no substantive changes, only a clarifying revision to paragraph 3.2 regarding the company's future reports on the momentary average interruption frequency index event, otherwise known as MAFI-E rather than MAFI. Thank you.
Without objection, your motion is allowed. Yes.
Presiding Commissioner, Ben Stone here on behalf of Microsoft. This is a little bit unusual because this relates to the DEC rate case, but we note the Commission's order from yesterday, which we appreciate. Also note that the deadline for proposed orders in the DEC rate case is September 4th, which is prior to or in the middle of the comment deadlines established under that order. So we would just request that the Commission, if it can, clarify how proposed orders relating to large load tariff issues will be handled relative to the general proposed orders.
Take that under advisement.
Thank you, sir.
Thank you. Any other procedural matters before we begin today? Not seeing any. I see our the public staff's large load panel is before us. We're going to go ahead and affirm the entire panel. Do you affirm that the testimony you're about to provide today will be the truth, the whole truth, and nothing but the truth?
Yes. I do.
Thank you. You may proceed.
Thank you, Presiding Commissioner McKissick. Tom Felling with the public staff here with Zeke Creech. Just for clarity of the record, the public staff calls Jay Lucas, Dr. Leah Weaver, and Dr. Jethro Senganzi appearing as the large load panel to the stand, noting that they're already affirmed. Mr. Lucas, in what may be your last time testifying as an expert witness in an expert witness hearing before the Commission, would you please state your name, business address, and current position for the record?
My name is Jay Lucas. My business address is 430 North Salisbury Street in Raleigh. I am the manager of Rates and Energy Services for the Public Staff's Energy Division.
Dr. Weaver, could you please state your name, business address, and current position for the record?
Good morning. My name is Leah Weaver. My business address is 430 North Salisbury Street in Raleigh, North Carolina, and I'm an engineer in the Energy Division of the Public Staff.
And Dr. Senganzi, would you please state your name, business address, and current position for the record?
Good morning. My name is Jethro Senganzi. My business address is 430 North Salisbury Street in Raleigh, and I'm a utilities engineer with the Energy Division of the Public Staff.
Panel, on July 9th, 2026, did you prepare and cause to be pre-filed direct joint testimony in this docket consisting of 80 pages, 5 exhibits, and 3 appendices?
Yes.
Yes.
Did your testimony contain both confidential and highly confidential information?
Yes.
Yes.
On July 29th, 2026, did you prepare and cause to be pre-filed an errata and corrections to your pre-filed joint direct testimony and exhibits?
Yes.
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 And on August 12th, 2026, based on guidance from DEP, did you prepare and cause to be refiled in this docket large load panel exhibit 4 with the previous confidential designation removed?
Yes.
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 Do you have any additional corrections to your pre-filed direct joint testimony or exhibits?
No.
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 If I were to ask you those same questions in your corrected pre-filed joint direct testimony today while appearing at the witness stand, would your answers be the same?
Yes.
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 Lastly, did you prepare and cause to be pre-filed on August 7th, 2026, the summary of your joint direct testimony in docket E2 sub 1380A?
Yes.
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 Presiding Commissioner McKissick, at this time, I would move that the pre-filed joint testimony, the large load panel as corrected, consisting of 81 pages, 5 exhibits, as corrected, including the refiled public version of large load panel Exhibit 4 and their 3 appendices, along with the pre-filed summary of joint testimony of the large load panel, be entered into the record as if given orally from the stand at the appropriate time.
With this being the appropriate time, there being no objection, your motion is allowed.
Thank you, Presiding Commissioner. The panel is now available for cross-examination and questions from the commission.
Okay, very good. I see ADS first in the queue.
Yes, thank you, Presiding Commissioner McKissick. Good morning. I'm Robert Josie with the law firm Nelson Mullins on behalf of Amazon Data Services. I think I just have actually one question for you this morning. And that is, does the public staff see the terms of the pro forma ESA and its proposed tariff itself, much like the commission rules or company regulatory conditions, in the sense that Duke could request a waiver from the commission of those terms and conditions contained in those documents?
Yes, any party could request a waiver if it had a unique circumstance that it had to deal with.
Okay, great. Thank you very much. Those are all the questions I have.
Okay, very good. Google,
We wave across. Thank you.
you wave your cross. Microsoft,
Ben Snowden on behalf of Microsoft Corporation. Good morning, everybody.
Good morning.
I'd like to talk, unsurprisingly, I'd like to talk a little bit about the public staff's proposed large load tariff. Just generally speaking, is it the public staff's view that when it comes to a large load tariff, the same substantive requirements should apply to large load customers in DEP territory as in DEC territory?
Yeah, large load tariff is, I believe, identical, almost identical, except for the base tariffs that each company uses.
Thank you. And you would agree that the same considerations with respect to large load tariffs and large load customers generally apply to DEP customers as DEC customers?
Generally, yes. If you're looking for differences, the large differences are in our recommended service regulations. The existing service regulations for each company is different. So we had to modify our recommendation for DEP a little bit more, add a little bit more than we did for DEC.
Thank you. I'd like to direct your attention to pages 79 to 81 of your testimony, where you summarize your recommendations related to large loads, and specifically to page 81, recommendation number 8. And here on page 81, starting along line 8, it says that the public staff recommends that the commission require DEP to develop its CIAC process to ensure that DEP waives CIAC contributions for dedicated facilities only in instances where remaining ratepayers are found not to be harmed by standard cost allocation methodologies. Did I read that correctly?
Yes.
Okay, and that is the public staff's recommendation on CIAC methodologies? Or rather, that is a public staff's recommendation with regard to Duke's CIAC process.
Yes, and we do go into more detail in our proposed service regulations.
Thank you. And on page 55 of your testimony, you define, I'm just going to give you the definition of dedicated facilities. You can turn there. It's on page 55, lines 16 to 18. But you define dedicated facilities as projects needed solely to serve the large load customer that do not benefit other customers, such as a dedicated substation serving only that customer. Is that the public staff's definition of dedicated facilities?
Yes.
Okay. And going back to the recommendations, the panel's direct testimony does not include a recommendation that Duke apply or change its CIAC process for other kinds of required facilities besides dedicated facilities. Is that right?
That CIC process could apply to required facilities too.
Well, understood. I'd just like to focus on what the recommendations are in the public staff's testimony. I
Okay.
understand that there's a universe of things that we could be doing, but the public staff's specific recommendation in your testimony relates only to to dedicated facilities. Is that right?
Yes, that's summary of recommendations. But in our exhibit 5, give you page numbers, so we go into more detail. Let's see this is page 12 of 15 in our exhibit 5. This is not confidential. Bottom of page 12, as we start adding more detail, that's what I was talking about a minute ago. Page 14, we have additions regarding CIC. That's where we go into more detail.
Okay. Do you all recall that at the DEC hearing, I and some other council that we had some conversations about whether the public staff had recommended a specific methodology for allocating the costs of required facilities other than dedicated facilities. So required facilities, and I'm going to call those non-dedicated facilities because we don't have a term for it. So by non-dedicated facilities, I mean required facilities that are required to support a large load customer, but that provide benefits to the system or to other customers. Is that an acceptable definition we all kind of understand?
Oh, let's see this. Let's go back to page 55, I believe we were talking. Let's get that clear. Yeah, this is page 55, starting at line 9, and talking about required facilities. Projects caused by the large load customer that benefit multiple customers and or the bulk system, such as protection equipment and transmission reliability improvements, including the following: projects that will serve other customers but were triggered by the LLC, projects that were intended to serve both the LLC and other customers.
Okay, great. Yeah, that's a great definition. Can we call those non-dedicated facilities just for, is there another term you'd rather use?
I just like calling them required facilities, like we said in our testimony.
But required facilities in your testimony also includes dedicated facilities, which don't provide benefits to the system, right?
That's correct.
Okay, so I'm just trying to distinguish between
Okay, non-dedicated required facilities.
non-dedicated required facilities.
That
That sounds great. Okay. So do you recall at the DEC hearing that we had some conversations as well as you all and counsel for other parties about whether the public staff had recommended a specific methodology for allocating the costs of those non-dedicated required facilities between to large load customers. You recall that?
Yes.
Okay. And I'd like to, Presiding Commissioner McKissick, I would like to have marked Microsoft Potential Cross Exhibit number 4. And I can bring you all a copy. This is, here, I'll go. May I approach?
Yes, proceed.
Okay, and this is an excerpt from volume 14 of the transcript of the evidentiary hearing in the DEC rate case. That's docket E7 sub 1329 dated July 14th, 2026. And I would ask, Presiding Commissioner, that this be marked as a Microsoft Cross Public Staff Large Load Panel Direct Exhibit number 1.
Duly marked and identified for purposes of the record.
Okay. And I would like to direct y'all's attention to page 252.
We're there.
Okay. And this is actually, this is cross-examination by counsel for Google. So starting on page 252, line 9, counsel for Google asked the panel to talk about required facilities that provide benefits to the system. What we're referring to is non-dedicated required facilities. So Dr. Zanganzi, on page 253, line 2, you acknowledge that there may be some murkiness in understanding the benefits that may be provided to the bulk system, and this would have to be investigated further. Does that reflect your testimony, Dr. Zanganzi?
And which line numbers? I'm sorry. Page?
This would be on page 253, starting on line 2. And I'll just read, Dr. Zanganzi, you testified that there might be some murkiness there in terms of understanding what benefits might be provided to the bulk system. There could maybe be some more investigation to that. But these are things that Duke has mentioned are things that provide benefits to the system. Is that your testimony?
Yes, that is what is stated there. And to provide some color to that, much like the definition that we just read on page 55, I believe, there, as Duke had stated in their own provided materials from Discovery, yes, there are dedicated facilities that are solely to serve large load customers or various set customers. And then there are assets that are useful to provide benefits to both the larger system and also the customer. So that statement, I believe, would be correct in the sense that there possibly could be more investigation to that. But based on the definitions that Duke had provided themselves, those are the stated characteristics on the ground.
Okay, thank you. So that testimony from July 14th is reflective of your views today?
Yes, that would be correct.
Okay. Okay, and Dr. Weaver, looking at page 282 of that transcript. Actually, Dr. Zanganzi, page 282, starting on line 4.
Can you repeat that page?
Yes, sir. Page 282, starting on line 4.
Thank you.
Lines 4 through 7. In here again, you say that there's some murkiness about the benefits of the larger system that should be investigated further. I'm sorry, do you need a moment to get there?
I see it now. So this is line 4 through 7, correct?
Yes.
Let me just read this out for the record. Page 282, line 4. We're not very sure how much of that money is actually benefiting the larger bulk system or is primarily benefiting the large load customer. There is some murkiness that can be investigated a bit further.
Okay, thank you. And then down on line 19, Dr. Weaver, you say, I just want to make clear that because, as Dr. Zanganzi said, there is a lot of murkiness about what these required facilities are. Is that your testimony?
Yes, that was, that's what this states.
Okay. And is that still your view today?
Yeah, I think, different customers are going to require different facilities, and Duke is going to have to look into each customer to understand exactly how these things should be divided between dedicated and non-dedicated required facilities.
Thank you.
And I could add to that. Like I mentioned during the deck proceeding, over a time period of a little over 2 years, Duke has signed up 6.7 gigawatts of new load. That's about 3 nuclear power plants of new load. And it's not just the generation that's going to serve that load, but it's going to be a lot of transmission and distribution. This is unprecedented amount of load in a very short, relatively very short period of time. So since we have not faced this kind of new load that's going to require the generation, transmission, distribution, as it stands now, Duke Energy will have a lot of work to separate which costs will be for these large loads and what costs will benefit some other customers and some costs that will not benefit other customers.
So is it fair to say that the public staff recommends that there be further investigation and development into how the system benefits of required facilities can be determined?
Well, we do not object, per the settlement, we do not object to the further investigation and stakeholder meetings.
I would add also that, we're sort of providing guidance in our testimony as to how we think Duke should be approaching the CIAC process, but we understand that they're going to have to develop the, step-by-step specific
Great.
process.
Okay. And would you agree that with regard to any process that's developed, that it should be transparent?
As transparent as possible. That's like, for example, our recommended ESA, Exhibit 4 was confidential, and we've pushed and fortunately gotten that made made that public. So we do want transparency to a point, yes.
Okay, thank you. Actually, Mr. Lucas, on that, would you, I'd like to direct you to page 266 of that transcript. And here you are talking about that very issue.
Okay.
So this is, I believe here you're responding here to questions from counsel for Google regarding the ESA application that was attached as Exhibit 4 to the panel's testimony. And you say that this here, I'm starting the end of line 12, page 266. You say, for starters, we want the Exhibit 4 made public so that all potential customers know that they're being treated fairly and they know upfront what's expected of them. And we do add some details. Is that your testimony?
Yes.
Okay. And that ESA application there that was Exhibit 4 is essentially the same as the ESA application that's attached as Exhibit 4 to your testimony here. Is that right?
Yeah, that's
Okay.
the same. Yes.
So I take it that it's still your view that it's important for customers to know upfront what will be expected of them?
Yes.
Okay. Could you explain just the importance of customers knowing upfront, like what is going to be expected of them?
By making that document public, before a customer even begins negotiation with Duke, we have a lot of requirements of what's expected of Duke and expected of the customer. And that allows a potential customer to prepare earlier and be assured that it's being treated like other large load customers.
Okay. And I suppose it would also allow those customers to make informed decisions about whether to make those investments in North Carolina.
It allows them to start the process. What could happen, or what is likely to happen, is once they get down to final numbers, certain costs, specific costs, those will likely be confidential. But at least the starting point is transparent.
Okay. And so would you agree that if the expectations or the obligations of a large load customer were to change from what they were given up front, that could lead to some unfairness?
No. Give me a moment. This is our Exhibit 4, page 1, paragraph 7. There are changes that occur, changes in tariffs, changes in riders, changes in service regulations. And it's best if I just read it. This is paragraph 7 on page 1 of our Exhibit 4. This agreement and the applicable schedule, riders, and service regulations hereto attached are subject to changes or substitutions, either in whole or in part, made from time to time by a legally effective filing of the company with or by order of the regulatory authority having jurisdiction. So all customers have to expect changes. Like I've just said, there are changes in tariffs. We have rate cases, we add tariffs, we delete tariffs, that sort of thing. So customers do need to be made aware of that.
Understood. But to the extent possible, you would agree with your prior testimony that it's important for customers to know upfront what is expected of them.
Yes.
Okay. All right. And just a moment. I believe you testified at the DEC hearing that you were not aware of the commission ever having rewritten or revised the terms of an ESA between Duke and a customer in the absence of any wrongdoing by the customer. Is that right?
Yeah, to my knowledge, the commission's never changed an ESA term.
Okay. So there's no precedent for, with the understanding that rate schedules and tariffs that are in existence are subject to change. You'd agree that there's no precedent in North Carolina that you're aware of for the commission changing the substantive terms of an executed ESA between Duke and a customer.
Well, commission does, like what you said, existing tariffs. The commission does not change just existing tariffs. It makes new tariffs and sometimes will delete old tariffs.
Okay, understood. Well, I'll let me ask the question a different way. With the understanding that tariffs change, you'd agree that you're not aware of any precedent in North Carolina for the commission having revised or changed the substantive terms of an ESA between Duke or any utility and one of its customers.
I'm not aware of a change, but like I said a few minutes ago, we have unprecedented load growth that's going to be difficult to manage. And we have our recommended tariff and our recommended ESA and our recommended service regulations to manage that.
Understood. And Dr. Zanganzi and Dr. Weaver, are you all aware of any precedent for an ESA having been altered by the commission in North Carolina?
Not beyond what you guys have discussed in terms of changes to tariffs and creating new tariffs.
So I guess I'll say, and I understand that none of us can be in the heads of a large load customer when they sign one of these agreements, but in signing an ESA with that regulatory change language that you refer to, Mr. Lucas, the background for any customer entering into an agreement with that language is that, to our collective knowledge, the Utilities Commission has never rewritten the terms of an ESA in North Carolina.
No, it is not.
Okay, thank you. Those are all my questions.
Very good. Not seeing any other intervener who's reserved time for cross-examination, so we'll go to redirect. Yeah, we have it in the past. We have it. We can do it in this case. Yes,
Presiding Commissioner, I think just brief redirect.
go right ahead.
Panel, as the question that was asked from Amazon Data Services and your response about the commission maintaining oversight or having the authority to modify certain terms of tariffs or agreements or whatever was characterized in your response. Is that based on your understanding that the commission retains inherent authority to sort of oversee rates and terms and, regulation under its control?
Yes.
No further redirect. Thank you.
Okay,
Presiding
thank you.
Commissioner.
We'll now proceed with questions from commission staff and from commissioners. And I have a few from our staff, and I'll go ahead and proceed with those at this time. In your testimony, you criticized Duke's large load impact analysis and provided a sensitivity that reflected the lower bound of Duke's assumptions. Did the public staff conduct its own large load impact analysis reflecting what you considered to be a more realistic scenario that captures a more comprehensive suite of risks? And if so, what were the results?
So I can try to address that. So we didn't create a whole new framework and conduct our own analysis in that sense. We did a variety of sensitivities, the majority of which I believe we discuss in testimony. And so I think the basis behind that is there's this whole world of assumptions, and we as the public staff, because this was presented in redirect or in rebuttal, don't have all of the information that maybe we would like to be able to do our own analysis. So we don't have a comprehensive understanding of what the expected billing demand is going to be for these customers. We don't even fully understand. We can't match up which customers are included in this analysis. So we relied on Duke's analysis. I will say one finding we had with regard to that billing demand, I believe it's in our testimony, is that the sort of break-even point of when the benefits exceed the costs at the end of 15 years was an 83% billing demand. So, that gives some sense of where the boundaries are. But I'll just reemphasize for the commission that our point with the analysis and what we presented is that the fact that the benefits outweigh the costs is a finding. But even more important than that is the timing over which that occurs and the fact that those costs are exceeding the benefits, at least for the first 8 to 10 years or so. So I hope that answers the question.
Thank you. Under the large load impact analysis, what factors are necessary in order to achieve a positive net impact within the given time frame?
So it depends a little bit on which basis you're looking at. If you're looking at the NTAP timing of resources and the gas generation being used as a proxy for the generation required, then it would be that 83% billing demand is that break-even point between the costs and benefits. I don't know that we there's a lot of variables in there in terms of the prices of the tariffs and that sort of thing, and we didn't adjust those from what Duke had started with.
And one benefit, if we have additional customers that are able to buy more energy with existing generation, that is a benefit to all customers. Duke would be using his existing facilities and selling more energy using existing facilities. But like we've pointed out, though, Duke's existing facilities will not be able to serve large load customers for very long, maybe in a very short term. But that's when Duke's going to have to add more generation, transmission, et cetera, that increases costs to customers.
All right. Now, in your review of Duke's large load impact analysis, under what assumptions did it demonstrate a net zero benefit when including the time value of money and using the LSG TOU rate schedule?
Just give me 1 second.
Sure. Take your time.
I'm afraid I don't have an answer to those questions for you as I sit here.
Okay, that's fine. Do you think you'd be able to file a late file exhibit that would provide that information?
Yes, I think we could do that.
If you could do so, that would be excellent. How did DEP's existing and proposed LSG TOU and LSG HLF rates reflect the cost of new large load customers?
Well, for example, DEP's HLF tariff works well with very high load factor customers. That's where demand charges are higher, and those customers would be paying more for the facilities they use. But like we say, we don't think these tariffs are sufficient right now, because right now customers have an option to pick and choose which tariffs they want to serve them financially. And these tariffs were not designed to recover the very large amount of generation and transmission that's required to serve them. So some of these tariffs are in the right direction, and we feel like our recommended tariff is a good thing to add on top of these tariffs, and along with our ESA and service regulations, that will bring fairness to all customers.
Thank you. Your large load recommendation did not include assignment of incremental generation costs. Please explain why you chose not to include these costs, and in particular, any challenges you identified in doing so.
It is difficult to assign generation to an existing customer. A brand new generation plant does serve all customers. Because of one reason, Duke's retiring old plants, and a new plant won't break as often. It has a longer depreciation life. It's typically more efficient and have lower energy costs. We have dug deeper, and we do have some concerns about that. And I can explain a little more if we go into confidential session. I have more information on that.
And I would
Okay.
add, if you don't mind, from a modeling perspective of how that works when we are running the models for the IRP to try to decide what generation is needed. All of these factors are being combined into a single run. So the load forecast, including the large load economic development portion of that, but also how everybody else is growing with EV load, and then the retirement of plants, and then the adjustments for behind the meter generation and EE and that sort of thing. So it's this big pot of assumptions that all goes into it, and then you get an output. And so disentangling exactly what generation is caused by the large load is difficult.
Yeah, but we are concerned. I mean, all of this new large load will require additional generation. It's like Dr. Weaver said, it's somewhat difficult to untangle it. And that's all I can say on it right now without getting into confidential information.
Well, based upon your response, it seems as if it be timely to go into a confidential session so we can obtain a fuller, more complete answer to the question. So what I'm going to do at this point in time, John, if you could terminate the live feed of this hearing, I will look to the attorneys for Duke and others to see if there are any people in the And we'll go on to the next question in the queue. Can you describe the differences between how CICA amounts will be calculated for what you are calling the dedicated facilities that have been built for large load customers and the required facilities that benefit both the large load customers and other ratepayers?
Yes, the dedicated facilities will be relatively simple. Duke should be able to identify items like direct transmission lines or substation transformers built to serve a large load. Going further back into system, adding transmission lines to feed substations, larger substation transformers will likely have the ability to serve other customers. That's a more difficult task when separating costs. But as we sit today, Duke Energy will have to take that on. It's going to have to anticipate what load is coming up from other customers and what load will be apportioned to that specific large load customer. And that's a task that Duke will have to do. And I think that's how the separation is going to have to occur between dedicated facilities and required facilities.
And can you explain the difference in an interaction between the required facilities charge treated as CICA and the upfront payment of 60 to 80% of the required facilities costs that you describe on page 64 of your testimony? And also, how does the upfront payment or irrevocable letter of credit for 60, 80% of the cost impact the required facilities charge?
Before Duke can come up with that 60 or 80%, it's going to have to determine dedicated costs and required facility costs and come up with a number. We make that recommendation because once Duke signs an ESA, it's going to have to commit resources, planning and engineering resources to start to serve that customer. That's why we want that upfront payment. And as time goes on, Duke will have to begin construction of facilities to serve a particular large load customer and do the calculations that I mentioned a minute ago to say this is your dedicated cost. You have required facility costs that for system components that are going to serve you. And for example, 70% might be serving you, but be 30% that will be serving other customers in the area.
If I could add to that,
Sure.
Commissioner McKissick, and Mr. Lucas can correct me if I'm misinterpreting this, but that section for the 60 or 80% is also discussing like potential letters of credit and security. And so
Right.
while it could be an upfront payment that is going towards the cost, it's more just hedging against the risk of that customer leaving. So the customer will be responsible for paying whatever CIAC Duke determines, but it's posted up front that it is able to pay that, if that helps.
Thank you for that supplement. Regarding the determination of the required facilities costs, let's say the actual cost to construct the required facilities end up being significantly greater than the estimated cost. Who bears the cost recovery of that difference?
We believe it should be the customer that needed those facilities.
And the follow-up, of course, is are the required facility charges or payment expectations updated to true up to actual cost?
We believe they should be. If Duke's having to serve a customer, and if there are inflationary pressures or something that that all parties are going to have to recognize, Duke Energy and the customer, yet the customer is going to have to pay for that.
Thank you. Now, the incremental cost test conducted for the required facilities is based on the rate schedule used by the large load customer. And of course, that's on page 60 for your testimony. So what happens after the next rate case? Would the incremental costs be rerun to ensure the required facilities charges are most accurate?
Yes, we think they should be, because if Duke constructs required facilities and some of that facility is dedicated or necessary to serve a customer, but there's also customer growth that can use some of the excess capacity. Yeah, it could be recalculated. If Duke's using those, that necessary capacity to serve other customers, those customers should pay for it, not the large load customer that initially triggered the required facilities.
Thank you. Now, in the comprehensive stipulation, the parties agreed to remove the interconnection cost of large load customers B and C while retaining the interconnection cost of customer A without revealing the identities of these customers or any confidential information. Can you describe what difference between these customers' interconnection costs and their associated benefits that led to customers B and C being removed and customer A being retained?
Yes, I can speak to that. So, with regards to customer B and C, some of their costs were removed because of the time from when they were put in service, or they were stated to be put in service, and actual delays on site. There was an agreement for those costs to be removed. However, with respect to customer A, that site was already in service and collecting some revenue. So when going through that with stipulating parties, it was agreed upon to have those costs in place, as the revenues that would be taken in would exceed the necessary required revenue requirement values for that respective customer.
Thank you. That covers our questions from our commission staff, but let me look to my colleagues to see if there are other questions. Chair Brawley?
No question.
Commissioner Tucker, go right ahead, sir.
Thank you, Presiding Commissioner. Just a couple of questions. Mr. Lucas, you received questions from counsel from Microsoft about precedent of contracts, et cetera, earlier in this discussion today. When did public staff have the opportunity to review an ESA?
This past spring, we got copies of ESAs in the E-100 sub 208 docket. So it was this past spring, we first got copies of ESAs.
Are you aware of any contracts or ESAs signed with data centers prior to you seeing that or being informed
No,
by Duke from the public staff?
no, we have not.
Okay. You stated earlier, if I recall, and correct me if I'm wrong, that I think you used the term Duke all of a sudden signed a 6.7 gigawatts of new load in a very short period of time.
Yes, it was just a little over 2 years, which is a short period of time for signing on that much load.
Right. There's no precedent historically for that either, is there?
No.
Okay. Did you, well, was there any effort made by Duke to make you know how many ESAs were in the queue? Or did that come in the spring as well?
That came in spring and it came at our request.
If I could add, I don't remember the exact timing, but I think it was after the 2023 CPRP when Duke started filing their large load updates. So while we wouldn't have seen the actual ESAs, I think those do have a breakdown of total capacity of ESAs signed.
Okay. Was there any discussion with public staff about the parameters of the contracts and the assignment of cost for generation, transmission, and distribution with public staff prior to signing the ESAs?
No, and that was one of our concerns, that the ESAs terms changed. They evolved. Some earlier customers had different requirements than later customers. And that caused concern that Duke can change an ESA at any, as it stands now, Duke can change an ESA at any time. They can change the ESA tomorrow if they wanted to. So that's one reason we have our recommended ESA.
Okay, very well, sir. No further questions.
Thank you, Commissioner Tucker. Commissioner Vanderwerk? No? Okay. Do you have questions, sir? Okay, very good. In that case, we'll go to questions on commissioner questions. Please identify yourself for purposes of the record.
Yes, sir. This is Nick Jimenez for NCJC et al. Just, I think, two questions. Commissioner McKissick asked you a question about incremental generation for large loads. Do you recall that?
Yes,
Now, whether it's within a large load tariff or standalone, couldn't a clean transition tariff allow large loads to pay for incremental generation?
yes, a clean transition tariff could allow a particular customer to sign up for a specific type of generation. Yes.
And Commissioner McKissick, Presiding Commissioner McKissick also asked about kayak, a couple questions about kayaks.
Yes.
If kayak costs are imprudent in some way, this is just kind of a clarification. Can you explain how that's handled? Like, can the customer challenge it? Would it come to the commission?
Yes, we could review that. If that customer could submit a complaint to the public staff or file a formal complaint and get that reviewed. Is there anything else? I'm sorry, what else? Maybe if you restated your question, I could provide more.
I think that answers it. It wasn't clear the mechanism to challenge. I think you've answered it.
Okay, and what you were saying about the CIAC, one thing we look at is what is paid for by Duke's other customers. If they're having to make contribution in aid to construction that might incidentally serve a large load customer, that was what we were cautioning about. But if a large load customer had CIAC that it felt was excessive, that's where that customer has an option to submit a complaint or file a formal complaint.
Okay, no further questions.
Thank you. Any other parties have questions on commissioner questions? Okay, well, it looks as if you're ready to be released at this time. I would like to say, Mr. Lucas, thank you for your tireless dedication and service for over 30 years. The public staff and the using consuming public in North Carolina have been well served by your research, by your analysis, by your advocacy. And we have commission have gained thoughtful insight as a result of your testimony, not just in this proceeding, but in the many, many, many proceedings that you've testified in over the years. You've earned an opportunity for retirement. I certainly wish you the very best on behalf of this commission, but it's going to be hard to replace you in terms of your knowledge, your institutional memory relating to so many issues, and more importantly, by the keen sense of facts that you're able to grasp, analyze, and share with us in the testimony that you provide. So
Well,
thank you very much, sir.
Thank you. It's been an honor to serve here.
Absolutely. We're going to go ahead and take a 5-minute break. Let the record reflect that this morning Commissioner Guider had a pre-existing commitment that did not allow him to be here today. Of course, also indicate for purposes of the record that Commissioner Vandervaart has been here since the beginning of the hearing. Commissioner Guider has been listening through YouTube, and we'll have appropriate motions later dealing with their ability to read into the record. So we're going to take a 5-minute break. We'll be back at approximately 10:30. Thank you. Before we get started, I want to recognize Mr. Snowden for a motion.
Thank you, Presiding Commissioner McKissick. It's been brought to my attention that I neglected to request that my cross exhibit be moved into the record. So I would move it for that at this time, please.
With that objection, your motion is allowed.
Presiding Commissioner, if I might be heard, while we have no objection to the specific portion of that transcript coming into the record, I do believe that it would be appropriate under Rule of Evidence 106, also known as the rule of completeness, that when a writing or recorded statement or part thereof is introduced by a party, an adverse party may require him at that time to introduce any other part of that writing or recorded statement, which ought in fairness to be considered contemporaneously with it. So because the cross-examination of the large load panel in the DEP case was sort of one continuous recorded statement with multiple discussions on kind of rediscussions of topics, including redirect from council, question from the commission. I think it would be appropriate that the entire transcript come in out of fairness to the panel. So I would just ask that instead of the excerpt coming in, the public staff has identified those transcripts in their redirect. I'm sorry, Commissioner,
But take your time. Following your line of thinking and concur that having appropriate context rather than guessing that SERP would allow for the completeness of the record.
Thank you, Presiding Commissioner. And so those were public staff redirect exhibits 6, which is the commencement of the cross-examination of the large load panel, 7, which is transcript 15, and 8, which is transcript 16, an excerpt concluding their testimony, if it would be appropriate for those exhibits to come in lieu of the transcript. Excerpt.
Presiding Commissioner McKissick, I have no objection whatsoever to doing it that way, but perhaps Council of Public Staff and we can confer offline sort of when we next break to make sure that we have the right volumes of the transcript.
I think that's a great idea. So the two of you confer, and we'll get that concurrence of opinion included as part of the record so that the record is full and complete.
And Presiding Commissioner Kissick?
Yes.
May I be heard? We are obviously back in the same territory we explored 2 days ago, and while we have not had a chance to assess the specific portions of the transcript, we're back into the general conceptual problems of if we're going to let in a portion of the transcript with a particular witness talking about a particular topic, I'm not sure why it would not also be reasonable to allow other portions of that same transcript from other witnesses addressing that same topic. And then we're sort of down the rabbit hole of where does this stop? And so I think for all the reasons we articulated yesterday, stepping foot down this path feels very problematic to us. We understand the desire for efficiency, but I think if we're going to go down that path, then I think we're going to have to ask for the right to, for the same reasons that Council of Public Staff articulated for completeness of the record, ask for other portions of that same transcript addressing the same topics to be included in the record.
All right. What we're going to do is this. I understand your concern about it being a slippery slope. Also understand what's been stated by both public staff and by Microsoft. So what we're going to do is reserve ruling until you all can talk and confer and perhaps reach a concurrence of an opinion. If you cannot reach a conclusion and have a concurrence of opinion, then I'll rule appropriately on what's been put before us. And with that said, yes, it looks like
I apologize.
now we now have Sigford ready to.
Presiding
Is this,
Commissioner
how slippery is this slope going to become?
It is. It does become slippery, but just along those same lines of what's just been discussed, Sigford would add to the voices, indicating that if we're going to let in the testimony from the DEC hearing as it pertains to this issue from one party's witness or panel of witnesses, then it does, I think, open the door for inclusion of other parties' witnesses who address the same topic. And along those lines, we would also ask that the transcript volume pertaining to Sigford witness Brian Collins on this issue also be part of this record if the commission rules in such a way that it allows the large load tariff testimony to come in from the DEC rate case from a different party's witness. Understanding we are happy to work with other parties during the break to try to reach an agreement here, but we would just echo that as well. And Mr. Felling, I'm sorry, I couldn't write down your numbers quickly enough. Potential redirect.
Those
exhibits.
were items 6, 7, and 8 from the public staff's potential redirect exhibits.
Thank you.
Yeah, and of course, Mr. Snowden did identify specific excerpts that were pretty full and complete. I understand the issue dealing with context, and so you guys try to work it out. If you cannot work anything out, I will make appropriate rulings at that time, and we'll take it all under advisement, what you all have each articulated, understanding the potential complexity and the slippery slope that we could find ourselves in. It's always good when everything is in one transcript and you're not going back and forth between transcripts to figure out what was asked and answered and why. So keep that in mind as we work through this potential issue. Now we have the Attorney General's witness before us. So if you would like to go ahead and introduce your witness, and we'll put him under oath.
Okay, the Attorney General's office calls Justin Brandt to the stand.
Give me one quick second. Here you go, Chair Brawley. Do you solemnly put your left hand on the Bible, raise your right hand? Do you solemnly swear the testimony you're about to provide in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Would you please state your name and place of business for the record?
My name is Justin Brandt. I'm a senior manager at Current Energy Group.
Okay. On or about July 9th, 2026, did you cause to be pre-filed in this docket direct testimony consisting of 68 pages, 1 appendix, and 2 exhibits?
I did.
Did your testimony contain confidential information?
No, it did not.
Do you have any corrections to your pre-filed testimony?
No, I do not.
If I ask you those same questions today under oath, would your answers be the same?
Yes.
Finally, did you cause to be pre-filed a summary of your pre-filed testimony on August 6th, 2026?
Yes.
Presiding Commissioner McKissick, I respectfully request that Mr. Brandt's pre-filed direct testimony and his witness summary be entered into evidence and copied into the record.
Without objection, your motion is allowed.
Mr. Brandt is available for questions from the commission.
All right, sir. Thank you for being here today. We do have a few questions here from our commission staff, and we may have additional questions from my colleagues that are here. First question, sir. You recommend creating a new large load customer class for customers over 100 megawatts. Can you explain why you recommend a new rate class for customers over 100 megawatts of load and not a new rate class for large load customers between 20 megawatts and 100 megawatt loads?
Yeah, I think it's, I guess, an issue primarily of around cost causation for those very large customers over 100 megawatts. They are very likely to require incremental investments in generation and transmission resources in the system. And given that, I think it's easier to address issues of cost allocation and cost causation with those customers by assigning them a new rate class so that it can be addressed appropriately rather than lumping them in with the existing rate classes as proposed by the company. For customers between 20 megawatts and 100 megawatts, there are certainly risks and likely investments needed to serve them, but the magnitude of those investments is just smaller and can be appropriately dealt with the existing rate class structure.
And can you explain how this would help or hinder allocation of generation, transmission, and distribution costs driven by these customers?
Yeah, I guess as I just alluded to, your discussions with the public staff previously around the challenges of directly allocating both transmission and generation costs. Again, I think there are emerging ways around that we're seeing in other jurisdictions around how those costs can be allocated appropriately, and that they're paying their fair share. And again, having a customer class, not trying to do it customer by customer, but thinking about the class of large loads as a whole and the cost that they are causing, it is likely easier and more representative of cost causation and would provide a fair outcome for all customers moving forward.
Okay. And on pages 26 through 28 of your testimony, you reference how 5 states, those states being Arizona, Wisconsin, Florida, Georgia, and Minnesota, are departing from traditional cost causation approaches to recover specific generation and infrastructure costs driven by large loads. For our benefit, can you, at a high level, provide us with an overview of the cost recovery approaches in these states? And why don't we begin with Arizona?
Sure. So Arizona, I guess it is a sort of interesting and unique model. So they are essentially trying to split up growth in generation between new generation that's replacing retiring resources and new generation that is being built to serve growth, which is not completely, but primarily from data centers in that jurisdiction. So it's a little complicated based on the effective load carrying capacity, but they are using the load carrying capacity and sort of their integrated resource plan modeling to try to distinguish which of the generation that's being built will be serving those new customers and allocating costs on growth based on the addition to incremental load from different customer classes rather than including it with embedded rates and allocating it based on sort of traditional cost allocation approaches, and then allocating the sort of remaining embedded costs as you would traditionally using their standard cost allocation approach.
And let's move on to Wisconsin.
So yeah, Wisconsin has really just directly assigned the generation costs to large load customers. Wisconsin is another interesting model where they've sort of created a separate utility for large loads. I don't know that I would advocate for that because they're not also paying towards embedded costs. They're really just being directly allocated the new generation costs and being fully allocated those costs.
And Florida?
Florida Power and Light, they've created an incremental generation charge. So they've essentially tried to directly assign those incremental generation costs in addition to the large load customers paying the full embedded cost rate for generation.
And for Georgia?
Georgia is still, I don't know, essentially they've reached a stipulation that Georgia Power will be paying incremental revenues, but the determination on how that's going to work will be in the next rate case, which I believe will not be filed for 2 years. So there's a movement in that direction, but I don't have any specifics to share with you at this point.
And Minnesota?
Minnesota, so Excel has filed, so there is a law requiring direct allocation through of distribution and transmission costs through a kayak. On the generation side, the approach I'm aware of is that Google for a large data center there and Xcel Energy have reached an agreement on a suite of incremental resources, and they're using a clean transition tariff model to directly assign those costs. So under that model, the customer pays upfront for the full cost of generation and then receives a credit on its bill based on the capacity and energy produced by those dedicated resources.
Okay, and have any of these tariffs been implemented for more than a year, and what results have you seen from their application? I think you spoke to that in part, but perhaps you could do so more explicitly.
I don't believe any of them have been implemented for more than a year, potentially Florida Power and Light. But when that tariff was created, there were no customers under it. So while that might have been implemented, for a year, potentially. I don't know that there are a lot of lessons learned. This is a rapidly emerging topic area, and unfortunately, the results there's not a lot to share on results yet, but I think the goals of all these jurisdictions taking different tracks are the same, which is to prevent costs from being shifted in the short term to all their customers who would see their rates going up for a potentially unknown future benefit of rate relief.
And at a high level, can you describe any implementation concerns with these cost allocation and cost recovery approaches?
Yeah, I mean, I think, like I said, the primary, I think, things that need to be balanced are providing minimizing rate impacts to other customers in the short term, but also providing the potential that there could be benefits in terms of rate reductions if these loads are maintained in the long term. So having the proper tariff structures in place to ensure a steady stream and a long-term stream of costs and financial commitments from large load customers, as well as so I think, given that, like I said, the model in Michigan or Wisconsin, is where essentially they just directly assign those costs, and that's what they pay for generation rather than also paying the embedded rate. It is not desirable, but trying to think of hybrid approaches where you are both directly assigning costs as well as assigning a portion or all of the embedded rates to those customers so that they are minimizing those short-term rate impacts. But again, if providing potentially long-term benefits to other customers.
And what approaches would you say largely shift the cost risk to large loads, and which ones partially shift that risk?
I think so direct allocation or a clean transition tariff fully shift the risk to large loads. And then some of these hybrid approaches, I guess one partially shift the risk. So like what Arizona Public Service Company is doing. I guess one I didn't mention in my testimony is in Colorado, where Xcel Energy is proposing what's called a higher of test. So they're doing modeling on the generation side to assess the incremental generation being built to serve the large load customer class that they're proposing. And then when those costs are put into rates, they'll conduct a test to ensure that the embedded rate would cover at least those incremental costs for those customers. And if it doesn't, assign sort of an adder on top of that to ensure that it does. So I think some of these, that's a partial shifting of risk. I guess I will just want to put a finer point on it, that none of these benefits will accrue to other customers unless that load is included in the billing determinants in a rate cut case. So as my colleague Ed Burgess testified in this case, that's not what's happening here in the multi-year rate plan for Duke Energy. So, all of these benefits in the future are theoretical unless we're ensuring that we're actually incorporating them into our cost allocation processes. And if we're not doing that, then these excess revenues just go to shareholders rather than being returned to customers.
All right. Now, you note on page 44 of your testimony that a well-designed large load ESA should include direct assignment of line and service extension and incremental generation upgrade costs. Now, do these line and service extension costs include transmission and distribution costs triggered by the large load customer, or are they defined and determined in a different way?
No, I would define them as incremental transmission and distribution costs. And I guess here I might would agree with staff. I think network upgrade costs, transmission network upgrades would be included in that. Given the size of large loads that we're seeing come onto the system, the traditional methodologies we've used of assuming sort of social benefits from network transmission upgrades is no longer the case. And that thinking of ways to directly assign those transmission costs to the large loads is appropriate rather than socializing any of the transmission upgrades needed or distribution system upgrades needed to other customers.
And could you elaborate on how incremental generation upgrade costs are defined in the context of least cost system planning and coal retirements?
Yeah, again, it's challenging, but I think through modeling, it is possible to identify those costs to the best of our ability. So like I said, there are utilities like in Colorado and Arizona that are conducting their IRP modeling or will be when they're putting things in rates with and without large loads to try to determine which of those resources would not be needed but for the addition of large load customers. And by doing that, you can identify incremental costs, even though the electrons from that resource are not being built solely to serve large loads.
And could you describe how incremental generation upgrade costs are allocated per your recommendation, given the benefits are shared by all ratepayers?
Yeah, again, I think we've talked a lot about there are options here on how you think about assigning those but-for costs. Based on sort of FERC precedent, those you can consider those options in a few ways. One is this higher of principle where you're paying the higher of the incremental generation costs or embedded costs, or what's called and pricing. So you're paying for embedded rates and the incremental costs. So again, I think this is why I recommended consideration of this in a future proceeding. I think open to it in this proceeding, but there are a number of pathways, but it is complicated and it's hard to have these discussions in the abstract without sort of real numbers before you.
And let's say the actual cost to construct the generation ended up being significantly greater than the estimated costs that were used to determine the incremental costs. Who bears the cost recovery of that difference? And would the incremental cost be updated to true up to the actual cost?
Yeah, the jurisdictions I've talked about, that's the approach they're taking. I think you do the modeling to get an estimate of what the transmission and generation costs may be so that you can have your sort of best recovery. But once we actually build the resources, those should be trued up to the actual cost.
Okay, and based upon your research, which tariffs in other states have addressed direct assignment of incremental generation, transmission, and distribution costs most effectively?
So a lot of the proceedings we're talking about are still in process. It have not been approved, so it's hard to point you to one because we don't know exactly what it's going to look like. I think the areas the ones we've talked about are good examples. Oregon, in response to legislation really recently, within the past week or two, released a decision around a sort of large load. I don't think it's a tariff itself, it's more the requirements that will be in it. And I guess suggest looking at that one. I think it's a pretty good example. But then additionally, the ones we've talked about are sort of what I'm seeing it as good practices. I know. Yeah, so unfortunately, it's still a work in progress and everyone's, I guess, building the plane as we're flying it or whatever the analogy is.
Now, in your testimony on pages 57 to 58, you criticize Duke's large load queue process and recommend establishing a process to ensure more certainty in the queue. What additional financial commitments do you recommend be applied to projects within the queue? And likewise, what financial commitments do you recommend be applied to those who fail to execute a LA or letter agreement and re-enter the queue?
Yeah, I mean, I believe, as I stated in my testimony, I think the requirements that Duke has put in place in the last year or two are pretty good in that it sort of requires projects to keep moving at a reasonable clip with increasing financial commitments. I think the areas I disagree with, and I can't remember. I believe they do have to pay for transmission costs up front based on Duke's FERC-approved transmission tariff. I guess if that's not the case, I think you'd want upfront payment of those that could potentially be credited back, depending on how your determining it. But I think the process in place is relatively good in that, and the time limits that they're putting on sort of each step is important to keep a process moving. So you can't just have potentially speculative projects sitting in the queue. I think the concern I have is projects that entered the queue prior to these requirements. So there's a number of projects that didn't have to post security, that didn't have to pay the application fee, that's not subject to the time requirements that are just sitting in the queue. So I think developing a process to either move those projects along or send them back to the beginning of the process where they would then be subject to the additional requirements that have been put on projects that entered the queue since then, is important, because at this point it's just unknown, are these projects not moving at all? Or they, they're just staying there and it's hard to plan for.
Have you seen that successfully addressed in any other jurisdiction for those pre-existing ESAs?
I believe so in Dominion, in Virginia's T1 rider case, this was an issue, and I believe it was addressed for historical projects as well, but I'm not 100% certain, and I apologize if I'm misrepresenting it.
Okay, do you know any of the details or specifics about how that was handled, or, and if you don't, then it's fine, I just didn't know.
I don't know the details off the top of my head.
That's fair. I think you've covered all the questions from our commission staff, but I want to look to my colleagues for additional questions they may have at this time, beginning with Chair Brawley. Commissioner Tucker. Go right ahead, sir.
Good morning, Mr. Brandt.
Good morning.
The 5 states that you outlined that have moved forward but have not completed and their works in progress. The one question I have on my mind is if they do transmission, generation, and distribution solely to enhance the grid for a data center, there may be benefits from periphery customers in that area. Are they trying to separate those costs and come up and allocate that, or they just go ahead and charge the data center and that's a gratuitous upgrade to the community and just let it go, because it's very difficult to determine, those kind of things. Where are they on that?
Yeah, like I said, it sort of varies between the different models. I think some just directly assign the costs and say your costs, these costs would not be built up for your facility. And even if there are auxiliary benefits to all customers, it's still your cost causation that is causing them. Whereas some jurisdictions, I think like Colorado, I talked about, are trying to think about how you thread the needle a little on that by saying, we're going to make sure you're paying at least your incremental costs. And then any cost you pay on top of that are sort of a benefit. But I think the assumption under that type of model is that there are some, benefits that may be socialized, that, those, I'd say those hybrid approaches are just much more challenging, and you're likely to assign some costs to other customers in the short term who would see rates go up. So there is, there is risk there about rate pressure for other customer classes, unless you're just directly allocating all costs.
Okay. With the 5 states that you've outlined, and would you agree with me that the overall theme of what they're trying to do with each one of these outlines for large loads is to make the very best effort not to impact the rates short term on any of their present customers? Is that the whole basis for this?
Yeah, generally, yes. It's to ensure that large loads are paying their incremental costs.
And that number would be what, 80%, 100%?
It varies state by state. Some it's 100%, some it's, I think in a lot of those states we talked about, the goal is that it's 100%.
Okay. One other question. Are you familiar with what happened with the in Ohio? They came up with a pretty significant percentage of cost of construction. And when that came out and they directed that to be the way business was going to be done and the data centers were to pay the higher amount, there were a number of customers that did not stay within, for lack of a better term, the queue. Has that happened in the other states as well? I mean, my point being, I'm told that Duke has 20 plus in the ESAs. If there is a change, and there would be a substantial change here towards the cost of construction by the commission, would you take the position that some of those customers would move on to other jurisdictions that may have a lesser charge from a pure business standpoint?
So I guess I've heard of the project cancellations in Ohio. I guess I hadn't heard it characterized that it was all due to changes in the utility tariff. I think, you know, as I talked about in my testimony, there's a lot of speculation right now and a lot of risk that large load customers are, you know, if you add up that a lot of the load in the queue for Duke and many other utilities is highly speculative and may not appear. So I guess I would err on the side of creating requirements so that the risks of overbuilding the system and having huge amounts of stranded assets are not put on the backs of residential and other ratepayers in the long term, rather than I think a concern about large load customers potentially leaving the queue if you put in the appropriate requirements, because I think it's really hard to say which of these loads are going to show up and why they're built or not, and attribute it to one thing. So I guess I hear your concern, and it's certainly something to balance, but I think the other side risk is much higher.
So would you say that if you come out with any state, us or any other state that has a cost of construction requirement that's there, that is significant from a pure business standpoint, that the ones that stay would be certainly concrete customers that would be the ones, and it would flush out the ones that were, for lack of a better term, I'm not a lawyer, shadowboxing with the idea of coming to North Carolina, they would probably move on, right?
Yeah, I agree. I think, and I think it's not just the direct cost assignment, it's ensuring that the contract term and minimum bill and exit fee provisions and all the other provisions of the service territory are stringent enough to protect other customers. But I think I totally agree that the suite of putting appropriate protections in place will hopefully cause the speculative customers to go away, and you're left with the serious ones.
Okay, very well, sir. Thank you. No further questions, sir.
Thank you, Commissioner Vandermark.
Thank you very much for your testimony. You might be just bright enough to help me try to understand some of this stuff. For one thing, you're talking about the classification, and the idea being that by focusing on the group that fits in that classification, you think you got a better shot at being able to allocate the costs in the incremental and the but-for categories. And tell me about Virginia. I thought Virginia was playing around with the class. Am I wrong about that?
No, they've so I know for Dominion in Virginia, that's what I'm most familiar with. They have created a customer class for all customers over 25 megawatts. So they have gone that way. I think it took a little bit to get there.
And that's a pretty low number. I would think that, I'm more in the camp of 100 megawatts or something like that. Do you
Yes,
understand?
25 is one of the lowest we've seen, though there are a number of utilities in a similar with a similar threshold. I think.
But the classification probably has other requirements that weed out just a regular old 25 megawatt, somebody making widgets, or no?
I don't remember if they have a load factor requirement for Dominion. I don't believe they do off the top of my head, but I'm not 100% sure. I think, that they're the biggest data center market in the country.
I know, that's why I'm looking at them, right?
So
Exactly.
and so we're seeing at least early in the process, a lot of the customers in their queue were in the 25 to 50 megawatt range. So I think that's why they chose to go with that level. I don't know if that's still the case as data centers have been getting bigger, but I think we see a potential, right now everything's bigger and bigger, but a potential for it to come back to maybe more smaller and distributed, and wanting to make sure that we're not having to sort of relitigate all these issues in 5 years, just given how fast things are changing.
So maybe historical. Okay, so I get, so that your approach there says, maybe we'll get a better precision on true allocated costs. Then I got a question about financing those costs. So, I mean, in a very simplistic way, we could, once you define those allocated, say, incremental generation costs, whatever it is, that could be paid upfront and by the customer completely and not refunded back in some kind of mechanism. And in that way, those assets would remain outside of the rate base. Is that right?
Correct.
But I could also give some sort of a deposit and then get some kind of refund scenario. And at the end of that term, if there are any undepreciated value, then those, well, actually over that period, would those assets go into the rate base?
Yeah, they usually would go into rate base. And then, I think the idea is with mechanisms like that is that if you sort of, ring fence everything and just directly assign it, not in rate base, then large loads are likely not also contributing to the existing system in that mechanism.
Well, wouldn't they also pay charges
You could do that, and I think that's what sort of the Florida Power and Light's trying to do, and Georgia Power. Again, sort of works in progress. But I think you have to make sure that you're doing that, because like I said, in Wisconsin, they've essentially ring fenced all the generation, directly assigned it, and large loads are not also paying embedded generation costs.
Yeah, that doesn't make sense unless they actually co-locate the generation and go off in an island somewhere, but they're still getting a benefit off of the system, the reliability, et cetera. So
agreed.
So why would, from a ratepayer standpoint, why would I pick the latter rather than the former mechanism? Because wouldn't the ratepayer be saddled with a pretty substantial increase in their rate base under the secondary model that we talked about?
So, I think there are I think the ideas you're trying to balance is ensure that it's possible to that long-term benefits can flow to other customers if large loads stick around and pay their rates for a long time. And it gets a little more challenging sort of with the ring fencing, but I guess agree it's much simpler and you are much less likely to assign any costs.
Well, and I'm talking about the financing model. I'm sorry, I'm talking about the financing model. I agree with the class being a cleaner approach. What I'm saying is if you pay upfront and that asset never enters the rate base, the guy may the guy may operate for 15 years and he may leave, but who cares? It's paid for, right? Mm-hmm. The other option is, he may leave in 15 years, but there's still this asset that's been added to the rate base and the ratepayers are having to pay for that. Why would, and again, appropriately charging in the first model, any benefits for being on the system? Yeah. Okay. It really should be a wash, by the way. But why would a ratepayer want to see the second version rather than the first version?
I guess I don't know that a ratepayer would want to see it. I think the challenge
utility would want to see it.
The utility would want to see it because they would certainly earn on that rate base. And then I think the other thing, and I don't know, given the scale of the companies we're talking about in this room, is just it becomes you're sort of requiring that only large customers, huge in multinational corporations would have enough resources to enter the market. And it doesn't allow for competition of smaller data center providers or
Well, but,
so
and that's a good question, because I thought under the deposit, they still have to have money up front in both cases, don't they?
they
Is
do
that-
have to have money up front, but if you're requiring them to prepay everything up front, we're potentially talking about hundreds of millions of dollars.
Oh, so you wouldn't be asking for all the upfront in the second. So then,
Not necessarily. I think you're,
so I'm a little confused on that aspect, but essentially you're looking at the company arranging their financing versus the utility arranging the financing. Is that a way of looking at that? Because they're not going to pay the whole money up front. They're going to finance it and pay it up front in the first model. Is that
yeah,
right?
I think if you're requiring the customer to fully fund those resources, that puts all the risk on them, and there's a lot of benefit to that from the perspective of other ratepayers versus a utility funding it through their traditional mechanisms.
Thanks very much.
Okay, we will now have questions on commissioner questions. Go right ahead. Identify
you.
yourself for purposes of the record.
Thank you. Christina Kress for SIGFR. Just a couple of very brief questions following up on your discussion with Commissioner Vandervaart regarding Virginia and Dominion's GS5 tariff. Do you recall that discussion?
I do.
Okay. Are you aware that the General Assembly of Virginia enacted legislation which took effect last month, specifically House Bill 1393, which exempts full-time equivalent workforce employees at manufacturing, industrial, or consumer goods, warehousing, and distribution activities who employ at least 200 people in the service territory of Dominion? It exempts them from having to migrate over to GS5.
I had forgotten that, so appreciate the reminder.
Thank you. No further questions.
Okay. Walmart.
Good morning, Carrie Grunman on behalf of Walmart. I want to pick up where Ms. Kress left off with the discussion of Dominion and GS5. And so to sort of lay the groundwork, you agree with me that GS5, when enacted by the Virginia State Corporation Commission, applied to all loads that were at least 25 megawatts or larger. Is that correct?
Yeah, I think I said that was my memory. I haven't looked at the tariff in a bit, so I wasn't 100% sure of that. But I'll take
Unfortunately
your
for
word
you,
for
I've
it.
spent a lot of time with that tariff. And I think one of the questions that you had said that you weren't sure of was whether or not there was a demand factor threshold. Would you agree with me, subject to check, that tariff GS5 did have a 75% demand factor threshold for inclusion in the tariff in addition to the 25 megawatt size?
Subject to check, yes. Like I said, I was not confident and hadn't looked at that tariff in a little bit.
And would you agree with me that, subject to check again, that that the Virginia GS5, the Dominion tariff, would deem a customer to have hit that 75% demand threshold if they hit a 75% demand in only 3 of 12 months?
Yeah, I'll agree, subject to check.
And so let's go back to that just as a hypothetical. If you have a customer who in only 25% of the year, so 3 of 12 months, hits a 75% demand threshold, that would include very traditional commercial and manufacturing that may have seasonal business that sometimes ebbs, but often is below 75%.
It could. I'm not familiar with the operating characteristics of the manufacturing in Virginia.
And then you've also acknowledged that there was, in response, the Virginia General Assembly then legislatively issued a carve out to exempt traditional manufacturing and industry of certain sizes from the applicability of GS5.
Yeah, that was the choice of the legislature.
Okay, and then just for clarity of the record, again, I think you mentioned the Rider T proceeding also decided by the Virginia State Corporation Commission.
Yes.
And are you meaning the recently decided case, docket number PUR 2026-00056, and the commission's order issued on July 31st, 2026?
I believe I was, but yeah, there have been a lot of decisions in Virginia recently, so that was the one I was thinking about. But again, I may have mischaracterized something, and if I did, I apologize.
And I think in response to some questions from Commissioner Vandevart, you were having some discussion about the benefits to ratepayers of the difference between sort of direct assignment versus rate basing. Do you recall those discussions?
Yes.
And the Rider T proceeding is solely a docket with respect to transmission costs for Dominion. Is that correct?
Yes.
And are you aware that in that case, the commission opened the door for direct assignment of direct connect transmission facilities as an option?
Yes. Yeah. The network upgrades, I don't believe, are under the jurisdiction of the Virginia Corporation Commission.
Are you aware that in that order, the commission ordered that a subsequent docket be open to address additional transmission issues?
Yes.
And then you had some discussions with Commissioner Tucker about the change in the Ohio queue for projects. Do you recall those discussions?
I do.
And it's my recollection that the most prominent information about the quote queue in Ohio was in the AEP Ohio service territory.
Yeah, I don't know the specifics. I apologize.
Okay. But you are aware that AEP Ohio was one of the first utilities in the country to implement a large load tariff, but that was a tariff specifically for data centers.
Yes.
And that Ohio is a distribution only state, meaning none of the EDUs in that state own generation.
Correct.
And then you also had some discussion with Commissioner McKissick about which I think you were discussing specifically in the concept of tariffs and state tariffs. And I think he asked you, which tariffs do you think best assign distribution and transmission costs? Do you recall that question? I know it's been a little while now.
Yeah, I recall that back and forth.
And one of the, it's not, I wouldn't say that it's a tariff, but are you familiar with the, it's not a tariff, but sort of like the methodology undertaken by Entergy Louisiana with respect to the large metadata center projects that are ongoing in southeastern Louisiana?
I've reviewed that, but I don't recall it off the top of my head what methodology they're using.
Well, are you just generally familiar that they are assigning a lot of the incremental costs over the term of the contract to the customer for whom the facilities are being built?
I know that's been discussed, but my memory is that the actual methodology they're discussed, again, it hasn't been worked out the details, but there are some potential problems with that.
And are you aware that in the more recently filed case, which deals with a subsidiary of Meta named Evist, that in that case, the contract between the customer specifically allows for the recovery from the customer if the estimated cost of the projects exceed what's in the contract? There is a process by which the utility can recover those increased costs from the customer?
I'm not aware of that.
Okay. Thank you. Those are all the questions that I have.
Go ahead.
Thank you, Presiding Commissioner McKissick. Ben Snowden on behalf of Microsoft. Mr. Brandt, I wanted to follow up on the series of questions that Commissioner Vandervaart asked you regarding the financing of incremental costs. And I think that one permutation or one possibility that you all discussed was requiring large load customers to pay up front for allocated incremental costs without a refund, and then also paying the full embedded system cost. Did I get that right?
I believe he asked me about that, yes.
Okay. So in that scenario, would allocated incremental costs include the cost of generation that it's required to serve a large load customer?
I mean, I think he was making a hypothetical, so I can't say for sure what his
Okay,
intention
okay.
was, but I believe that was the intention, yes.
Okay. And then with respect to embedded system costs, those would also include those would include the costs of generation that are required to serve the broader customer base, right?
In this hypothetical, yes.
So, and again, and apologies to Commissioner Vandervaart if I've misunderstood the hypothetical. But in this hypothetical, a large load customer would be paying for both the generation that's required to serve it, But it would also be paying for a share of the generation required to serve the broader customer basis. Is that right?
Yeah, it would be paying the incremental generation that would not be needed but for that large customer, as well as the embedded rate to fund all of their generation, yes.
Okay. Would that, in that scenario, would that mean that the large load customer was both paying for its incremental generation and then effectively subsidizing other customer classes?
I don't believe so. I think it would be paying for the incremental generation that it caused, as well as the benefits that it receives from all other generation that serves all customers.
Okay. And I guess that's what I'm struggling with. If it's when you say the incremental generation, it's causing, it's getting the benefit of that generation. How is it benefiting from the other generation on the system then?
Well, I think in this hypothetical, we're presuming that's not being directly served or by these co-located resources, that those are being built by the utility. So while those resources wouldn't be needed, but for that customer, it is still, benefiting from the existing generation system that's been around for decades or centuries.
Okay, thank you.
Are there any other questions on commissioner questions?
No further questions, but Presiding Commissioner McKissick, Sigford would respectfully request that the commission take judicial notice of the General Assembly of Virginia House Bill 1393, which reenacted Code of Virginia Section 56-585.1, excuse me.
Commission hereby takes judicial notice of the statute that you identified for purposes of the record in this proceeding.
Thank you.
Not seeing any other commissioner questions, you're hereby excused, sir.
Thank you.
And next in the queue, we have Sigford, I believe.
Commissioner McKissick,
Yes.
the AGO had 2 witnesses that were excused by commission order. Would you like for me to move?
This would certainly be an appropriate time.
Thank you. So we had, one of our witnesses, Mr. Burgess, pre-filed confidential corrected testimony consisting of 93 pages, 1 appendix, and 6 exhibits. Then we have Mr. Casera. He pre-filed testimony that did not include confidential information consisting of 127 pages, 1 appendix, and 15 exhibits. I would ask that Mr. Burgess and Mr. Casera's pre-filed testimony, as well as their witness summaries, be entered into the record.
Without objection, your motion is allowed.
Thank you.
Presiding Commissioner McKissick, in keeping with the spirit of trying to accommodate various scheduling conflicts that are arising in real time, Sigford is amenable to Google calling their witness, and then Sigford's witness will be called directly after Google, if that's okay with the.
That is not a problem. I see that there are several places down on the queue, but we certainly want to be respectful of the schedules of witnesses and potential conflicts. So we will move on now to Google. And I see Attorney Fennell's moving forward. And it looks like we have Ms. Berry here.
Thank you very much. Would you like to swear the witness first?
Yeah, we'll go ahead. Put your left hand on the Bible. Raise your right hand. Do you solemnly swear the testimony about providing this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Good morning. Could you please state your name and business address for the record?
My name is Carolyn A. Berry. My business address is 2001 K Street Northwest, North Building Suite 500, Washington, DC 20006.
Where are you employed, Dr. Berry?
Bates White Economic Consulting.
And what is your position?
I'm a partner.
Are you the same Dr. Carolyn Berry who caused to be filed testimony on July 9th, 2026 in this docket consisting of 25 pages and 2 exhibits?
Yes.
Was that testimony prepared by you or at your direction?
Yes.
Do you have any corrections to your pre-filed testimony?
No.
If you were asked today the same questions that are set forth in your pre-filed testimony, would your answers be the same as reflected in that testimony?
Yes,
Did you also cause to be filed in this proceeding a summary of your testimony on August 10th, 2026?
yes,
Is that summary true and accurate to the best of your information and belief?
yes,
I would ask that Dr. Berry's direct testimony be copied into the record as if given orally from the stand, and also ask that her summary be entered into the record.
Without objection, your motion is allowed.
Thank you. She is presented for commissioner questions. Thank you.
Good to see you.
likewise.
And we're going to try to go through a few questions from our commission staff. There may be some additionally from fellow commissioners. The first being, you recommend that a proposed large load tariff should ensure that these large load customers are covering their costs. With that in mind, how should the cost of these large load customers be allocated?
There is no one right way to allocate costs. The allocation method should ensure that they're covering their costs. In this case, for example, Duke says the allocation methodology is covering costs, and staff has a different position. These are two different methods, but both could cover costs.
Okay. And what costs specifically should large load customers be responsible for?
The costs that are incurred on their behalf.
And how much of their costs should the large load customers cover? I guess percentage wise, or however you would see that, or
There's
a
no
specific type. If you could get more explicit about what you have in mind or what you feel would be fitting or appropriate.
It would be the generation, transmission, or distribution costs. Any of those costs that are incurred to serve them would they would need to be paid for by the large load customer.
And do you have an opinion about what the term of the cost recovery period should be, or?
Depends upon the cost.
Okay. And you note in your testimony that Duke has conducted an analysis to determine the impact of large load customers on the system and on rates. What independent analysis have you done to validate or test Duke's analysis and assumptions?
I have not done an independent analysis.
All right. Now, on page 22 of your testimony, you argue the importance of ensuring large load customers bear all costs that they cause, as well as costs caused by other customers, are not shifted to large load customers. Can you provide the commission with an example of a tariff that achieves this objective most effectively?
I think the rate making paradigm, that is the objective for all utilities, to allocate costs to those who are driving the costs or that they're incurred for. So in our traditional method, before the large load issue came up, all of those allocation methodologies are designed to allocate costs to customers, to measure it with their causation.
Okay, now, Dr. Berry, the public staff criticized Duke's large load impact analysis, both in the stand, in the DEC rate case, and in their DEP testimony. Their analysis showed that assuming 75% minimum billing demand, there is no net benefit from large load customers. And in fact, there is a net cost to other ratepayers. Do you have any issues with the public staff's analysis? And if so, what?
I have not I've not dug into the details of staff's analysis.
Okay, very good. I think that covers the questions from our commission staff. Let me look to my fellow commissioners. Chair Brawley.
No questions.
Commissioner Tucker. Commissioner Vanderwaart. Commissioner Gaida. All right, we'll have questions on commissioner questions. I'm not seeing any. Therefore, for your excuse, thank you for being here.
Thank you.
Good morning. Again, Presiding Commissioner McKissick. Sigford calls Brian C. Collins to the witness stand.
Good morning, sir.
Good morning.
You could put your left hand on the Bible, raise your right hand. Do you solemnly swear the testimony you're about providing this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Mr. Collins, would you please state your name, business address, and current position for the record?
Yes, my name is Brian C. Collins. I am a managing principal with Brubaker and Associates Incorporated, and my business address is 16690 Swingley Ridge Road, Suite 140, Chesterfield, Missouri.
Did you prepare and cause to be pre-filed on July 9th, 2026, direct testimony in this docket consisting of 81 pages and one appendix consisting of 3 pages?
Yes,
And your testimony did not contain any confidential information, did it?
no, it did not.
Do you have any corrections to your testimony?
I do not.
If I were to ask you the same questions from your pre-filed direct testimony today while appearing on the witness stand under oath, would your answers be the same?
Yes,
Did you also prepare and cause to be pre-filed on August 5th, 2026, a summary of your pre-filed direct testimony in docket number E2 sub 1380A?
yes, I did.
Okay, at this time, Presiding Commissioner McKissick, Sigford would move that the pre-filed direct testimony of witness Brian C. Collins consisting of 81 pages and one appendix consisting of 3 pages, as well as his pre-filed direct summary, be entered into the record as if given orally from the stand.
Without objection, your motion is allowed.
Thank you. Mr. Collins, have you reviewed the cost of service stipulation, which was filed on October 24th, 2025 in this docket?
Yes,
And in your opinion, is the cost of service stipulation in the public interest, and should the commission adopt it in its entirety?
yes,
Have you also reviewed the third amended comprehensive revenue requirement agreement and stipulation of settlement, which was filed in this docket on August 12th, 2026?
yes, I have.
And in your opinion, is the comprehensive revenue requirement agreement and stipulation of settlement in the public interest, and should the commission adopt it in its entirety?
Yes,
Presiding Commissioner McKissick, all parties have waived cross-examination of this witness, so Mr. Collins is now available for questions from the commission.
Very good, sir. Thank you for being here. We have a few questions from our commission staff, and there may be additional ones from our fellow commissioners. Mr. Collins, we want to get some historical context for the record, given your extensive experience in this field. To your knowledge, when industrial loads were first connecting to for electrical service decades ago, what was the responsibility of these loads to pay for the facilities they served?
I believe it was, based on the cost that they incurred the utility to incur.
Okay. Now, on page 31, line 20 of your testimony, you note that care should be taken when developing a large load tariff to avoid unintended consequences for existing large customers. So, what are some examples of these unintended consequences that you have seen or expect to see? And the follow-up would be, what steps should be taken to mitigate these unintended consequences?
Well, I think one example, I was involved in the Virginia proceeding last year with Dominion, and the creation of the GS5 class. And I think one of the concerns, was if traditional manufacturers are, moved in to the new GS5 class, there may be some intra-class subsidies going on, between customers, old and new customers. So in particular, if there was maybe some minimum demand charges that were applied to, existing customers, there might be some inter-class subsidies. So I think that's probably the one example that I would give you to answer your question.
Okay, and in terms of mitigating the impacts from those unintended consequences, I mean, what would you say could or should be done? And
I think-
perhaps by way of using the Virginia example, if that's appropriate, if there are others that come to mind, and certainly feel free to identify those as well.
Well, I think in that example, the existing customer would be served by the GS4 rate. So, they made, business operation decisions based on that tariff being applicable to their service. One thing I think that was considered in that case was, possibly letting those customers voluntarily move to GS5 instead of being forced, on that tariff without, consideration of previous consequences as to why, they chose to locate there in the territory of Dominion.
Okay, and what does SIGFR want to see in a large load tariff, and what would make a large load tariff most effective and align with SIGFR's interests?
Well, we have, two proposals that are on the table right now from both the company and staff. And then we also have, the proposal from the commission in the order that was issued, yesterday. So now 3 alternatives. I think we're still looking at all those alternatives. We're very appreciative of the additional alternative that was issued, last night. We've not really had a chance to fully digest or discuss amongst ourselves. But I think we're willing to, look at all 3 of those examples and, engage with the stakeholder process, and then also, through the comments that we're going to provide to the commission as requested. There may be some things that we would recommend as improvements to those tariffs, but, we're fully dedicated to, reviewing those and providing, very constructive comments and suggestions on those alternatives available.
Thank you, sir. Those are the questions from our commission staff. Let me look to my colleague to see if there are other questions. Chair Brawley. Commissioner Tucker. Commissioner Vanderhart. Commissioner Gaida. Questions on commissioner questions?
Just two briefly.
Okay, go right ahead.
Thank you. Mr. Collins, you were asked a question about how historically did the company determine whether CIAC would be required from a new customer that was connecting to the system and taking service. Do you recall those questions?
Yes.
Okay. Is it also fair to say that historically there would be a calculation made by the company to calculate the estimated revenue credits associated with that customer and their anticipated load, and figuring out whether that revenue stream would exceed the estimated CapEx required to serve that customer's load?
Yes, that's my understanding of how that process, worked.
And if the revenue stream did not exceed the costs of connecting that customer and serving it, then the customer would be responsible for paying the difference. Is that an accurate overview?
Yes, I would agree.
Okay. And you were also asked a question about unintended consequences. Is it fair to say that there are also unintended consequences for new customers, new economic development customers coming to North Carolina, which is currently the number 2 place to do business in the country?
Yes, I would agree.
Okay. And SIGFR believes that all customers should pay their fair share of costs. Is that a fair characterization?
Yes, that's a fair characterization. Yes.
But it's also concerned about unintended consequences for both existing and new customers.
That's right.
Thank you. Nothing further.
Surprised you didn't get an objection on some of those questions, but nevertheless, you did not. Thank you for your testimony. You're hereby released.
Thank you so much.
I believe Environmental Defense Fund is next in the queue. And let the record reflect that Commissioner Gaida is here. I know we've recognized him. He came in probably a half hour ago.
Good morning. Ben Smith from the Environmental Defense Fund and witnesses Karan Pohl and Timothy Linnell have already approached the stand, so they are available to be sworn in.
All right. Get your left hand on the Bible, raise your right hand. Do you solemnly swear the testimony you're about to provide in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
I do. I do.
Thank you.
And Presiding Commissioner McKissick, before I begin my brief direct examination introducing the witnesses, I wanted to notify the commission that due to my own error in calendaring, I filed the witnesses' joint direct testimony summary just yesterday, rather than the required 2 business days before their before they were called to the stand. I wish I could blame it on the scheduling issues, but it was actually just my own calendaring error. So I've notified the other parties. I have 15 paper copies of the summaries if any folks need it. And I don't believe any party has been biased by my late filing of the summary. So I do intend to request at the conclusion of my short direct examination introducing the panel to accept the summary into the evidence despite it being filed out of time.
I appreciate the directness and candidness of your comments.
Thank you. Mr. Pohl, can you please state your name, position, and business address for the record?
Yes, my name is Karan Pohl. I'm an energy consultant with Daymark Energy Advisors representing EDF today. My business address is 370 Main Street, Suite 325, Worcester, Massachusetts, 01608.
And Mr. Linnell, please state your name, position, and business address for the record.
My name is Timothy Linnell. I'm a lead consultant at Daymark Energy Advisors on behalf of Environmental Defense Fund. My business address is 370 Main Street, Suite 325, Worcester, Massachusetts, 01608.
Thank you. And Mr. Pohl, I'm going to be asking you the questions on these next few questions on behalf of the EDF panel. Did you cause to be pre-filed in this docket direct testimony consisting of 81 pages and 2 exhibits?
Yes.
Did your pre-filed testimony include any confidential material?
No.
Do you have any corrections to make to your pre-filed direct testimony at this time?
No.
And if I were to ask you the same questions today that appear in your pre-filed direct testimony, would your answers be the same?
Yes.
And on August 12th, 2026, did you also cause to be pre-filed a summary of your direct pre-filed testimony?
Yes.
And is the summary set forth, excuse me, and is the testimony set forth in your summary true and accurate to the best of your knowledge?
Yes.
Presiding Commissioner McKissick, at this time, I would ask the direct testimony, including 81 pages, and the summary testimony of the summary of the testimony of EDF witnesses Linnell and Pohl be entered into the record as if provided orally from the stand.
Without objection, your motion is allowed.
I would also request the 2 exhibits included with the pre-filed direct testimony now be entered into the record.
Without objection, your motion is allowed.
At this time, Presiding Commissioner McKissick, the panel of witnesses Pohl and Linnell is available from questions from the commission and questions on commission questions.
Thank you. Good to see you again.
Good to see you.
We have a few questions from our commission staff, and there may be some additional questions from commissioners. First being, you recommend creating a rate and tariff specifically for data centers. Please elaborate on the operational and system impacts that are unique to data centers, but not other large industrial loads.
I'll start with one that I think is crucial and let my co-panelist add more. I think one that comes to mind is the quick ramping capability of these data centers. That is really unlike any other load, especially at the scale. You can see hundreds of megawatts come offline and come back online within seconds, really. So that specific operational characteristic alone is something worth developing a specified rate class for.
Yeah, and additional would be the investment cycle. So we mentioned every 3 to 5 years, there could be re-racking of facilities at each time that could introduce different load densities with each generation of that re-racking facility. Their large load factor in itself is unique. The flexibility is also, it not only impacts reliability investments, it also allows for participation in curtailment programs and things of that nature. So you can see it not only as a reliability impact, but also as a benefit that could be used and incorporated within planning. So those are additional measures as well. And then we also mentioned their data centers have high reliability standards, often referred to as 5 nines, that have often, dual feeds, different things like that, that increases investments, system investments. Also, it typically they have behind the meter resources for when there's voltage issues or whatever that they can just quickly shift load onto their backup facilities. Again, that has reliability issues, but also is those behind the meter resources can be coordinated within system planning to defer investments. So for those reasons, I think we would consider data centers to be unique.
Okay, now you warn on pages 22 to 23 of your testimony that if large data center loads materialize and are served on existing rate structures, non-large load customers could see increased costs. Could you elaborate on this concern and your recommendation for addressing this concern?
Yes. So we're in a period of rapid increases in costs. Marginal cost of generation is increasing at the same time of this incremental costs is being driven by data center loads. So we know that high load factors traditionally, and I think panelists have talked about, have traditionally helped bring overall embedded system costs downward. We're in a period of rapid cost increases. When you're not taking into account the class, how the class is utilizing the system, those costs moving upward and their load factor moving those costs downwards, those are being spread across all customer classes. So we see how that could impact existing customers by segregating it into its own customer class. You can make decisions about which costs are customer specific, directly assigned to the customer, which costs are class specific, assigned to that class of customers, and which ones are system benefits assigned more broadly to the system without that distinct characterization within this a particular tariff for the data centers or large loads. You're not able to make that class or particularly the class assignment because they're being served on different classes depending on their choice.
And based on your review of large load and data center tariffs elsewhere, what differences have you found between tariffs for vertically integrated utilities and other utility structures?
That's a good question. I mean, vertically integrated utilities are going to be solving all levels, generation, transmission, distribution. So to the extent that, AEP Ohio was mentioned, that's a wires tariff is particularly pointed at, the system and the wires because generation is not part of that. So vertically integrated utilities have it's important, our recommendation when we talk about optionality, curtailment, using that as part of system planning, that is something that's, applicable in this scenario, but not more broadly across, in the case of AEP Ohio, that wouldn't be necessarily the same characterization when you're talking about, avoidance of generation capacity costs and things of that nature. So you definitely have to take into account what utility you're describing, and it has to be applicable in this situation here today. And so our recommendation is, looks at what is DEP and DEC's particular opportunities as well as risks at each level.
And you state on page 33 of your testimony that large load center customers may place downward pressure on rates. Therefore, what analysis did you conduct to support this statement for Duke Energy ratepayers, and what was your exact finding?
Yeah, we did not conduct any specific analysis to come to that conclusion, more on the broader concept that given extra headroom, a higher load factor customer would be paying a larger amount potentially placing downward pressure on rates. So we're highlighting that potential, of course, with the caveat that an increasing cost environment that may not be the case if adequate protections are not put in place ahead of time.
And based upon your review of Duke's proposal, what critique would you provide in terms of their large load impact analysis?
Their impact analysis or the
Yes.
large load tariff itself?
Impact analysis. The impact analysis conducted by Duke.
I don't think we have any comments directly on their impact analysis.
That's fair. For tariffs that use an incremental cost test, what happens when the actual cost to connect the customers to the system end up being significantly greater than the estimated cost that were used to determine the incremental cost? Who bears the cost recovery for the difference? And would the incremental cost be updated to true up to actual costs?
Yes, so that's a great question. And for incremental cost tests, there should be in ensuring that the actual costs incurred on the system is being paid by that customer class. So truing up of the customer costs would be beneficial for that design.
Now, on pages 43 to 44 of your testimony, you mentioned ring fencing of specific resource or portfolio costs, and the utility bills or procures the generation and the customer pays the full or incremental costs through a rider or ESA. Can you provide more details on this type of cost recovery and allocation structure?
Yes, happy to. So in the reference case, we mentioned two potential tariff structures that have been implemented across the country. The clean energy, or excuse me, the clean transition tariff, the CTT, and then the clean energy accelerator charge as well, CEAC, not to be confused with kayak. So the CEAC and the clean transition tariff are really contract for differences. So there is a embedded tariff for the customer class that they would pay. This is the customer selecting a set of resources, a generation portfolio, so to speak. They want to see battery, long duration storage, wind, solar. They know the incremental cost is more than the least cost solution in the IRP process. So they say, we're willing to pay for those costs, assign those costs to us. So in the clean accelerator charge, clean energy accelerator charge, they're paying an incremental charge over the base tariff that's being directly assigned to the customer, not the class, to the customer. The overall system, it's a ring fencing of costs. So the overall system is still operating as a system. It's not co-generation, but it's a system asset. But because the customer wanted those clean energy resources and is willing to pay for it, it's an opportunity for economic development and for that ability for the customer to meet their clean energy goals. And so that's the framework and the context for those comments there.
And of course, the follow-up is if the full incremental costs are paid, how is that treated on the utilities books? And likewise, how does the customer get repaid for their upfront payment?
And that's a good question. And neither of us are accountants. So I don't want to really speak to the books, so to speak. I will say in the clean accelerator charge and CEAC, there's an annual revenue requirement determination for that. It's paid throughout time, so it's not necessarily all upfront. Kayak contributions in aids of construction or customer advances. It's really paid through over time, determining how much as you're going through the milestones, as you're ramping through, as you're starting to build facilities, those costs are being attributed to the customer. So there's different mechanisms, I would say, and each one will would be treated differently. Kayak, I think we've mentioned, or others mentioned, not part of rate base, right? Treated separately than customer advances versus, a separately revenue requirement to determine. Each of those would have different impacts on the company's books. But there are those different mechanisms.
Okay, and on page 45 of your testimony, you state, by assigning incremental costs to the customer, generation assets can be fast-tracked and more expensive resources that would otherwise not be selected in an RFP process can be accelerated to the market, financed by large load customers. The CEAC structure builds upon that framework, incorporating with it system-wide benefits while allowing the utility to continue centrally managing resource planning. Can you elaborate more on this concept?
Yes. Yeah, we can elaborate on that concept. But one of the interesting things about that arrangement was the batteries. It's not just, a 1 gigawatt battery in one location. So it's really distributed batteries across the system to solve other things like, voltage problems or whatever the case may be on the system. So in, the SEAC paying for the incremental costs and to meet their generation capacity, they are having these system benefits. That's the system benefit side of the comment there, where these batteries are being deployed in a way that has other system benefits for reliabilities for the existing customers. So the costs are ring fenced to the customer, they pay it, but there are social benefits to all customers. And so that is an opportunity to have these growth benefit existing customers, while the costs are being financed by the hyperscalers involved.
Thank you. That kind of concludes the questions from our commission staff, but let me look to my colleagues to see if there are additional questions, beginning with Chair Brawley.
No question.
Commissioner Tucker. Commissioner Vanderwart. Commissioner Gaida. Go right ahead, sir.
In your testimony, I believe you all recommend the development, and I'm just kind of, I think it's pretty early on in your testimony, but you recommend I'm going to use your language, the development of a holistic rate and tariff design framework for large load customers, particularly data centers over 50 megawatts. So my question for you all is, can you say more about the 50 megawatt criteria? And I guess what I'd like to know is specifically what makes that number better than another, and whether you recommend that demand criteria for any customer or specific to data centers or similar loads.
Yeah, I could start. So we, and I think there's starting to be a unified framework. The Large Load Task Force from NERC has identified breaking points. We see those breaking points typically occur at 20, 50, 75. So those are the common breaking points where you start to see system investments needing to be made based on the size of the customer. 50 in this case was selected based on the reason that, in our data requests for data, and we saw that it captures the majority of economic development load. So it's capturing a lot of the growth. If there is, if you were to lower that, you would capture a little bit more, but it creates that bright line for consideration. Obviously, there needs to be considerations for totalization rules and things of that, so there's no gaming of the system. But the selection for 50 was based on both that understanding around this common breaking point where system investments are needed, as well as this particular rate case proceeding in capturing the majority of the economic development load. We have seen NERC come up with a computational definition for load. I believe that's at 20 megawatts. So it's sort of evolving, but those are the common breaking points in our rationale for this selection.
Okay, and just to make sure that you answer my last question there, I recognize your point about the break point. Is this, do you recommend that demand criteria specific to a type of customer as described as a data center or a similar load, or any customer that might exceed that demand criteria?
Yeah, so what we suggest is for the data center in this and explicitly we are saying that data centers have this unique impact to the system, and so in our testimony we're prescribing this for data centers in particular.
To be clear, we're not opining one way or the other on non-data center large loads.
Thank you, Commissioner. Opportunity for questions on Commissioner questions.
I just have one.
Go right ahead.
Mr. Linnell, Mr. Pohl, you recall a question from Presiding Commissioner McKissick and from the commission staff about ring fencing. You referenced a number of benefits of ring fencing, but one thing I wanted to point a pin on, can something like the clean energy choice involved in some of the programs that you described in your testimony benefit a utility and its ratepayers, particularly a utility that has decarbonization requirements?
Absolutely.
And could you explain a little bit how it might benefit that?
Yeah, so like I mentioned, it allows for the ability to for 100% clean portfolio to be matched against these new hyperscalers and developers, which may not be the same portfolio choice if going through a least cost IRP type process. And so to the extent that it will accelerate what would be the default choice offering, it's accelerating the selection and of clean energy resources.
No further questions.
Very good. Well, thank you for being here this morning. You're hereby released. Too bad you can't take some of the heat from North Carolina back to Worcester, release in the winter months. I remember one year I was there, they had 63 days where the temperature dropped below zero at some point during the day. But thank you for returning once again.
Thank you. Thank you.
And we're going to keep moving forward. Try to get another panel before we break for lunch. And it looks like we have Microsoft next in the queue. Sir, if you could go ahead and put your left hand on the Bible and raise your right hand. You solemnly swear the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
So good afternoon, Presiding Commissioner McKissick, Chair Brawley, and Commissioners. This is Microsoft's witness, Isaac Gable-Frank. Mr. Gable-Frank, can you begin by stating your name and business address, please?
Sure. My name's Isaac Gable-Frank. My business address is 417 Dennison Street in Highland Park, New Jersey.
And by whom are you employed and in what capacity?
I'm employed by Gable Associates and I'm the co-CEO.
Did you cause to be pre-filed in this docket on July 9, 2026, direct testimony consisting of 21 pages and one exhibit identified as Gable-Frank Exhibit 1 that consists of 2 pages?
I did.
Are there any corrections or changes that need to be made to your direct testimony in one exhibit at this time?
No.
If I were to ask you the same questions today that appear in your pre-filed direct testimony, would your answers be the same?
They would.
And your direct testimony and one exhibit do not include any confidential information. Is that correct?
Correct.
Did you also cause to be pre-filed on August 7, 2026, a summary of your direct testimony.
Yes.
And Presiding Commissioner McKissick, at this time, I would ask that Mr. Gable Frank's direct testimony be entered in the record as if given orally from the stand, as well as a summary of his direct testimony.
Without objections, your motion is allowed.
And also, Presiding Commissioner McKissick, I would ask that Mr. Gable Frank's one exhibit that is attached to his direct testimony be entered into the record at this time.
Without objection, your motion is allowed.
Presiding Commissioner McKissick, is no cross-examination for this witness, and so he is available for questions from the commission.
It's good to see you, sir. Thank you for being here.
Likewise. Thanks for having me.
Absolutely. We do have a few questions from our commission staff and maybe additional questions from commissioners. On pages 8 through 9 of your testimony, you know that the impact of large or growing loads on system costs requires systems-specific analysis. What was your analysis of the impact of large loads for DEP on its system?
I did not conduct any specific analysis for the DEP system, so I was talking in the theoretical that those loads can have impacts one way or the other.
Thank you. I want to ask you about your criticisms of the public staff proposal. Now, your first criticism of the public staff's large load tariff proposal is regarding the effort to align cost recovery with cost causation. What can the commission do to best align cost recovery with cost causation for incremental cost of these large loads?
So at first, I think I would just say that criticism is a harsh word. I think public staff obviously put a lot of thought into their testimony and the proposal they put together. And
Hey, Mr. Gable Frank, can you move your microphone a little closer?
yes, I can.
Thank you.
Sorry. So I think in my testimony, what I tried to point out are just some areas of that need additional discussion and confirmation. So none of the ideas I think that they put in there are necessarily wrong. I was more focused on what they mean, how they'll operate, how they will interact with each other. And when we're moving forward and putting together a tariff that's going to, cover all the different issues that need to be kind of handled with this tariff, that it's done in the right way, that there aren't unintended consequences, because all of these issues, as we've seen with all the discussions upcoming so far, are very complicated. So.
Sure. Now, some interveners have recommended establishing a customer class specifically for large loads. Would doing so help establish a means of allocating costs for these large load customers?
I think that's one method that could be done to do that. So I come in here kind of indifferent or agnostic to like the many different positions that could go forward. And what I try to do with my advice to my client and the commission here is kind of talk through the different options. And as we've discussed, there's multiple options to getting there. I think that is one, but kind of thinking through and figuring out what is going to be best in the state of North Carolina and achieve the goals of the people of North Carolina is something that can be achieved in a process where you kind of work through those things.
Okay, now there was a second concern that you raised relating to the public staff's proposal with regards to system-wide planning. Can you elaborate on how their proposal emphasizes system planning for individual projects versus the system as a whole?
Sure. So theoretically, what happens kind of in the status quo right now is Duke does their planning and they're looking at all their loads together and trying to figure out their least cost options to meet those loads. What I pointed out in my testimony is it's unclear how that will be handled when you start to bifurcate certain loads out, how you assign and build out for those certain loads, and how that will impact the system-wide load planning, whether there will be overbuild, how all those things will interact. So one of the things I think that as we work through figuring out the right process and approach here, you want to make sure you have in mind that you don't want to lose system efficiency. You don't want to overbuild the system, but you do want to put the right protections in place and make sure that all customers are paying their fair share.
And of course, there was another critique or observation related to public staff's proposal. And that proposal notes no evaluation was conducted on the interaction of the various provisions. I'm going to go through those provisions. What would this evaluation look like and how would such evaluation be conducted?
Sure. So I think in my testimony, I provide an example of one of those interactions, and that's how prepaying costs upfront through a kayak or other mechanism would impact what these customers are paying for embedded rates and on their bills. And there's been some discussion on that today, whether customers should be paying for resources that are serving them and whether customers should be paying for resources that are not serving them. And I think those interactions are something that's important to figure out. You don't want to double pay. You don't want to subsidize in either direction. You want to make sure all customers are paying their fair share.
And what are the baselines or standards for how this evaluation would be measured and assessed?
So that's a good question. I don't have specific ones off the top of my head while I'm sitting here. I think that's something you'd want to discuss. Certainly, there's lots of different, approaches to how you handle cost allocation, and jurisdictions across the country handle those things differently. So I don't think there's one or the other. I think you're going to have to sit down and think about what do we want these customers to pay for, what is fair, and then work through and do the analysis to make sure that everybody is paying their fair share.
Can you provide or point to another large load tariff that considered the interaction of various provisions in the way you describe and recommend?
Well, to be clear, I didn't recommend a specific approach, so I recommended that we have an accelerated process to work through that. But I think there's been a couple jurisdictions that have been talked about today, and you can see the different approaches there. I think Wisconsin is one where they're directly assigning the costs and they're avoiding paying the embedded costs because those costs are not serving them. And then you can look at other jurisdictions where maybe they're taking a different approach and they're using minimum billing charges and they're still paying for those full system costs.
Now, you raised a concern about the public staff's proposal as it concerns administration and implementation and how some aspects are unclear. Therefore, there seems to be some overlap between your first criticism or concern and your fifth. Can you help us understand the difference between the two?
I think they're all interrelated. So certainly that's a good observation. If I recall, my first observation was, give me a moment while I find it.
And I'm calling them observations rather than criticism because I could understand that you took issue with the use of that terminology.
Yeah, no, I appreciate that. So one of the, I think they're very close together. So they abut one another. When thinking about the methodology, is more of a theoretical approach. So what are you doing and how should these costs in the abstract be assigned? What is the right way to assign a cost to someone? That's working through the methodology. The administration is how are you actually doing it? What are the process and the steps that Duke or others are going to take to actually, do the math and figure it out in a fair and transparent way?
Thank you. I think that concludes the questions from our commission staff, but let me look to my fellow commissioners. Chair Brawley, any questions?
No questions.
Commissioner Tucker. Commissioner Commissioner Vanderhart.
Just very briefly, and I'm just throwing this out there for everyone. In the scenario that you may have been in here where I asked a question about either paying something completely up front and it not becoming part of the rate base, and the other where you get a deposit and all that, there was a question about the demand charges and not wanting to double pay, which absolutely was not the intention of those two scenarios. Intrinsic in the comparison is that the appropriate demand charge is charged in both cases so that it should be economically neutral over the course of the contract. Does that make sense?
Yeah, I think so.
Okay, thank you very much.
Right, questions on commissioner questions?
I have no questions on commission questions.
All right, sir. You're hereby released. Thank you for being here. We appreciate your testimony.
Thank you for the opportunity. Have a great day.
Absolutely. And let's see, it's 12:18. I think what we're going to do is go ahead and break for lunch. If one commissioner wants to bring you on up here. But I think this is a pretty good hour, and I think the public staff has some things going on during lunch hour today. So we're gonna go ahead and adjourn right now, and we will reconvene at roughly 1:35. Okay? Thank you. Room. Good afternoon, Mr. Wilson. Your witness is here. Why don't we go ahead and swear him in now? You want to put your right hand on the Bible, raise your left hand. Do you solemnly swear that the testimony you're about providing this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Go right ahead, sir.
Thank you, Presiding Commissioner. We have NCJC et al. Have John Wilson on the stand. Mr. Wilson, if you could please state your name, title, and business address for the record.
My name is John D. Wilson. I'm Vice President at Grid Strategies LLC. Our office is at 9207 Kirkdale Road in Bethesda, Maryland, and I'm officed in Lexington, Kentucky.
Please briefly describe your role and responsibilities at Grid Strategies.
I primarily do expert witness testimony for various clients across the U.S. and Canada. I also lead research projects for various clients.
Mr. Wilson, on July 9th, 2026, did you cause to be pre-filed in this docket direct testimony and 2 exhibits which contain confidential information and collectively consist of 145 pages?
Yes.
On August 7th, 2026, did you cause to be pre-filed in the E-2 sub 1380A docket a summary of your testimony consisting of 5 pages?
Yes.
Do you have any corrections you need to make to your testimony?
No.
Presiding Commissioner McKissick, I would move to have Mr. Wilson's pre-filed direct testimony and testimony exhibits, which collectively consist of 145 pages, and pre-filed testimony summary consisting of 5 pages, entered into the record as though given orally from the stand, and have the exhibits attached to his pre-filed direct testimony identified as pre-marked.
Without objection, your motion is allowed.
Thank you. I understand all parties have waived cross-examination. The witness is available for questions from the commission.
Thank you, sir. We have a few questions from commission staff, and there may be some additional questions from commissioners that are here this afternoon. You discussed financial security recommendations on pages 86 through 87 of your testimony. I'll give you a few minutes to get there.
I'm there. Thank you.
All right. Now, on page 87, lines 5 through 7 of your testimony, you include in your recommendation to expand the scope of the advance to include costs related to new resources required to meet planning reserve margins or resolve transmission contingency violations. Can you clarify what you mean by these new resources? And also clarify whether these resources also include generation resources.
Yes, thank you. Just a second. Let me review the context here. Yes, I am speaking here about both generation and transmission resources. And what I'm referring to here, I think, is very similar to what the public staff has put forward in describing both, I believe the term they're using is dedicated and then required. And so I'm referring to a similar scope of resources. I'm happy to elaborate, but that's
Oh, feel free to elaborate. Go right ahead.
So when I speak, for example, on the new resources required to meet planning reserve margins, what I'm referring to there would be generation resources. And the point I'm making there is not just enough resources to serve the customer's load, but also to meet the planning reserve margin as it's currently implemented by the utility. So, for example, if a 500 megawatt data center was being built, it would need to be 500 megawatts plus the planning reserve margin would need to be the amount of generation resources that would be added. And then we get into the question of sort of how you do the cost allocation. And I know we've had a lot of discussion on that this morning. Perhaps you'll get into some questions on that. But that's the basic concept is you don't want it just to be the 500, it's 500 plus.
Got it.
And then with transmission contingency violations, what I'm referring to there is actually, I apologize, I've forgotten the context for this. So in this specific case, What I'm also focusing on and really primarily focusing on is the short-term cost requirements. So in this case, when I'm talking about the advance, I'm also talking about the fact that during the period between when Duke begins to energize or allow the customer to begin to energize and use their take service from the utility and the point at which they've got all the resources in place and all the services in place. So the customer is now drawing load at the contracted demand. During that time period, the utilities reserve margin requirements go up. And so that's also what I'm referring to here. And then in the second part of it, this is where I'm really getting into that time frame. You've got the limited duration curtailment provisions in Duke's current model ESA. And I think the public staff has also proposed that. And I'm generally in concurrence that that's a reasonable way to proceed. But even during that period of time, you've got transmission contingency violations. When you resolve those during that time period, you're going to have costs associated with that. So an example of that could be, for example, while a transmission facility is being built, that means that facility, or let's say it's being upgraded. So let's say you've got a transmission line that you're going to double the capacity on it. And so you're going to reconductor it or use some kind of advanced transmission technologies or whatever. You've got to take that line out of service for a period of time while you're reconductoring. That creates stress on the system in other places where you may have to delay construction of something, or you may have to use a generator that you wouldn't normally dispatch at that hour because the original transmission line is out of service. So there's various costs, scheduling, et cetera, that are imposed on the system during that time period. And so what I'm indicating here is that not only should the customer be responsible for the costs, the long-term costs of the infrastructure and the services that are required to deliver power to a large customer load, but in the short run, or not in the short run, in the medium run, let's say, where the construction is taking place and the customer is being ramped up to its ultimate level of demand, you need to look at those costs as well. And those costs also need to be allocated to the customer and not simply imposed as maintenance or operating costs onto the general customer base. So it gets fairly complicated. And the easy way to do that is just to roll it into rates and everybody pays for it. And what I'm pointing out here is that there are potentially significant costs that might be overlooked even under a proposal where the ultimate costs are fairly allocated.
Thank you. Can you please elaborate on your refundable advance proposal? Would this be treated like CICA and then refunded to customers over time with interest?
Yes, I'm not proposing any changes to North Carolina's general approach to CIAC other than some language I proposed later in my testimony, I believe, except for this one point here about capping the refund amount. And this is something that I've modeled on some decisions that were reached in California. I'm not aware of any other jurisdiction that has done the same thing. But generally, when a CIAC or kayak approach is used, the kayak is then refunded to the customer so that the utility can place that cost into rate base. And it's refunded as a credit against their bill. And so the amount of the credit is usually capped at their bill amount. So if their bill amount is, say, $10 million for the month, I guess that might be a high figure for some. But if you're at $10 million for the month, then that's how much you can reduce the kayak credit by. And that's how much rolls into rate base. And what I'm suggesting that is instead of 10 million, it'd be capped in that case at 7.5 million, so that there is some amount due to the customer in every month to contribute towards the embedded costs in the system. And then the remaining part is used to pay down the kayak and move that into rate base for recovery as determined by the cost allocation process.
And what are some financial security examples from other tariffs that you think this commission should consider?
Well, as I acknowledged at the beginning of the this section of my testimony, this is the probably the area that I'm had spent the least time delving into as compared to some of the other provisions of my testimony. So I'm not aware of any sort of model that is perfect, but I'm also I've highlighted some sort of potential hitches that I've seen, such as the example I gave from Meta, Louisiana, with the ownership change there. And so that's what I would kind of point the commission's attention to. I think that, you know, as a general matter, I think that overall Duke and the public staff have a good understanding of how to do this, but I think that the scale and the complexity of this requires a lot more attention to some of the finer details that are normally not so important. So if you've got a, say a, to pick a customer, a Walmart, you know, that is building a store, you know, paying really close attention to exactly how the kayak is going to be repaid, how the security, financial security instruments are set up is probably less important, because if you get it wrong in their case, at least you've gotten it wrong right in most of the other customer cases. So I think that a lot of times we don't pay really close scrutiny to those terms. And I would encourage the commission to rely on expertise in this hearing, or to, if it's not available in this hearing, to certainly encourage it to be brought forward to really scrutinize these the details of the financial security mechanisms over time, so that we make sure that we get that right. I think my fundamental concern there is that there's a lot of systemic risk in place with data centers in particular, that you could see a large sort of correlation in customers reducing or leaving service entirely. We don't know that that's going to happen, but it's unique, I think, in, you know, really anywhere in the country to see such a large growth of a single sector in such a short period of time. And I think that that creates sort of the back end risk of a large decline in demand from that same single sector. And so you really want to make sure that the financial security mechanisms you've got in place are really robust, and that may require further investigation.
Okay. Now, you recommend creating a large load customer class as a straightforward way to set rates for large load customers. Given the limited amount of data centers currently on the system, how would this large load customer class be created to accurately reflect cost allocation and create rates?
Yeah, thank you for that question. I appreciate the commission's interest in creating a large load class, and I believe that that is the correct way to go. And I think there's a number of reasons to create a large load class. I discussed those in my testimony on pages 90 and following. But very briefly, first, it's important to create the large load class because that makes it very clear that, you know, where the revenues are coming from, so that the commission, if it is saying to the public that we have assured you that these revenues are covering the costs for these facilities, it makes the accounting very clear. And that is a, you know, I don't want to say it's simple, because nothing in cost of service and rate design is simple, but it is a relatively straightforward task to mathematically create a new load class and begin assigning customers to it. So that's kind of the first thing that I would say. The second one is that, you know, as the commission has proposed in the DEC order yesterday, the terms and conditions can be spelled out in the tariff immediately. And I think that's really important to have that clarity there, that going forward, there's going to be a class and here's how it's going to be treated. And I think one of the concerns I have is that as you establish a new class, there's a lot of questions about legacy customers. Should they be included? And if not, and under what terms, and so forth. And I think the sooner you move to creating that class, the fewer parties will have objections and considerations that the commission has to evaluate, and it just makes it a lot harder. So I think putting this decision off to the next rate case just makes the decision that much more difficult. So I would encourage the commission to move forward with a class, if only for that reason, just simply to do so. And the third thing that helps out here is then once you've established that large load class and defined who's in it, then in the next case, there's no ambiguity as to what data Duke Energy should use in filing a cost of service study and proposing rates for that class. If you say, let's have Duke propose a rate class in the next case, then their proposal is subject to intervener challenge. You know, people can say, well, I don't think it should be 50 megawatts. I think it should be 20 megawatts or 100 megawatts. And so that changes the data that are being used. That changes rates for all of the customer classes. If you've defined the class now, and then in the next rate case, you're creating rates that are designed around the customers that are actually in that class at that time, it's just that much simpler. So those are kind of, I hope I've addressed your question. I may have lost track of a piece of it.
No, that's fine. I think I appreciate your full and complete answers. Can you elaborate on the interaction of your financial security recommendations and the creation of a specific large load customer class?
Trying to think of, is there any way we can clarify that question? I know that's coming from staff, but it's kind of a broad.
It is fairly
associated.
broad, so I mean, interpret it, put whatever guardrails or parameters in there that you feel you need to condition your response upon. But I'll repeat it. Can you elaborate on the interaction of your financial security recommendations and the creation of a specific large load customer class?
Well, I think what I'm saying is that the financial security recommendations and really many of the other terms that I recommend would be applied to that class and not to, say, a new customer that signs an ESA with Duke that's outside the class, and that Duke would continue to have its current practices for dealing with ESAs and other large customers that it has under its current tariffs without alteration. You know, my focus was on changes that would be relevant to this new class. Hopefully that answers the question.
I understand your response. I think it certainly responds to the question has raised. Mr. Wilson, you mentioned that data centers have hardware refresh cycles of about 5 years, and how the industry is building new facilities with modern IT loads in mind, rather than upgrading ones that already exist. Can you elaborate on how these behaviors of data centers may be incompatible with utility investment and what Duke can do to mitigate potential consequences of these incompatibilities?
Yeah, this really gets to the crux of the importance of the contract term length or other exit fee provisions that might be in place. The concern here is that data centers are very different than, for example, a military base or a auto manufacturer, in that a large portion of their facility is built with a lifetime of really just 5 years. And I base this on published writings and conversations that I've had with people in the data center development industry. I don't have direct knowledge of this information. But I have acquired it from a variety of sources, so I believe it to be true. So whatever the exact refresh cycle is, it is extensive. It's swapping out any equipment that is no longer sort of state of the art. And that's a lot of equipment at a data center. In comparison, if you're a military base or an auto manufacturer, a lot of the equipment, even when you do undergo a facility overhaul, you're looking at a lot of the equipment staying in place. You're looking at a lot of the facility investment remaining in place. You've got a lot of trained people and supply chains that are in place to support that facility. In every case, there's a very high disincentive to relocate. Now, obviously, we know that manufacturing plants and so forth do relocate from time to time, but they don't relocate, have a business evaluation of whether they should stay in business or whether they should reinvest or whether they should relocate every 5 years or so. That's an extraordinarily fast pace for those kind of decisions. And, you know, we'd certainly like to believe that Duke will provide such a high level of service and at such a great price and will be politically supported in doing so by the citizens and customers that they'll stay in place, but the risk is that they won't. And so you've got to take that risk into consideration when you're designing exit fees and minimum billing requirements and so forth, to make sure that if a facility does decide that it no longer makes sense to operate that facility and they are not able to substitute another customer in its place, that a substantial financial recovery occurs to cover the cost of the transmission and generation infrastructure that was required to support their business plan that they provided to Duke when they took service.
Okay, and on page 86 of your testimony, and I'll give you a moment to get there if you want to pull up page 86.
Yes, sir.
You gave the example of Meta reducing its ownership stake of a data center and the resultant impact on its credit guarantee. What is your recommendation for addressing and mitigating a similar circumstance in North Carolina?
Well, I would defer to the expertise of a contract attorney on that matter. I would just say that this is why I brought it to the commission's attention without providing a recommendation. I'm not an expert in how to solve that problem, but I did want to bring it to the commission's attention.
Thank you, sir. I think that concludes the questions from our commission staff. Let me look to my colleagues for additional questions. Chair Brawley. Commissioner Tucker. Go right ahead, sir.
Mr. Wilson, good afternoon to you, sir. Thank you for being here. You referred to California in your testimony today. Do they have any kind of but-for or upfront pricing in that scenario you discussed?
Yes, sir, Commissioner Tucker. Thanks for the question. I will have to refresh my memory a little bit about exactly how California does it, but California does have a very strong approach to requiring both generation and load customers to paying upfront, and then and that's the whole setup for the decisions that I referenced. And so the precedent in California was that for most generation and load customers with kayak provisions, that they would get 100%, up to 100% of their bill would be credited based on their kayak payment. So if their kayak payment was $100 million and their bill was 10 million, then 10 months of bills would be zero. And then after 10 months, then they would start paying their bill. So that's how it's an overly simplistic approach, but that's kind of how it worked. And what the commission said was, in this case, because the kayak payments are so large, and because that means that these companies are effectively not contributing to they're contributing to the cost for the dedicated and required facilities, to use the public staff's language. It's different language in California, but to use the same language.
Everything's different in California.
Yeah, and I will confess, I hesitated quite a bit before typing in the words to bring a California example before you, but it is the only example that I'm aware of where this issue has been squarely dealt with. So they're looking at the same kind of dedicated and required facilities there. And what they said was, we want these customers also contributing towards the embedded system costs. So the existing facilities that they're also relying on. And so the compromise that they reached was 75% credit towards the kayak, 25% goes into system costs. So that means that the kayak refund takes longer to complete. So it takes longer for it to be fully transitioned into the utilities rate base. Depreciation does occur normally, as it would with any asset, also during that time.
Okay.
I hope that answers your question.
It does. You also mentioned you talked about your clients in the US and in Canada. Um, you also mentioned about the fact that we need to readily establish a large load class. Do you think a large load class, given a short amount of time that we have this time to make decisions, do you think that a large load class should be resolved in the rate case, or should it have a separate docket?
I would personally like to see it resolved in the rate case. Because I think that just gives everyone clarity. I will defer to the lawyers who understand the scheduling constraints and so forth as to exactly how that works out. I really can't answer that. I do think that the suggestion that I made, which is that the commission, when it establishes the class, simply adopts existing rates, means that if there's further deliberation on some of the terms that take longer than you would like to for the rest of the order to be completed, you won't be interfering with other rates. So normally, I think the concern with sort of settling rates for one class at one time and another class later is that if you reduce the rates for class X at a later date, then you've got to increase the rates for classes A through, W. And that creates a problem. So I think what I'm recommending here is that the actual rate schedule be approved along with all of the rest of the rate case. So the idea would be that this rate class would use an existing rate schedule that's already been approved. Now, whether that happens in this docket or another one is obviously your prerogative. But I would just encourage sooner rather than later.
Okay. You talked about, by establishing that large load, you talked about the accounting should be clear, pretty much straightforward task, oversimplification, and you talked about a carve out. I use that term, a carve out for industrial customers versus data centers. So you have given warnings, if I may use that word, about relocation, about change out of equipment every 4 to 5 years, the change in ownership, wanting stringent financial penalties up front, those kind of things. What would be your reasoning for not suggesting to this commission that the best way to cover all those bases is to get the cash for the kayak up front and move forward from there?
Commissioner Tucker, I would have no objection to that kind of an approach. By what I tried to do with my recommendations was conform them as closely as possible to the existing practices across all rate classes, and the kayak approach is the current practice that is used in North Carolina. But I do think if the commission directed that customers simply pay for these facilities up front and that just be the end of that, that is a perfectly reasonable solution, and I would support it.
Okay.
I think also in your question, you suggested that I'm recommending that this large load class be directed at computational load only. And that's not really the case. I am suggesting that it be a large load tariff or a high load tariff. I understand we've got the large general service class and the concern about the title, so maybe we'll call it a high load tariff. I think that, at the lower levels, that there needs to be a high load factor setting so that you're only drawing in customers that have a very high load factor. But once you get, say, above 100 megawatts, I do think that the scale of the impact of the facility on the system merits including it in this class as well, simply because of the cost risk that's associated with serving a customer of that scale. So I think, my general approach would be for smaller customers, a high load factor requirement that should exclude nearly all manufacturing, I would think. I think I recommend 85% and, or maybe 80%. But somewhere in that range would be appropriate for excluding most manufacturing load. And you might find that there's a few kinds of facilities that would come in that would be above that. But I think those facilities would be likely to present the same kinds of operational and cost risks, at least as computational load.
Okay, thank you, sir. No further questions.
Commissioner Vandermark. Commissioner Gaeta? Go right ahead, sir.
Mr. Wilson, this is on an item I don't think we talked about as much, but in your testimony, I'll point you to, you had a discussion on minimum system method.
Yes, sir.
Yes. And I think that was, I think for the record here, I've got it in page 96, I think. Or
Okay, I've got
so,
it
97 maybe?
97, yes,
Yeah,
sir.
thank you. Yeah. So help me understand, if I understand part of your kind of what you're stating here is you have a concern that too much of the primary distribution system is being classified as customer related. Do I understand that right?
Yes, sir.
So I was trying to understand from your testimony, and maybe you can just provide some additional color, is you know, just help me understand more. Why is the primary distribution system why is it not customer related? Or why do you, I understand there's a distinction between customer related and demand related, and I think that's what you're trying to draw out. But why would the bulk of the primary system not be customer related?
Thank you, Commissioner. Yeah, so I'll turn you back to pages 97 and 98, where I quoted Duke's witness. And basically what they were saying is the concept DEP uses to develop its minimum system study was to consider what distribution assets would be required if every customer had only some minimum level of usage, e.g. one light bulb. Now, you would not need a 69 kV transmission system to serve 100,000 light bulbs. There would be no primary distribution system. You might need a transmission system in order to bring power over long distances, but you would almost immediately step that down to secondary voltage. So the concern I have with including the primary system in the minimum system method is that the cost of a primary system, the poles, the wires, et cetera, is much higher than the secondary system. Furthermore, a lot of the primary system is built out to provide reliability benefits. So you would have multiple primary distribution feeders that would be redundant in a theoretical minimum system. I mean, this is one of the challenges with the minimum system is you're describing the cost of something that doesn't exist. And so that's kind of what I'm getting at there is that you've got a system that is probably more miles than you would need, and it's much more expensive to build than you would need. And so that's why I'm recommending, changes to the minimum system method on the primary costs.
Okay, on page 99, I think you mentioned that DEP's primary distribution voltages are, you have 12 to 13 kV, 23 to 24, and 34 kV. Is that right? That's what I understand you to state.
So yeah, so what I'm quoting from there is a discovery response that provided the high side and low side voltages of certain substations. What I did not get in response to discovery was data on the voltages of the lines themselves. That Duke did not have those data.
Of the lines that are connecting directly to the customers?
Right. They did not provide data on their secondary system. They stated that they do not designate circuits in the system of record as either primary or secondary. And so I don't. So while I have that data on the low side voltage of substations that they reported as being at that location, it doesn't mean that those, it's unclear to me a little bit as to exactly what their service configuration is. So I just wanted to clarify that for the record, that I'm relying on that type of evidence and not, often in other cases where I've worked with other utilities and I've asked this type of discovery, We're provided circuit miles by voltage for the secondary system, and it's pretty straightforward. And Duke just did not provide those data.
Okay, and just one last thing to clarify your initial statement there, I think you mentioned that if it was we'll just call it a single light bulb characterization, I think you're saying that in reality would result in transmission being, we would still have to have transmission perhaps, but then that would be stepped directly down to service voltage because that's all that would be needed.
Correct.
Okay, thank you.
Okay, questions on commissioner questions? Go right ahead.
Thank you, Presiding Commissioner McKissick. Just a couple of questions for you. Good afternoon. I believe you were discussing with Commissioner Tucker this high load factor recommendation, if you will, and you are aware, are you not, that the company already has a high load factor tariff?
I am.
Okay, and you're aware that HLF tariff was developed in response to feedback that the company received from traditional manufacturers who have high load factors?
Yes, I discussed that tariff in my testimony, and the point that I made about it was that tariff is more appropriate for computational load and other similar facilities than, for example, the time of use rate tariff. I believe it's the IND-TOU. I'm sorry, I'm blanking on DEP and DEC. I get crossed up on. Find that in my testimony. LGS-TOU. So LGS-TOU is designed to recover more costs through the electricity rate or the energy rate than LGS-HLF. And so my recommendation is that LGS-HLF be the tariff that is, or the rate schedule that is used for the large load class or high load class or whatever you want to call it in the future, in the interim until a fully class-based tariff is developed in the next rate case.
And when you testified in response to questions from Commissioner Tucker along those same lines, that you didn't expect there would be many, if any, traditional manufacturers who would have load factors above 85%, you're not basing that off of, let's say, any discovery that you did of the company in terms of their customers and their customers' load profiles, are you?
I am. I did not get complete information on that. Give me a moment to find the information we did get. So let me try this way. Yeah, so on page 62 of my testimony, DEP, as of December 2024, DEP did not have any customers on its schedule LGS-HLF, and its 137 customers on schedule LGS-TOU had an average demand of less than 5 megawatts and a capacity factor of about 56%. So I don't have information on every customer that's on that tariff, but that indicates to me that, since the vast majority of the customers, the majority of customers are probably less than 5 megawatts, and many of them are probably less than 20 megawatts. So those customers would be excluded from the proposed class, the class that I proposed in my testimony. And then second, the capacity factor being 56% on average, that would also suggest that most of those customers would be well below the load factor threshold. So for those reasons, I think that there would be very few, if any, customers in LGS TOU that would be placed in this class. I'm not excluding that there might not be a couple, but it would be very few. And that's consistent with my experience in the Dominion, Virginia case, where I think there were only a couple of customers that were not data centers or computational load facilities that were pulled into the GS5 class in that case.
But you can't answer, as you sit here today, how many customers in DEP service territory have load factors over 85% or megawatt peak demand over 25 megawatts or 50 megawatts, can you?
Both of those at the same time. I assume that's what you mean?
Correct.
Yes, that is what I just said, but thank you for restating that.
Okay. So you would agree with me then that there are customers, even if it's not the majority of customers, there are customers in DEP service territory who have load factors above 85%.
I'm not aware of that.
You're not aware of the opposite either, are you?
Correct.
Thank you. Finally, you had a conversation with Commissioner Gaida about the minimum system methodology for allocating distribution costs. Are you aware that the PBR statute requires that the minimum system methodology be used for the purpose of allocating distribution costs between customer classes?
Yes, that's quoted on page 98 of my testimony.
Thank you. Nothing further.
Further commissioner questions, please identify yourself.
Sir, thank you. Sorry, Commissioner McKissick, Ben Snowden here on behalf of Microsoft. Good afternoon, Mr. Wilson. It's nice to see you again.
Nice to speak with you, Mr. Snowden.
Mr. Wilson, I want to follow up on a discussion you had with Commissioner McKissick in response to staff questions about, I think it was the incompatibility between large load customers and traditional cost allocation. You talked about how data centers are very different from other large customers like an auto manufacturer or military base. And one of the things that you stated was that the service life of the equipment at a data center is about 5 years. But you also said that you learned that from talking to other people, but that you don't have any personal knowledge of that fact. Is that right?
Yes, that's correct. I mean, research studies conducted by people in the data center industry, that sort of sourcing, yes.
Okay. And when you say equipment, you're referring, well, are you referring specifically to the high performance processors that are used at data centers?
That's one component, but I'm also referring to things like the power systems, the cooling systems. There's a number of very, costly and highly engineered systems that operate within a data center. You can't just sort of pop a mini split heat pump into a data center to cool it. It's got to be an engineered system that is designed to fit with the servers and all of that equipment, is my understanding.
So is it your assertion that the cooling systems and other physical infrastructure at data centers only has a service life of 5 years?
Portions of them could. I'm not referring to like every aspect of the cooling system, but I'll give an example from another point, which is the power systems. I have read about, for example, that certain data center architectures are being enhanced by moving to different voltages in their internal power distribution. And so, one could imagine that in the future, an engineer might say, instead of 600 volts, let's do an 800 volt architecture. Again, this is not an area that I am a direct expert in, but I understand from people in the field that when major system architecture changes are made to one system, all of the others that are physically integrated with it. So I'm talking here about on the racks and in the immediate building environment of the servers, that all of that needs to be potentially reconsidered as well.
So if there is a change to the configuration, those other elements may need to be changed as well.
Yeah, that's what I'm getting at.
But it's not the case that those components necessarily have a service life of less than 5 years. It's just that they may be changed. Is that right?
I mean, I guess it just depends on what your definition of service life is,
Okay.
but I'm talking, you know, in here in the context, I'm talking about the scale of the financial study, the business case that is being evaluated by the data center owner
Mhm.
to determine whether or not to make a major refresh investment. And so what the scope of that is broader than just simply, you know, a few microprocessors.
Okay, understood. And you agree, though, that the capital investment, the upfront capital investment required to construct a data center includes other things like the land, the building itself, backup generation, other significant capital investments that potentially have a longer service life?
Yes, I agree with that. It's just that my understanding is that the major computational load related facility, you know, the servers, the associated power systems, the associated, again, in physical proximity cooling systems, all of those pieces are the largest component of the cost. That's my understanding.
Actually, do you have personal knowledge of how much of the capital cost of a data center corresponds to high performance processors or adjacent equipment with a potentially shorter service life versus the rest of the facility and the physical
No, I do not.
infrastructure?
This is exactly the information that I was referring that I've reviewed a number of different sources on, but I don't have direct personal knowledge.
Okay, thank you very much.
Go right ahead.
Good afternoon, Mr. Wilson. Carrie Grunman on behalf of Walmart. I'll be honest, I heard you mentioning kayak, and it always happens this way. And you were like, let me think of a customer example. And then you mentioned Walmart. Can you?
Just because you were sitting there.
Well, you know, I was sitting over there, which is how I wondered how you had eyes behind your head. But I was just curious as to, I then heard numerous comments in response to commissioner questions where I felt like you were distinguishing between the characteristics of data centers and other traditional industrial and manufacturing customers. It is not your opinion, is it, that a Walmart store or a Sam's Club is similar to a data center?
No.
Okay. I'm going to start there. So then I also did not realize I would be discussing Dominion's GS5 in North Carolina so much. Were you a witness in that case?
I was.
I thought that you might have been. You mentioned a couple of times today in response to some commissioner questions. As I understand it, you sort of think there are certain customers that no matter their load factor, their size warrants a large load tariff. So like, I think you said 100 megawatts. Is that correct?
Yes.
And then as I believe it, your proposal is for there to be a tariff at 25 megawatts, correct?
Yes.
But as based upon what I heard you say today, you think there should be some sort of high load factor threshold for those smaller customers.
Yes.
And then,
and if I can quickly clarify on that, because I heard the discussion earlier about the 75% over 3 months. I don't agree with that aspect. I would need to go back and verify that. I actually, if that's the case, I did not recall it coming in here today. But anywhere in my testimony where I'm speaking about a load factor, I'm talking about an annual load factor.
okay, so to the extent you are supporting a load factor and like a smaller, so let's say 25 to 100 megawatts, you are also proposing an 80% annual load factor, not some sort of lesser number of months where you hit it.
Exactly.
Okay, and so by virtue of having someone who on an annual basis is hitting 80%, that's why it's your position that most traditional commercial manufacturing and industry wouldn't likely to be caught into that tariff.
Exactly.
Okay, let me make sure I had one other question, but I think that it's the annual makes more sense.
I'm glad you agree with me on that.
Well, I can tell you for certain that within Dominions, it is based on 3 months of hitting their load factor.
I will take your word for it. Thank you.
Those are all my questions. Thank you.
Go right ahead, sir.
Thank you, Presiding Commissioner. I have just a couple clarifying questions. Mr. Wilson, when Presiding Commissioner McKissick was asking you questions, I think these were from Commission staff. He asked about, I'll start here with the your recommendation to set a large load class or to establish a large load class to set rates and the limited amount of information on data center loads to date. And I think you kind of got at this in your colloquy with counsel for SIGFR, but could you just explain what I believe your recommendation is to use kind of LGS HLF as a bridge? I want to try to connect those two pieces.
Yeah, commissioners, my recommendation is that the tariff should be set up just like any other tariff for any other class, but that instead of designing a rate for this class, that you just simply adopt the LGS HLF rate as the rate for this class, whatever that rate turns out to be as a result of the settlement and any, I have not tracked all the settlement terms, but whatever the implications are of the settlement for adjusting rates, that those be carried through, HLF be determined as would be determined under the settlement, but that then that rate be just simply included in the large load tariff and it be required for all those customers. And one reason for that is that right now, customers have the opportunity to choose other rates that are significantly have lower demand charges and higher energy charges. And as a result of that, during the period that they're ramping up, they are contributing significantly less to fixed costs of the system than they will be eventually when they reach contract demand and they perhaps switch over to rate HLF. So there's a revenue loss as a result. I think that was something that was testified to in the DEC hearing by Duke witnesses, that for the same customer, they have an advantage at sometimes to be on LGS TOU and it's sometimes to be LGS HLF. And what I'm saying is put them on the rate that is appropriate to the service requirements that they are requesting, that they are requesting transmission and generation that will meet those parameters, that will deliver power at a high load factor, and therefore will, they should be charged accordingly.
And just to clarify, so I said bridge, maybe I'm getting this wrong. You're saying put them on LGS HLF until the next rate case?
Right. And then in the next rate case, you would design, normally you would design a rate based on the customers in the class billing determinants. So their peak demand, monthly peak demands, and their energy use. And that would result in a rate like HLF, but it might have a different load factor assumption in it. So the load factor assumption might be 89%, simply because that's what comes out of the evaluation of the customers that are on the rate and their billing determinants. If there still aren't enough customers on that rate, then Duke is going to have to make some choices about how to design that rate. But that would be normal. Duke has, I believe, a number of rates with a very small number of customers, and they have methods in the cost of service study. Happy to talk about that, but there's methods in the cost of service study as to how to deal with that circumstance. And so this would be a little different in that you would have a class with a small number of customers potentially, but you'd still have to apply those same kinds of concepts.
Okay, one more clarification. So I think it was the next question that presiding Commissioner McKissick asked you was if you could elaborate on the interaction between financial security requirements and the creation of a large load class. And I know in the large load tariff that you would propose and in the public staff's proposed tariff and Duke's, there are these kind of, I think of them as stranded asset protections. Could you explain whether those are still necessary when you have a large load class or not, and what they should be?
Yeah, I mean, that is the point, is stranded asset protection is the key issue, I think, here. And that's accomplished both through financial security and through the exit fees. We haven't really talked a lot about the exit fee proposals in my testimony, but those are also essential because if a customer determines after one of those refresh cycles that I was discussing with Mr. Snowden, if say 10 years into the life of a very large facility, they determine that they made their best shot at it, but the other AI company won out and they're going to close down their facility. The exit fee needs to be large enough to recover costs so that there are not costs shifted onto other customers. Does that address your question?
Even when there's a large load class, that's still
the case. Yes.
Yeah,
and it's possible that you might structure the large load class so that those costs would be shifted onto other large load customers. But I think that those customers would find that undesirable.
No further questions.
Thank you. Well, sir, you're released.
Thank you very much.
Thank you for being here this afternoon. It looks as if we're now moving to public staff panel.
correct, Presiding Commissioner. Thank you for that. The public staff now calls Caleb Hill, Eric Fernandez, and Tommy Williamson on the topic of the PIM stipulation. While we call this panel, that we'll have a brief change in cast of characters here.
Absolutely. Give everybody time to transition. Oh. If you could go ahead and put your left hand on the Bible, raise your right hand. You solemnly swear the testimony about providing this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Mr. Fernandez. Will you please state your name and your current position for the record?
My name is Eric Fernandez, and I'm a utilities engineer for the Public Staff's Energy Division.
Okay. And Mr. Hill, will you please state your name and your current position for the record?
I'm Caleb Hill, engineer with the Public Staff Energy Division.
All right. And Mr. Williamson, will you
Uh,
please state your name and your current position for the record?
Sure. I'm Tommy Williamson. I'm a staff engineer with the with the public staff.
And is it correct that the business address for all three of you is 430 North Salisbury Street, Raleigh, North Carolina, 27603?
Yes.
Yes.
Okay. Now, on August 6th, 2026, did you prepare and cause to be pre-filed direct joint settlement testimony in this docket consisting of 6 pages?
Yes.
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 And did this testimony contain confidential information?
No.
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 Did you have any corrections to this testimony?
No.
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 Okay. If I were to ask you the same questions today, would your answers be the same?
Yes.
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 All right. And finally, did you prepare and cause to be pre-filed on August 7th, 2026, a summary of your joint settlement testimony in docket number E2 sub 1380A?
Yes.
Yes.
Okay.
Yes.
So, Presiding Commissioner McKissick, at this time, I would move that the pre-filed joint settlement testimony of Mr. Fernandez, Mr. Hill, and Mr. Williamson, consisting of 6 pages, as well as the pre-filed joint summaries of their settlement testimony, be entered from the record as if given orally from the stand.
Without objection, your motion is allowed.
All right, and so now this panel is available for cross-examination and commission questions.
Okay. Give me 1 minute, gentlemen. I just wanted to check my outline twice here. I'm not seeing questions of this particular panel. All right. Let me look to see if there are any other questions from commissioners of this panel. Chair Brawley, Commissioner Tucker, Commissioner Vanderhart, Commissioner Gaida. We have gone through this as an exercise of formality. Your testimony is now officially a part of the record. There will not be any questions on commissioner questions unless you're reading our minds. In which case that's inadmissible. You're hereby released. Thank you.
I'm sorry, Presiding Commissioner. There had been at least one party that had crossed for this panel earlier. We should have moved, or I believe they dropped it, but we
Okay.
in hindsight, we should have moved for their excusal, and I'm sorry for taking your time.
Oh, it's okay. I went through the outline twice. I said, maybe I missed something, but nevertheless, thank you.
I don't think they're sorry.
We're going to take a 5-minute break and we'll resume with our last 2 panels. And I think we'll conclude everything today, unless there's some very, very lengthy responses. And it looks like we have the panel of Bird and Beveridge before us at this time. If you could put your left hand on the Bible, raise your right hand. Do you solemnly swear the testimony you're about to provide in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
I do. I do.
Thank you.
Thank you. You're way ahead of me, Presiding Commissioner McKissick, as
It's
usual.
all right. No, that's-
Well, we are at the finish line, so we will get through these preliminary matters as quickly as possible.
okay.
Mr. Byrd, we will start with you. Can you please state your name and business address for the record?
Yes, my name is Jonathan Byrd. And my business address is 293 Boston Post Road West, Suite 500, Marlborough, Massachusetts.
And in what capacity are you providing this direct testimony?
At the time I filed my direct testimony and exhibits, I was employed by Duke Energy Business Services LLC as Managing Director of Rate Design and Regulatory Solutions. After filing my direct testimony, but prior to filing my supplemental direct testimony, I became employed as Vice President at Concentric Energy Advisors. I have continued to assist DEP on the rate design, tariff, and service regulation issues.
Thank you very much. So on, November 20th, 2025, did you cause to be pre-filed in this docket direct testimony consisting of 52 pages and 11 exhibits, including subparts, which testimony was then amended by filing made February 26, 2026. And your exhibits 5, 5-1, 5-2 were corrected on July 31st, 2026, correct?
Yes.
Subsequently, on May 6, 2026, did you cause to be profiled in this docket supplemental direct testimony consisting of 3 pages and no exhibits?
Yes.
Thank you. And on May 18, 2026, did you cause to be profiled in this docket 3 supplemental direct testimony exhibits, including subparts?
Yes.
And do you have any corrections to be made to your pre-filed direct and supplemental direct testimony?
I do not.
And none of your testimony or exhibits contain confidential information, correct?
No.
I would ask you those same questions today. Would your answers be the same?
Yes.
Did you also cause to be pre-filed a summary of your pre-filed direct and supplemental direct testimony that was pre-filed in this docket on August 7th, 2026?
Yes.
All right. Thank you. Turning now to your rebuttal testimony, on July 24th, 2026, did you and Mr. Beveridge cause to be pre-filed in this docket a joint rebuttal testimony consisting of 51 pages and 4 exhibits, with a correction being made to rebuttal exhibit 1 on July 31st, 2026?
Yes.
Subsequently, on July 29th, 2026, did you and Mr. Beveridge cause to be pre-filed in this docket Byrd, Beveridge, rebuttal exhibits 2, 2-1, 2-2, and 4, 4-1, and 4-2?
Yes.
Do you have any corrections you need to make to your pre-filed rebuttal testimony?
No, I do not.
Thank you. And none of your testimony exhibits contain confidential information, correct?
That's correct.
If I were to ask you the same questions today as were set forth in your pre-filed rebuttal testimony, would your answers be the same?
Yes.
Turning now to the settlement testimony, on August 6, 2026, did you and Mr. Beveridge cause to be pre-filed in this docket joint settlement testimony consisting of 7 pages and 6 exhibits, including subparts?
Yes.
Do you have any corrections you need to make to your pre-filed settlement testimony?
No.
If I ask you the same questions, would your answers be the same?
Yes.
And did you cause to be filed a summary of your joint pre-filed rebuttal testimony on August 7th, 2026?
Yes.
Very briefly now, turning to the settlements, there's 2 settlements that you are addressing: the Comprehensive Revenue Requirement Agreement, as well as the DCFC settlement. Have you reviewed both of those settlement agreements?
Yes, I have.
And in your opinion, are both of those settlement agreements in the public interest and should be adopted by the commission?
Yes, I support the comprehensive settlement as representative of negotiated compromises that reflect a give and take among the company and stipulating parties.
And do you
And-
also support
and
the DCFC stipulation as well?
Yes, and the DCFC stipulation as well.
Thank you very much. Now turning to you, Mr. Beveridge, can you please state your name and business address for the record?
Yes, my name is Morgan Beveridge. My business address is 525 South Tryon Street, Charlotte, North Carolina.
And by whom are you employed and in what capacity?
I'm employed by Duke Energy Business Services, LLC, as Director of Rates and Regulatory Planning. I lead a team responsible for rate design, rate analytics, and load research across Duke Energy's jurisdictions.
Thank you very much. And for the benefit of the commission, you did not file direct testimony in this docket, correct?
Correct.
But you did join in the rebuttal and settlement testimony with Mr. Byrd, correct?
I did, yes.
If I were to ask you those same questions that are set forth in your joint pre-filed rebuttal and settlement testimony, would your answers be the same?
Yes.
And now turning to the settlements, same questions to you. Have you reviewed both the comprehensive revenue requirement agreement and stipulation of settlement, as well as the DCFC settlement that were filed with this commission?
Yes, support the comprehensive settlement and the DCFC stipulation as negotiated compromises that reflect the give and take between the company and stipulated parties.
Thank you very much. Presiding Commissioner McKissick, with that, I would ask that the pre-filed direct testimony, Mr. Byrd, filed on November 2025, the pre-filed supplemental direct testimony, Mr. Byrd, filed on May 6, 2026, the joint pre-filed rebuttal testimony filed on July 24, 2026, and the pre-filed settlement testimony of Mr. Byrd and Mr. Beveridge filed on August 6, along with all pre-filed summaries and exhibits be entered in the record as if given orally from the stand.
Without objection, your motion is allowed.
Thank you very much. With that, this witness panel is available for cross-examination and commissioner questions.
All right, first in the queue is the Attorney General's office. Did you waive? Yes, sir. All right, thank you. ADS, you're next in the queue.
Thank you. Good afternoon, gentlemen.
Good afternoon.
My name is Robert Josie. I'm with the law firm Nelson Mullins on behalf of Amazon Data Services. Mr. Byrd, I believe this first line of questioning is appropriate for you. Is it correct that there are demand charges included in the rate schedules that Duke is proposing large load customers to take service under?
Yes.
And what is the purpose of a demand charge?
Demand charge typically attempts to recover a significant portion of fixed cost used to serve those customers.
Okay, and when you say fixed costs, what do you?
Fixed costs would be non-variable costs that costs do not change as a result of, say, load variation month to month. They would be like installed capital in a generation or a transmission line, for example.
And those demand charges, are they included in the minimum bills?
Are you speaking about the company's proposed large load tariff, or are you speaking in general?
Just generally, if you have a tariff with a minimum bill or demand charges included in that?
A lot of our just standard tariffs have minimum billing provisions in them, and a lot of them are related to that demand charge. That's correct.
Yeah. And what is the purpose of that minimum bill?
The purpose of the minimum bill is to ensure that we have revenue recovery throughout the year, or if a customer has a shutdown or some variation in load, the company has invested significant amount of capital that remains invested despite that customer's load going up and down. And so the demand charge is there to ensure that you get consistent levels of revenue to address those very consistent cost items from the capital invested.
Thank you. And it's my understanding that you can both speak to witness Duff's testimony as well.
I think so.
Okay. In Mr. Duff's testimony, he states on page 23, lines 10 and 11, that the companies with signed ESAs have made. Do you need a second to get there?
Were you speaking about his direct or rebuttal testimony?
I think he just had rebuttal testimony.
Okay. Can you give the page number again, please?
23.
Okay.
On lines 10 and 11, he states that companies with signed ESAs have made substantial capital decisions based in part on the expectations regarding the binding terms and conditions of the ESA with Duke, correct?
Yes.
Okay, and can you explain what he means by capital decisions there?
I think he's speaking to the planning that these customers are making to secure a site and construct, procure and construct their location.
That's all the questions I have.
Okay, thank you. Next in the queue is Microsoft.
Microsoft waives cross-examination of these witnesses.
All right, North Carolina Justice Center et al.
Presiding Commissioner, panel, this is Nick Jimenez with Southern Environmental Law Center for NCJC et al. Just a few questions. Turning to, I'd refer you to page 8, lines 18 to 20 of your rebuttal testimony. This is about termination damages. Let me know when you're ready.
Yes.
So I'm seeing there that the proposal is 15% of remaining minimum bills. And just leaving the other parts to the side. Do you see that?
Yes. What, did you say page 8?
I think this is on page 8, lines 18 to 20. No, page 9. I'm sorry.
Page 9, okay. Yes, I see here where we're, describing the elements of the performance and credit provisions in the proposed large load tariff.
And so this is the item termination damages on lines 14 to 17.
Yes.
Recovers 15% of remaining minimum bills, et cetera.
Yes.
Okay. Now, in DEC, as I recall, and I think we discussed, the proposal was that termination damages would be 25% of remaining minimum bills, putting the other parts to the side. So is your proposal to lower that to 15% for DEP?
So what we're trying to do here is recognize that in DEP, a greater amount of fixed cost recovery occurs through the demand charges on LGS TOU than is the case on OPTV for DEC. So what we're trying to do is make sure that customers with similar sizes would receive a consistent termination damage in their ESA. And so this roughly makes them the same. That's been the case since the commission approved some service regulation changes back in early 2024. We started using these minimum billing demands in this approach. We were using a different number for DEC and DEP to derive the termination damages to then place them in the ESA because we were looking at driving consistency between the two operating companies, and we didn't feel it was, it was not necessary to adjust those just because you had a historic difference of fixed cost recovery through demand charges.
Okay, so in Exhibit 1, the actual proposed large load tariff attached to y'all's testimony, rebuttal testimony. This is page 2 of Exhibit 1. On my PDF, it's page 53. I'll just tell you, it's, to my eye, it still says 25% there. Is that just a holdover?
It was a holdover from the DEC tariff. It was updated, and I believe filed, but I don't have the reference here.
We did file a correction. If you need me to find that, I can find the date. I have that somewhere in here, but we did file a correction to update that 15%.
The 15% was the intended percentage.
Okay.
Again, reflecting the current pricing differences between DEC and DEP, and something that, we would hope to converge and reconcile as the pricing between the two utilities, converges over time as well.
I see. Okay, so turning to your defense of Duke's large load benefits analysis, you could look to pages 27 to 32 of your rebuttal. Let me know when you're ready.
Yeah, I'm there. Thank you.
So the public staff's, as you described it here, the public staff's analysis used a worst case or lower bound estimate of 75% of contract demand for all 25 large loads considered, right? I'm looking at page 29, lines 11 to 15.
Yes, that's one of the scenarios they ran.
And then you said you think that's highly unlikely given the rigor of the large load interconnection process and the substantial financial commitments embedded in the ESAs. Right?
Yes.
That's just following.
Yes. Given that these are this model was looking at 25 individual ESAs, 16, different projects and companies. And so to assume that all 25 of those are going to fail to reach 75% of their, intended contract demand, given the rigor of that large load process, thought was really a kind of unrealistic assumption. But more importantly, I think on this piece is that the model was not designed to speak to this scenario because if we started to see that large loads were not materializing as expected, we would make adjustments to our resource plan. We would make adjustments to our load forecast. And so that's, we talked a lot about in the IRP of that, of the realization rates, or seeing the materialization rates. And so, we have lots of checking points between IRPs, CPCNs, rate cases, where we're going to be looking at how these loads materialize and come online. And we would not get 10 years down the road and see 25 ESAs not materializing and still building an extra gigawatt of generation to the original contract demand they asked for. It's just unrealistic compared to all the safeguards that we have in place to make sure our resource planning is prudent.
So, I appreciate that answer. So if the AI bubble pops, for example, and the data centers, vanish, or they reduce their demand and contractual minimum kind of in line with that worst case projection, DEP would adjust over time. Is that a fair summation of what you just described?
Certainly, yeah. Our load forecast is based partly on actual loads that have come onto the system. And so we would see some of this in the actual load. And then to the extent we have ESAs, we can apply adjustments based on our experience and materialization. And so the resource plan would be adjusted. We would, move out or drop off generators in the future that didn't look like they were going to be needed if we started to see, these ESAs move that direction.
But aren't some of the things that DEP is building now to serve growing demand eligible for construction work in progress?
I believe that's true.
Thanks.
Yes.
No further questions.
Okay, that would bring us to redirect.
No questions.
Right, we do have a few questions from commission staff and then maybe a few others from commissioners. In both the DEC and DEP rate cases, the company filed its own large load tariff in rebuttal. There seems to be a difference in the amount of termination fees in the proposals. Are there any other critical differences between the two tariffs? And if so, what's the rationale given the upcoming merger date?
No, there are no differences other than the 15%, the 25% we were just speaking about related to termination damages, just reflecting the current pricing for demand charges.
Exactly. Thank you. Now, Mr. Byrd, how many customers are there currently on schedule LGS HLF? I don't know why I'm getting ready to mispronounce it after 3 weeks of of saying it correctly.
Sure, I can speak to that. There are no customers in DEP on LGS HLF. The corresponding schedule in our Duke Energy Carolinas territory does have, I believe, 3 customers, but LGS HLF does not have any customers yet.
All right. And we move on here. One of the sensitivities in the public staff's analysis of large load impact analysis showed that large load customers did not provide a net benefit. Has Duke stress tested its revenue projections to determine a minimum amount of revenue generation that will provide net benefits?
So this speaks to the discussion we just had, that the large load impact analysis was done using a model that was really intended to reflect the benefits if the load materializes. Because you are looking at the transmission and generation build if that load does materialize and comparing the revenues to those costs. If the load does not materialize, things would really just scale downward. And to the extent that there are I guess, damages that would offset those benefits. That's what we're really trying to construct the performance and credit provisions and now these large load tariff proposals to recover any stranded costs and then provide adequate time to be able to redeploy those resources in our resource plan so that they continue to be used and useful in the system and don't detract from those benefits. So I would say it's difficult to model a certain threshold because we are really intending to capture those risks and downsides through the performance and credit provisions to maintain those benefits.
And if I might add, just those performance and credit provisions, the long-term contracts, even in our rebuttal large load tariff, the notice provisions, the termination damages are expressly designed to give the company time to do that adjustment in the resource planning process. So that's when you try to apply that minimum billing logic to what happens if they do show up, I think that's just missing the point. You've got to separate those and look at them in two different buckets. We want to make sure we have enough time to adjust the resource plan, and that's why we've designed those pieces in that proposed large load tariff.
Thank you. Has Duke previously designed new rate classes or rate schedules in an expedited manner as is requested by multiple interveners? And how much time would Duke estimate they would need at a minimum to conduct an expedited process?
So we have had history of new rate classes. I believe like the OPTV class in DEC was a new rate class that was pulled together a number of years ago. I think the issue is not how long does it take to do the math. I think Witness Hager spoke about that, right? You can do the math. The question is, do you have the data to separate that class? And right now, our position is we don't have enough data to separate that out looking forward. Cost of service is a backward looking exercise. So once you get enough customers in that bucket, you can do that math. So that's kind of where we're thinking. You look out and you can do that in the future. I know we've talked a lot about the Virginia GS5 class. I would stress that in that development of that class, they had, I think, more than 100 customers that were considered for that class. So they had data upon which to design and base that new class. I think that's kind of the position we're in right now is we are thoughtful about the tariff design. We want to make sure we're covering the risk if the load doesn't show up. And when they do show up, when we get enough customers in that size category or load factor category, that's when you could consider separating them out as a different class, and maybe they get a different rate outcome as a result.
Okay, now historically, how did Duke handle large industrial customers with high load factors interconnecting to their systems? Was it ever necessary to create an alternative cost recovery mechanism to front load anticipated costs to serve them?
So, yeah, I would start just as we're talking about rate schedules and classes. We do have like the large general service class is looking at larger customers, and DEC, the OPTV has the primary distribution and transmission distinction that sort of capture those larger customers. And even though we do cost of service at a class level, it's how we present exhibits in a rate case. Those cost of service teams also do that analysis at a more granular level, and you can see some of the detail behind some of those rate schedules to make sure that you can appropriately allocate costs between rate schedules within a class as well. And so for larger customers within a large general service class, you still have information to know the appropriate kind of cost of service and rate increase for those customers. And so that's part of the way we can address that. And then I would say some of the provisions we have, scale with size. So our minimum bills based on minimum billing demand, our termination charges that consider, loss due to early retirement and minimum bills, extra facilities charges. These things generally scale with customers. And so I don't think we've reached a point with large industrials where we felt like something was needed outside that.
I think part of your question is when you were connecting a new customer, if they're asking for something that if there was a required payment from them for that. So there's one instance where we have an extra facilities charge. So if that customer is asking for something, I'll give an example, like a dual feed or some other redundancy need that we would consider to be non-standard. So they're asking for something that's not the standard delivery service. We would apply an extra facilities charge and they would pay that above their normal tariff. But what's included when we're doing the design and the pricing for like LGS TOU, it includes the standard service. And so as long as they're getting that standard service, they are paying for the use of the system and their extension of that system to serve their load.
And how should the commission think about the consistency which Duke has applied the ESA provisions based on the concerns raised by public staff?
Yeah, I've heard those concerns, and I would say there is a concern of inconsistency, but from where I've been participating in this all the way back to late 2023, what we have done is progressively increased those provisions. And so if you think about when we received approval in early 2024 for modified service regulation, we were imposing performance provisions and credit provisions consistently going forward. Later, we included other provisions like accelerating the ESA up into the letter agreement a little bit on a time. I think it's 120 days you have to sign an ESA. We included the refundable advance. We included their curtailment provision. Once those came into play, I think it was late 2024, early 2025 timeframe. Once we started using those, we were using them consistently going forward. So if you look back over time, yes, you can find ESAs with different terms, but once the company adopted that standard, it used it consistently going forward. And I think that's just evidence of the proactive response and approach the company's used over this time frame, where we've seen other utilities making changes. It's a dynamic market. We've been proactive and updating our approach to pricing and dealing with these large load risks. And I think the proposal that we included in our rebuttal testimony is a very natural extension of that progression that we've seen over the last 3 years.
And I guess the follow-up would be, now that you have this new modified ESA, would you consider amending it as need as time moves forward, unless it is completely uniformly directed, unless the Utilities Commission directs you to just use it as is? I guess otherwise you would continue modifying it as the need changed or as new issues arose. I mean, how would you envision that occurring? I mean, you speak of an evolutionary process, which is understood, but, and I understand it now, it's standardized based upon the way Duke views it at this time. But moving forward, unless the commission were to direct you to use a uniform standard ESA without modification, would you continue just modifying it?
So if you're speaking about the progression over time, I would say I think there's examples of that already, of starting with performance and credit provisions in 24, adding in the refundable advance, the curtailment provisions, things like that. And then even, I think tangent to this is like our large load queue process and all the, reforms we put into that. So I think as we're learning and having discussions with customers, with public staff, incorporating best practices and making sure, as we do things like the large load impact analysis, and there'll be more iterations of that as we go into new cost of service studies, where we actually start to bring in these customers and better understand what their cost of service looks like. We would absolutely, adapt that over time.
Okay.
And I would just add some of the discussion with public staff, I think, around those ESAs and what they thought might be inconsistency. That was looking at the spring 2026 large load report, that 25 ESAs that, was the same ESAs we put in this large load impact analysis. Some of those were in South Carolina, most were in North Carolina. Some were economic development projects, where others were data centers. Some met the large load definition that would require the ESA for large loads, and others wouldn't. And then they changed over time as well, or they were signed at different points in time. And so when you consider all those factors, there were differences between those ESAs. But to Mr. Bird's point, if you look at the form ESA that we had adopted in 24 into 25 now, that was consistently applied, and the modifications were wording changes on the margin, to get comfortable with certain things. But the major provisions we've talked about of curtailability, minimum loads, longer contract terms, consistently applied in every one of those, tariffs based on the time it was implemented or signed.
You want to say something further, Mr. Byrd?
If I might add, I think there's been concern about transparency as well. And I would say the company's been made a lot of efforts to be transparent, even through this where, you're saying we had this ESA that we were using. It was not part of the tariff or published on the tariff website. It was an ESA that was consistently used. The economic development team was very transparent in sharing that with customers through that time, prospective customers. I came and sat down on several occasions, had discussions with public staff on that. So I think we had a significant amount of transparency through what was being done with that ESA. And as I've already described, that approach allowed us to progressively enhance those performance provisions in a pretty quick manner in response to some of the market dynamics we were seeing.
And I guess the question that logically follows up, assuming there was that open dialogue, constructive dialogue, and everything was getting evolving in a way that it was mutually understood between Duke and the public staff, why do you feel the public staff's testimony is to the contrary?
I'm not sure, Commissioner.
That's fair enough. I mean, I gather their testimony does not appear to be consistent with the perceptions of Duke as you've articulated it today.
I mean, I remember being in the room doing page turns of the ESA and so forth. As that was being modified, say early 2025, and we discussed large load topics and the need for some of these performance provisions in late 2023, which allowed the public staff to come and support in a staff conference meeting in January of 2024, those performance provision changes. So I feel like we had good communications and we're pretty open about the challenges we were trying to address with the contract provisions.
Thank you. Let me see if there are further questions from my colleagues. Chair Brawley. Commissioner Tucker.
It's 3:15. And gentlemen, either one of you can answer my question. And Mr. Byrd, congratulations on your new slot as VP.
Thank you.
But we appreciate you being here and all your expertise and years of learning being at Duke. Mr. Beveridge, you talked about if loads do not materialize. Did you not just a moment ago?
Yes.
And that Duke is always in a mode of analysis and adjustment. And I don't doubt that for a minute. But, we're getting the windows closing on making decisions about funding, et cetera, where the money's come from, those kind of things. Do the performance penalties, the adjustments, the refund advance, the provisions that are in the ESA, do they cover the cost if you're moving ahead or Duke is moving ahead and they get to a point where they built half a gas plant and then the material, Mr. Jimenez used the word AI bubble. If something like that happens, how does Duke recover from that? Or is that all going to be in the rate base and are the rate customers expected to pay for something like that? I mean, you got five or six gas plants going on. Part of that is certainly a large part of that is a response to the opportunity you have with data centers. And then, you the customers were coming to you, I would guess in 25, if Mr. Byrd's correct, in January 24, having some discussions about what you were trying to do as a company, and then you went out and signed up all these ESAs, and then we heard about it, or at least I heard about it commission-wise in March, I guess, when the 23 or 26 were on there. So, I mean, you got all this bevy of business that you've signed up for. We're trying to determine how we're going to pay for it. And then if the load does not materialize over time, I know Mr. Byrd said that the company has enough time or should have enough time or there's enough leeway there to stop or curtail building some of the generation. what covers that cost if that scenario were to come about? Which, you know, both of you've read about data centers being put in orbit and the sun giving the energy and, you know, that somebody's now calculating something probably, in my mind, better than AI. And the next step as we move through in technology, just help me as a commissioner get comfortable with you guys bowling on ahead with business in your pocket, cash in your hand, and we're going gung ho. And Mr. He said the other day, Duke's going to borrow $10 billion between now and 2030. Help me understand what that scenario in business I can see happening. What safeguards, if you will, are in place to make me feel comfortable with where Duke is going with all this?
I think the first thing I think about is the word speculative, right? So if you have a customer, a prospective customer that's wanting to build a data center, they're asking questions about it. The company is not putting that into that load forecast and that IRP process until you get that high probability or that signed contract. So when we have those signed contracts, that's when the provisions that you're talking about come into play, when we have the signed ESA. And so that's what's driving that resource plan, is those signed contracts. And so those provisions are in force, and that gives us the termination damages and so forth that allow us to adjust the resource plan if that load subsequently doesn't show up. But those are contracts that are executed. And so you have those performance provisions in place. When you're talking about the half-built gas plant, that gas plant would be based on a load forecast that includes signed contracts.
But people can back out of contracts, Mr. Berg. In business today, they pay penalties, but do those penalties cover the building, the other build out of the gas plant?
So what we would try to do is have the penalties cover the time it takes to adjust. So think about the revenue requirements until such time as the resource plan adjusts. So if you've got, minimum bills for an extended period of time, whether it's through the notice provision or the termination damage, that gives you cash that's funding that resource and gives you a chance to adjust the resource plan so that gas plant can be used for, the other customers that are coming and the normal growth that we're experiencing on the grid as well.
Yeah, I think the large load queue, the refundable advance, those are the things on the front end that are trying to make sure we have the serious projects that are as committed as possible, the longer term contract. I think what you're speaking about of if you have a customer that comes on, but the load's not materializing, or what stops them from leaving, what covers that cost. It is partly the minimum bills. 75% of contract demand is a significant minimum bill payment. And that also, translates to termination damages that are based partly on minimum bills. And so the termination damages for a lot of these large ESAs are in the hundreds of millions. And so that, just like Mr. Bird said, I mean, that's going to help fund those revenue requirements for a period of time for the system to grow, for Duke to, update its resource plan and sort of reintegrate that in. I would say from a practical standpoint, for better or worse, we sort of have the benefit that we have traditional load growth, we have coal retirements coming up, and we have a higher reserve margin that we're building for. And so a lot of the upcoming large generation assets in 29, 30, 31, those are driven by those other factors. You're not going to have a resource that's solely driven by large loads until later into the 2032, 2034 maybe. And so the amount of build that's needed sort of absent these large loads provides a little bit more time as well, or opportunity to again sort of adjust that resource plan to absorb any generation build.
Good. Two more questions. The 23 or 26, I don't know what the number is now, of ESAs that are in the queue, are they all solid contracts?
I'm not sure what you mean by solid contracts.
That they're in the load forecast, they are signed, sealed, delivered, and you're going to have to build load generation and transmission for those 23 ESAs. I mean, You know, I mean, in sales a long time. I got the contract. Have you got the deal done on 23 of them, or is it 14 or 26, or what's the number? That equates to that 6.7 gigawatts that Mr. Lucas mentioned earlier today, that all of a sudden set precedent, you know, come in with this big load. Are all those contracts there? I get the growth, I get the industrial growth, I get the population growth. And now I'm asking those ESAs, are they all done deals and signed, sealed, and delivered?
I mean, once we get to the ESA stage, that is a signed agreement. We had 25 ESAs in that spring 2026 large load report, and I think we talked about 4 ESAs, I think 3 of which were retail that were added after that. So somewhere in the high 20s there, I think that we're at this point in time. So those are all signed ESAs with financial obligations. I would make the point that the interconnection facilities and transmission, some of that's built on the front end for those ESAs, but the generation, it's not like we commit to a certain generator at a certain point in time for each of those ESAs. Those just go into our load forecast and into our resource plan. So to the and most of those ESAs are coming on in a number of years, and then their load ramp will be a number of years after that. So the, I guess, integration of that load, the building of the generation, and the time to adjust is really a 10-year time frame. It's not something that we commit, fully commit all those resources to right when the ESA is signed.
Okay, so am I to understand, are you saying you've got ESA signed and financial obligations committed and all of that for in the high 20s?
Yes, that's well, it depends on the scope that you're talking about. That high 20s number references ESAs across both DEC and DEP, North and South Carolina, above 20 megawatts.
Okay, fair enough. Thank you, gentlemen. Appreciate you answering my questions. No more
Thank you.
questions.
Commissioner Vandermark.
Just one. I've heard this before, and there was a previous witness. I don't understand about this idea that you need retrospective data to develop a class as much as you would need that for developing a tariff. And you've got a negotiated tariff. It may not be right. It's whatever it is. But you've got pretty much information just to define the class. And then you can put your negotiated tariff in that class if you like, if you feel good about it. But the impact of inaccuracy to the rest of the classes is more to do with whether that tariff is right than whether your definition of the class based on the type of load factor, voltage level. I mean, isn't that right?
So I agree that it is much more important to get the tariff right at this stage than the class. So let me speak about why, and then I'll describe why the class is something that can be addressed later. So the tariff, and we're talking about tariff in kind of a broader sense of including those performance provisions, termination, credit, and all of that. That's very important to get right up front. And so we had that since early 2024, as I've described.
But you don't have retrospective data on that. That's a negotiated tariff that you all are putting forward.
So those were performance provisions that are layered on top of the normal embedded cost tariff, like LGSTOU. And so if you look forward, when you say, let's pull out and look at a separate class, I have to have data from actual customers that were operating that look like those high load factor, large loads, if you will, in order to have Witness Hager, who spoke about this, in order to have that cost of service model actually run and allocate those costs based on billing determinants from actual load. That's the way you do the cost of service.
I know you're going to do a cost of service once you get these guys going, and I get that. What I'm saying is that's going to be really valuable for truing up your tariff that you started out with as a negotiation. And I get all that.
That's right.
I just think that the class, the bin, is not nearly as dependent on that. I mean, you have a lot of information in these ESAs about these facilities that you could, I mean, hell, Virginia just uses, I think we were actually trying to nail this down, but a 25 megawatt with a 75% load factor, and that was it. They defined that was a class. You didn't need any cost of service study for that. You do for the tariff. I guess I'm just saying, I don't feel any more comfortable about you putting a tariff forth for these facilities that that we don't have retrospective data for. In fact, I think it's more important than developing a class, and the class will provide greater transparency when you do the cost of service, because it'll be defined in that class. But anyway, that's all I need. Thanks.
Commissioner Gaeta? All right, questions on commissioner question? Go right ahead. Identify yourself for purpose of the record.
Thank you. Good afternoon, Christina Kress for SIGBUR. Good afternoon, gentlemen. I just have a couple of questions for you. Mr. Byrd, I want to start with you. I want to ask you about the discussion that you had with Presiding Commissioner McKissick in response to a question from him regarding what time or process is needed to develop a new rate class or a new rate schedule. And so I just want to ask, in your experience, turning back to the comprehensive rate design study, which spanned 12 months leading up to the filing of the finished report with the commission in March 2022. Is that fair to say?
I think we filed on April 1, 2022. That's right.
Okay. I just want to ask a couple of questions about that study and that process. Would you agree with me, subject to check, that the comprehensive rate design study involved 18 sessions held across 4 working groups?
We had 4 working groups. We had a lot of sessions. I would say 18 probably understates. We had a lot of breakout groups and discussions with interested stakeholders on a variety of topics. It was a very engaged crowd and a very engaging 12-month exercise.
And in fact, there were 300 individuals who were part of that process in some form or fashion. Is that right?
I remember 50 organizations. I don't remember the number of individuals, but it was a large number.
Okay. And so you said 18 sessions, you would agree, subject to check, for the 4 working groups, but there were also 22 subgroup discussions. Is that consistent with your recollection?
That's what I was saying. We had a lot of meetings over that 12-month period, correct?
Okay. How does that process, which spanned a year and involved many different organizations outside of just the parties to a rate case, how does that compare to what has led up to the potential adoption of a large load tariff in these rate cases?
You're asking about the difference in process. So
Correct.
in this rate case, in my direct testimony, I did not file a large load tariff. And then public staff proposed a large load tariff in their testimony. And in response to that and a host of comments from other parties, the company and our witness beverage and we filed rebuttal testimony that included a large load tariff.
Okay, so as we sit here today, have there been any stakeholder discussions, working group discussions, subgroup discussions, or any of the other things that culminated in the comprehensive rate design report filed with the commission? Have any of those other things happened here?
I would say that the company's proposal in our rebuttal testimony is a very thoughtful extension of what we've been doing. It reflects conversations that we've had with different parties and so forth throughout the last 3 years, and also observing just how the market is changing. But it is not the product of that same 12-month stakeholder process that you're referring to that resulted in time of use period changes, the high load factor rate, and so forth.
Thank you. Turning to you, Mr. Beveridge, you had a discussion with Commissioner Tucker about some of the different factors that are driving the need for investment in new natural gas plants. Do you recall that discussion?
I do.
Okay. Would you agree, subject to check, that the commission's last carbon plan order specifically found that the near-term action plan, natural gas capacity resources, were needed due to compliance with the carbon plan statute?
I couldn't speak to that order specifically. subject to check, that sounds reasonable, but I couldn't speak to that order.
Thank you. And then, Mr. Byrd, you were having a conversation with Commissioner Vandervaart regarding retrospective data and whether that is useful and to what extent it might be useful in either developing a new rate class or a new rate tariff. Do you recall that discussion?
I do.
Okay. Mr. Byrd, were you in the room or were you watching online when Witness Hager testified that if you were to pull data center load out of its current rate class, the only class that it would impact is the class that that load was leaving? Did you hear that testimony?
I did.
Okay. And is the reason for that because the risk as we sit here today is a risk of potential intra-class cross-subsidization rather than inter-class cross-subsidization?
I think yes, but let me explain why that is. So if you have, for lack of a better word, these very large customers in the large general service class, and the thought is, well, let's separate those. What you're saying is that within that today, large general service class, there is some amount of intra-class subsidization going on. So when I form a new, very large load class and separate it out, the cost of service is going to drive different revenue requirements to those two classes. What's unaffected is, as Witness Hager described, the residential class. And so I think in response to the way you're asking it is dealing with a potential intra-class issue that may exist within the LGS class today as it is currently comprised.
Thank you. No further questions.
Any further questions on commissioner questions? Please identify yourself for purposes of the record.
I apologize. I don't have my nameplate. Carrie Grunman on behalf of Walmart. Gentlemen, just for clarity of the record, Commissioner Vandervaart asked you some questions again about Dominion GS5 and the creation of that tariff versus the rate design. Do you guys have some familiarity with that proceeding that developed GS5?
Generally, recall the large load informational docket that happened last year. Dominion presented that, and I participated in that proceeding, and I heard their testimony with respect to what they were doing in Virginia.
Okay, so you're aware that in Dominion's last rate case in Virginia, the commission approved a GS5 tariff, correct?
I am aware of that. I believe it has not been effective yet. I'm aware of that generally, yes.
Okay, so we'll try to go through this one at a time. You agree with me that that tariff goes into effect on 1/1/27?
That is my understanding.
And so what that means is that going into the company's next rate case, assuming it occurs some appreciable time after 1/1/27, Dominion would be able to conduct a cost of service study based upon the customers then in GS5.
Yes.
Those are all my questions.
Yes, Mr. Felling.
Thank you, Presiding Commissioner. Tom Felling with the Public Staff. Gentlemen, I think the questions that I've got are going to be in response to Commissioner McKissick's question, generally asking you about perceived differences in perception on the process for ESAs, sort of the evolution of ESAs, and perceptions between the public staff and Duke. Do you recall sort of generally that question from Commissioner McKissick?
I do recall that, yeah.
Okay. So I've got a few questions to maybe sort of expand on that point. At a starting point, would you agree with me that there's a distinction between an ESA, like an executed ESA, versus the form ESA application that Duke has continued to work on throughout the course of this process?
An executed ESA is a signed contract. And when I hear you say form ESA, that just means a standard contract that is not executed by a particular party. It's just, these are the terms and conditions under which we would execute with a load.
Fair. And would you agree essentially an ESA or an executed ESA is the bargain for agreement that happens between the customer and the company that contains numerous commercial terms that have been agreed to by the parties, versus the Form ESA application, which is sort of the blank form that's used as the starting point for arriving at an executed ESA?
I think that kind of gets to the difference of the characterization that there's this, you know, broad change throughout a particular ESA on particular issues. So, and I think witness beverage says there's small terms and conditions, like you're a commercial attorney working with another party, a commercial attorney. There's things that have to be, you know, addressed with respect to that contract, right? And these are very large, very unique customers. But when I was speaking about the termination, damages, credit, minimum contract term, all that, the minimum billing demand, so forth, those were in and later, the refundable advance, curtailment, the accelerated ESA provision, those were required standard terms that the company would use consistently after those were put into place. So that was my experience through the evolution of those over several years.
And I think that's, I think I'm trying to start at a more simple point. So I'm apologies if my question was not more tailored. I think the point I'm trying to make, and let me know if you agree with this, is that the Form ESA application is a form, right? That there's blanks that'll be filled in by the parties in Duke as they negotiate this agreement. But it exists as a form, as a starting place. But the ESA itself is an executed contract that's the result of bargain for exchanges between the company and the customer. Is that a fair characterization of the difference between the two?
Yeah, and again, I'm not an attorney, not a commercial attorney. I'm not on the deal team that's working on those. So I'm giving you, I was working on the performance provisions, the design of the things that we've been talking about predominantly, not the T's and C's in that contract. But you're asking me about the difference between an executed contract and a form that you might hand to somebody to negotiate. Generally, one is signed, one is not signed.
And one has terms that are filled in and one doesn't, right?
Sure, like the load ramp and so forth. So we would have a blank there, and you would have blanks in other places because it has to reflect the customer's requested demand, time frame for that demand, and then all the necessary provisions around that.
Okay, I thank you for that. So, and Mr. Byrd, I think you referenced some meetings early on with the public staff to review documents in your response, and those would be the Form ESA application and the form letter agreement. Is that correct?
I believe that's right. It would also, we had discussions just around the risks that were trying to be addressed with those. So yeah, that's fair.
Okay. And in those meetings that you referenced with numerous meetings with members of the public staff, do you recall that there was some analysis that Mr. Metz asked to be performed? And do you know, if you recall that, whether that was ever completed and provided to him?
Can you be more specific about the analysis?
I don't want to get into more details than that. So if you don't recall the specific analysis that he's requested, that's fine, and I can move on. I'm just
so I recall one thing that Mr. Metz discussed with me, and it was about modeling for a class. And I think that's the challenge that we've been talking about here. He wanted to see what that would look like, and I've had discussions with him subsequent to that request. I don't know how to do that without the data. And if I were to price a tariff for a 500 megawatt high load factor customer, it's going to look like HLF right now, because that's the information that we have to go on. And so that was the response that I recall giving.
All right. And so I want to move on. If one were to look at the ESAs that were filed in response to the Commission's directive to file executed ESAs in the sub 208A docket, if one was to analyze the date of execution of those ESAs sort of from earliest to latest, it's fair to say that some of those ESAs were executed before these meetings with the public staff to discuss these Form ESA application and form letter agreement. It's true those predated those meetings. Is that correct?
I do not know.
Okay. Is it fair to say, though, that Duke started signing large load customers using ESAs and LAs before these meetings with the public staff occurred that you referenced?
So the first presentation that I recall meeting with public staff, the term used was mega load. So I just want to, all this has been evolving over time. So when you ask me, did you sign a contract with a large load? This was not a defined thing. We were operating with a recognition that customers were asking for more load, and there were costs involved with that were different than anything we had seen prior to that. And based on my interactions with the economic development team, we were being responsive to that, and we were having active conversations that were constructive conversations with public staff on the appropriate responses to those requests.
Is it whether we use the term mega load or large load, but in terms of the scope of, the economic development customers and the types of those customers that we're seeing, it's fair to say that Duke began signing ESAs and LAs with those types of customers before meetings with the public staff to discuss these forms that I've referenced.
I don't have a history of those executed contracts. I know the companies used ESAs for years for customers. So,
okay. Has the company ever come in prior to executing an ESA with a large load customer to sort of preview what that specific agreement would look like with that customer before it being signed?
I don't know.
Are you aware that in discovery in the CPRP, the public staff asked for copies of executed ESA agreements, and the company objected to providing those, and those were later provided only after those filings were made in the sub 208A docket?
I'm not familiar.
We accept that subject to check.
I can't speak to it. I'm not familiar with.
Okay. In terms of, I think there was some discussion about the evolution process that you've talked about, as the companies responded to this ever evolving process and sort of evolving the forms to sort of reflect current best practices or current best safeguards. Isn't it fair to say that the ESAs that were filed in that sub 208A docket contain terms that the public staff might see as materially different in terms of what is or isn't contained in those executed ESAs, such as whether or not curtailability is a sort of commercial term in those ESAs?
Are you asking about what we understand the public staff's position to be?
Let me start over. I think I didn't do the best job there. I think I understood your testimony to be that the sub 208A ESAs that have been filed all sort of contain consistent and similar commercial terms. Did I understand that testimony correctly?
No, I don't think that's what we were saying. We talked about there were ESAs from North Carolina, from South Carolina, DEC, DEP, and they happened at different points over time. And so before 2024, you didn't have those performance and credit provisions in place. 2024 to 2025, we had an initial set. Then at 2025, we added some more. So what we were saying is all the key provisions that we're talking about, all the major terms, were consistently applied based on the point in time that they were signed.
Okay. I guess, and on that point, curtailability and whether or not that is a commercial term reflected in that ESA is something that's also evolved over time. Is that fair to say?
That's right.
Do you know whether Duke and the public staff met to discuss changes to the Form ESA application each time that application was changed by the companies?
I don't have enough information to answer that question.
And I guess just to your knowledge, prior to the sub 208A agreements being filed and provided to the public staff, to your knowledge, were any other executed ESAs provided to the public staff before that point in time?
I do not know.
I was curious, in the CPRP proceeding, let me actually ask this question another way. Do you know when the first time it was that the public staff was made aware of the existence of a red team that was sort of discussed, I think, in the DEC proceeding?
I do not know.
Okay. And so if the public staff did not discuss the existence or elicit testimony from company witnesses on the red team in the CPRP proceeding? Is it possible that was because the public staff was not aware of the existence of that red team?
I have no knowledge of that. And let me be specific. I don't know what communication was made with public staff regarding the red team. So that's to be specific.
Well, I guess just as a final question, is it fair to say that? Well, actually, I'm going to confer with my colleague. I'm actually not going to ask the question, make sure I've got everything I know. I think those are all my questions, Presiding Commissioner. Thank you.
Okay, very good. Let me thank you for your
Presiding
test-
Commissioner McKissick,
Yes,
may I
go right ahead.
be as brief as I can here? Just a few questions.
Not a problem.
Thank you. Mr. Byrd, Mr. Beveridge, I don't want to spend much more time on this topic that Council for Public Staff has been asking. And you were asked a lot of questions that seem to ask you to read public staff's mind. I'm not going to ask you questions in that vein, but I do want to ask to go back to the engagement you described in late 2023. What was your intent in that engagement? What did you believe you were having a discussion with public staff about at that time period?
So in my work with the economic development team, we were seeing requests for larger loads that were more expensive to connect than anything that was historic. When we looked historic, it was, 10 megawatt, 30 megawatts, and all of a sudden we were getting 100 megawatts, 300 megawatts, and we needed to have a response to that in terms of contracts or tariffs. And so we worked with a number of subject matter experts across the company to think through some ways to approach that, the risk and the uniqueness of those large loads. And then we described those requests to public staff and proposed the modification to the service regulations to address that risk. So I thought it was constructive conversations that we had, and it's why the public staff brought that to the commission in January 2024 in a staff conference, and those were just approved with little discussion. I think it was apparent to everyone that we needed those enhanced performance provisions, and I think we were successful in getting that very early on, which was really good protection for customers.
And when you say it was clear to everyone that those enhancements were needed for large load customers, why was that apparent to you and to other parties at the time? You already spoke to it, but just talk a little more about what was happening in the company's queue that would tell you it was necessary to make those changes.
So we were getting a lot of requests, and those requests were very large. And when you think about adding in, as Witness Beverages talked about as well, adding in these large requests, 300, 500 megawatts into the resource plan, it's a single load that's that large. And so that requires, I think it's just obvious to have some incremental performance provisions and to hold those customers accountable for the request that they're making. If I have a 5 megawatt or a 10 megawatt customer making a request, we certainly we have protections in our service regulations to address their connection and all that. But when I back up to IRP space, a 5 megawatt or a 10 megawatt swing is in that kind of econometric model, and it's in the noise. We have customers ramping up, ramping out all the time, but a single 300, 500 megawatt request, I think it's just on its face, it needs special attention and thoughtfulness to address in the contract.
And so to roll the tape forward, the fact that we are seeing these large load customers execute contracts in 2026 is not a surprise to you, correct? Because Duke Energy, you saw that coming in 2023, correct?
We did, and they were making those requests for interconnection studies and so forth, yes.
Okay. And so one of the things that you described that Duke Energy did to prepare for this was the service regulation changes, correct?
Yes.
And then you had a discussion with Commissioner McKissick about the fact that the ESA agreement then over time was progressively improved with more protections for customers, correct?
That's right.
And there was discussion about whether it's a blank form or a template agreement, in various ways it was characterized in your exchange with Mr. Felling. the core customer protections that were added over time, were those, are those blank in the template, or are they, the core customer protections are in the template and rolled forward in executed versions, correct?
So generally, yes. What would be blank in the form would be like there's a table for termination damages. And we had a standard process to calculate those. It requires the customer providing us a load ramp and their ultimate contract demand in order to calculate what those termination damages were going to be. So that was necessarily a blank that we would fill out, working with economic development team or the large account management team. We had a standard tool that we used to develop those specific tables that were unique to the contracts.
Okay. But you described that over time, the company added additional customer protections into that ESA as it learned from lessons learned in dealing with customers, correct?
Correct. Like refundable advance, curtailment provisions, yes.
And those were one-way ratchets that increased the protections for customers.
That's a good way of describing it, yes.
All right. And was one of the benefits of that ESA approach that the company could act quickly to make necessary changes?
Absolutely.
And at this time, the company now has proposed a large load tariff in this docket, correct?
We have.
And that tariff memorializes many of these customer protections, correct?
Correct.
And the company's more than willing to accept those being formalized in the tariff at this time.
Yes, and I would say that we've had several years of using these, and there's some stability there with those. So we've put them in this tariff that we filed in our rebuttal testimony, correct?
Okay. And then very briefly, Commissioner Tucker asked you questions about the agreements that have been signed, sealed, and delivered. It's a great song reference. Do you recall that line of question?
Yes.
And when a contract has been signed, sealed, and delivered, when these customers sign their name on these ESAs, what is it about that step that gives the company the confidence that these projects are serious about receiving service in the state of North Carolina?
That is what triggers the financial obligations of the minimum billing demands, the termination fees, all these type of protections that we're talking about are included in the ESA. It's that, signing of it.
And so those customers are taking on enormous financial commitments through those contracts, correct?
Yes, absolutely.
And are you familiar with the company's LAM, large account management team? And is it your understanding that they stay connected with these customers after they sign the ESA and continually monitor their progress through the construction cycle?
Yes, very much so.
And is that one of the factors that that the company takes into account as it assesses its load forecast over time, is how these customers are moving forward?
It does. I think our large account management team probably works closer with our load forecasting team than they ever have in the past to really monitor all of these projects and make sure we're putting in the best information, the latest into these load forecasts for our research plan.
And so when you combine the contractual protections in the ESA plus the real-time feedback the company's getting on how these projects are progressing, that's the cycle in the resource planning process that allows the company to be confident it's not overbuilding the system, correct?
That's right.
And finally, with all of this suite of protections currently in the ESAs, is it your opinion that these large load customers can be served in a way that benefits all customers, including protecting customers from scenarios where these customers don't show up or show up and use less energy? Is it your view that the company's processes and contractual protections have provided a system in which all the customers can benefit from large load customers over time?
Yes.
Yes. Yeah.
Thank you. No further questions.
Okay, well, I think you're ready to be released at this time. Of course, I appreciate the reference to signed, sealed, and delivered. I remind you the artist was blind, and we don't want to be vision impaired moving into this episode in dealing with large load growth and tariffs. On that note, we're going to go ahead.
He also had a song called Sir Duke, if I'm not mistaken, as well. So I'm not sure what we make of that.
We could go on for a long time with this. But we're going to go ahead and take a 5-minute break. We're going to come back for the final panel of this particular case in this particular hearing. Thank you.
Thank you.
seats. If somebody could close the hearing room doors. How are you both this afternoon?
Doing good, thank you.
You have the distinction and honor of being part of our last panel. And that may move things along more quickly, yet to be determined. If you would, go ahead and put your left hand on the Bible, raise your right hand. You solemnly swear the testimony you're about to provide in this hearing today will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you.
Thank you very much. Good afternoon. Ms. Bateman, we'll start with you. Can you please state your name and business address for the record?
Yes. My name is Laura A. Bateman, and my business address is 411 Fayetteville Street, Raleigh, North Carolina.
And by whom are you employed and in what capacity?
I'm employed by Duke Energy Carolinas as Vice President of Carolinas Rates and Regulatory Strategy.
Thank you. Ms. Farmer, can you please state your name and business address for the record?
Yes, my name is Renee Farmer and my business address is 525 South Tryon Street, Charlotte, North Carolina, 28202.
Thank you. And by whom are you employed and in what capacity?
At the time of the filing, I was employed by Duke Energy Carolinas as Rates and Regulatory Strategy Director. Currently, I am employed by Duke Energy Florida as Rates and Regulatory Strategy Director, but I am still supporting DEP in this proceeding.
Thank you. Ms. Bateman, I'm going to turn back to you to, on behalf of the panel, now introduce the PBR policy panel direct rebuttal and settlement testimony, and we'll do this as quickly as we can here. Ms. Bateman, on November 20th, 2025, did you and Ms. Farmer, on behalf of this panel, cause to be pre-filed in the docket testimony consisting of 53 pages and 4 exhibits marked as PBR policy panel direct exhibits 1 through 4, with PBR policy exhibit 1 being corrected on July 31st?
Yes.
2026. Beat me to it. Ms. Bateman, does the panel have any corrections you'd make to that direct testimony?
No.
If I were to ask you the same questions today, would your answers be the same?
Yes.
And just to confirm, the panel's direct testimony did not include any confidential information, correct?
Correct.
And did you also cause to be pre-filed a summary of that direct testimony
Yes.
on August 7th, 2026?
Yes.
We'll move all the testimony at the end if that's okay with you, presiding.
That'll be
Commissioner.
fine.
Ms. Bateman, on July 24th, turning to your rebuttal testimony, on July 24th, 2026, did you cause, along with Ms. Farmer, cause to be pre-filed in this docket a rebuttal testimony consisting of 86 pages and 3 exhibits marked PBR policy panel rebuttal exhibits 1 through 3?
Yes.
And do you have any corrections you need to make to that pre-filed rebuttal testimony or the exhibits?
No.
If I were to ask you the same questions today, would your answers be the same?
Yes.
And again, you did not have any confidential information in that rebuttal testimony, correct?
Correct.
And did you cause to be filed a summary of your rebuttal testimony for the commission on August 7th, 2026?
Yes.
Turning to your stipulation testimony, on August 6th, 2026, did you and Ms. Farmer cause to be filed in this docket settlement testimony consisting of 19 pages and 4 exhibits marked PBR policy panel settlement exhibits 1 through 4, with PBR policy panel corrected settlement exhibit 2 being corrected on August 10th, 2026?
Yes.
Does the panel have any corrections to make to its pre-filed settlement testimony or the accompanying exhibits?
No, we do not.
If I were to ask you those same questions today, would your answers be the same?
Yes.
And again, no confidential information, the settlement testimony, correct?
Correct.
And did you cause to be filed a summary of your settlement testimony for the commission on August 7th, 2026?
Yes.
Commissioner, with that, at this time, we would move into the record the PBR policy panel direct rebuttal and settlement testimony along with all accompanying exhibits.
Without objection, your motion's allowed.
And I apologize to court reporter for speaking so quickly. We appreciate you being able to keep up with us. Turning very briefly now to the stipulations and settlements filed in this proceeding. We're going to go through the settlements, make sure you're aware of all of them, and then we'll ask that, to confirm that you support all those settlements. So have you reviewed the agreement and stipulation of partial settlement, which was filed on October 24th, 2025, the cost of service settlement?
Yes.
Have you also reviewed the third amended comprehensive revenue requirement agreement and stipulation of settlement filed on August 12th, 2026 in this docket?
Yes.
Have you also reviewed the agreement and stipulation that the PIM settlement between the company and public staff, which was filed on August 5th, 2026?
Yes.
And NCSC, I apologize. The NCSA
Yes.
was also part of the PIM settlement. In your opinion, are those stipulations in the public interest, and should the commission adopt them in their entirety?
Yes, I think they represent a reasonable compromise and a result of give and take between the company and the stipulating parties.
Thank you. And turning to you, Ms. Farmer, have you also reviewed that third amended comprehensive revenue requirement agreement and settlement of stipulation filed on August 12, 2026 in this docket?
Yes,
And have you also reviewed the PIM settlement, which was filed on August 5th, 2026?
yes,
And in your opinion, are those stipulations in the public interest?
yes, I support the stipulations as negotiated compromises, reflecting give and take between the company and the stipulating parties.
Thank you very much. Commissioner McKissick, at this time, the PBR policy panel is available for cross-examination and commissioner questions.
Okay, very good. Looks like the first in the queue is the Attorney General's office. All right, ADS. All right, we'll move on down to Microsoft.
No questions.
North Carolina Justice Center et al. I'm missing someone here. Go ahead.
Yes, presiding Commissioner McKissick. I do have some questions for this panel, if I may
Okay.
proceed. Good afternoon, Hannah Klaus for NCJC et al. Starting with your direct pre-file testimony, now entered into the record. At the time you filed that direct testimony, DP proposed a total PIMS financial incentive structure with a maximum of 5.4 million in upside and downside potential. Is that correct?
5.4 and what did you say was the?
5.4 million in upside and downside potential per rate year.
Yes,
Is that correct?
That's correct.
And you note in your direct testimony that in PBR 1, DP had approximately 10.25 million in potential upside and downside per rate year for its PIMS portfolio.
Can you repeat that?
In PBR 1, you note in your direct testimony that in PBR 1, DP had approximately 10.25 million in upside potential and 10.25 million in downside potential in its PIMS portfolio. Is that correct?
Thereabouts, yes.
Okay. And so the difference between DP's proposed PIMS portfolio at the time you filed your panel's direct testimony as between PBR 1 and PBR 2 is about 4.85 million. That's a $4.85 million decrease in the potential rewards and penalties.
Yes, and as we stated in the testimony, we explained that our decreases were to reflect a reasonable and realistic approach and still continue our measured approach to setting more realistic caps in our PBR2 filings.
And you're aware that the statutory cap for PIM incentives and penalties is 1% of the total traditional annual revenue requirement?
Yes, I'm aware of that.
And so at the time your panel filed its direct testimony, given that the proposed total revenue requirement was 5.2 billion, the potential total PIMS portfolio could have been 52 million. Is that correct?
Yes, but I will state that the commission was in favor of our measured and balanced and careful approach to our PBR1 filing. And they were in favor of that. And I believe we had spoken before about how we needed to kind of walk before we run. So this was all new and we wanted to, take a measured approach for our first time out with this.
If I can have you turn to the NCJC potential cross exhibit binder, which I think is on the far corner of the table there, to potential cross exhibit 4. And this is the performance-based regulation study group work products that are a product of the NERC process that have been discussed today. Is that correct?
Yes.
Presiding Commissioner McKissick, at this time, I would like to mark this exhibit as NCJC et al. Cross-performance based regulation policy panel, Bateman Farmer direct rebuttal settlement, Exhibit 1, please.
Duly marked and identified for purposes of the record.
Thank you. Ms. Bateman, the 2020 North Carolina energy regulatory process was a stakeholder process to look at performance-based rate making and other potential utility regulatory reforms, including PIMS, correct?
Correct.
And you were one of the NERP co-leads?
Correct.
And at the conclusion of that process, stakeholder process, there was a report release, which is the one before you, correct?
Correct.
Can I please have you turn to page 20 of the section that has a subtitle PBR regulatory guidance? And this is page 24 of the PDF overall.
Yes.
And here, there's a section on PIMS principles recommended by the stakeholder group that you were the co-leader of. One of the principles in bullet point 3 states that PIM should collectively comprise a financially meaningful portion of the utility's earning opportunities. Is that correct?
That is correct. I would like to add some context, and I think Ms. Farmer alluded to this, that we're in our second round of our second PBR that we've applied for. And so what was discussed in the NERP process is that, yes, it should be the PIM should be meaningful. And I think what we've proposed and what's part of the settlement is meaningful. It's a meaningful amount. But they're also part of the NERP guidance and principles that we discussed were the same thing that Ms. Farmer stated about walking before we run, starting slow, establishing. In fact, when we looked at other utilities, a lot of them just established tracking metrics and looked at those for several years before adding any rewards or penalties into their PIMs. So I think we're very consistent with the NERP guidelines here, or the NERP principles and what we've proposed. And I do think, and especially in the settlement, I think the settlement does provide meaningful rewards and penalties in the PIMs that were negotiated and are part of that settlement.
Turning to your settlement testimony now, if I can have you direct your attention to page 6 of that testimony, beginning on line 18. There you describe the proposed MYRP refund rider. Just let me know when you're ready.
Yes.
And do you have the comprehensive settlement agreement and Exhibit 1 to that agreement available to you?
Yes.
Looking at page 2 of the first exhibit to the settlement, which is page 37 of the comprehensive settlement overall, describes the MYRP refund rider as a part of the comprehensive settlement. Would you agree that for the purposes of calculating refund riders, the project completion ratio only considers whether a MYRP spending project is completed within a given year?
I'm sorry, what section are you referring to?
This is page 2 of Exhibit 1, describing the calculation of the project completion ratio.
So there's two ratios that go into the formula. For the project completion one, you're correct. It does only look at whether the number of projects that were completed in rate year one in terms of the projects that were completed. But there's another ratio that also goes into the calculation that looks at the revenue requirement that's completed. And that does look at the month that the project went in service and is impacted by that. So it's a composite. It looks at both, whether or not the projects were completed in the right year, and then also when they were completed and what the cost of those projects were.
Okay, and going back to page 2 of that same exhibit, do you see the language under the conclusion heading, providing that the rider does not return every dollar to ratepayers for uncompleted projects?
Yes, and so I think this is a settlement mechanism, and the company explained in its rebuttal testimony, and I think the public staff agreed with this, the need for flexibility. And so I'll give an example, like if there's an MYRP project, and our MYRP projects are defined at a very detailed level. So project, task, location level. So let's say we have 5 units, and we think we're going to have to replace units 1 and 2, a specific part. And this is 2 or 3 years in advance. Let's say we get into it, we do inspections, and we realize, well, you actually have to replace that part on units 3 and 4, but units 1 and 2, you don't. And so you replace units 3 and 4. You're going to do the right thing, but you didn't complete those units 1 and 2. You didn't complete that specific task location that was originally projected 2 or 3 years earlier. The utility has to have that flexibility, and we will always do what's right for customers and use that judgment. And so I think this takes that into consideration. I think where the public staff's concerns was that the magnitude of the deviations in MYRP1. And so I think this mechanism addresses that concern and provides for flexibility. I will state it always provides for a refund if there's a delay or a project is not completed, even if it's outside of the utility's control. So there's no thresholds, there's no substitutions. So there's always a refund, but it also acknowledges, and I think it put here, that it's not designed to be punitive. And it does recognize that the utility is going to have situations where it needs to exercise that flexibility in order to do what's in the best interest of customers.
Turning now to the PIM settlement, I'll give you a moment to turn to that. With regard to the time of use PIM, which is addressed on page 3 and 4 of that settlement, would DEP receive a $10 per customer incentive for rate year 1 for each rooftop solar customer required to take service under the TOU rate?
Yes. And so new enrollments, the TOU PIM is the structure is any new enrollments for rate year 1 would receive $10. The reward would be $10 per new customer enrollment. And then in rate year 2, it would be the same, in addition to any newly or any retained from rate year 1 would also earn a reward of $10 per customer.
Turning to the reliability PIM, in the PIM settlement, the parties agreed to a maximum penalty of $6 million per rate year and a maximum reward of $1.2 million per rate year, correct?
Yes, that's correct. And this PIM again, was a product of negotiations between and agreements between public staff, the stipulating parties, and the company. It's a little different, structured a little differently. There is a midpoint of I think 140 minutes. There is a dead band where no penalty or reward is given, and then there's the rewards and the penalties are based on. The reward is 120,000 for each minute below 133 minutes. And then the penalties start at 148 and is 120,000 for each minute above 147. And then anything below or above that would be a penalty, would increase based on the table of 600,000 per minute. And this reliability PIM, we feel holds Duke accountable for reliability performance, and it maintains and improves system reliability and supports the policy goals.
Returning to the PBR regulatory guidance, as identified as the NCJC cross exhibit 1. On page 28, there's a section with recommendations for reliability PIMs. Just let me know when you're there.
Yes.
And so within the table captioned outcome reliability, do you see the language providing that reliability PIM should be downside only?
I think that's just one of the metrics that was proposed here. There's a preferred metric, there's alternative metrics, and then some notes. And so I don't think it was across the board. This should only be downside only. I think that was just one option that was provided.
But an option for upside was not something that upside incentive was not something that the stakeholder group chose to include in the recommendation for this outcome.
I don't think that's true. I mean, the alternative metrics listed don't state whether they're upside, downside, or symmetrical.
And do you see the additional language within the same table providing that rewards for further improvement towards the outcome of reliability may not provide a net benefit to customers because of diminishing returns?
Yeah, I think that's in a situation where you might be in that, a utility might be in that situation, but I don't think we're in that situation. I think improvements to our reliability, the investments that we're making to improve reliability are valuable to our customers, and I don't think we're at a point of diminishing returns. Especially I think about the Carolinas and the extreme weather that we have and the certain periods of time where it's very important to keep the power on to our customers. And so I just don't think that we're at a point of diminishing returns in terms of reliability.
No further questions. Thank you. Presiding Commissioner McKissick, at this time, I would move NCJC et al. Cross performance-based regulation policy panel Bateman Farmer direct rebuttal settlement exhibit 1 into the record, please.
Without objection, your motion is allowed.
Thank you.
And any redirect?
No redirect.
All right, we're going to move on to commissioner questions. We do have a few questions from our commission staff, and there may be other questions from commissioners. Ms. Bateman, one of the commissioner's questions to witness Giggets was deferred to you and will be asked now. I'm looking at paragraph 61 of the comprehensive settlement at page 22. You might want to get there. Paragraph 61 on page 22.
Yes, I'm there.
All right. Now, this paragraph describes a potential rate case stay out condition on deferring costs at a full weighted average cost of capital for the Person County combined cycle, Unit 1, and the Marshall combustion turbines. Paragraph 61 names Unit 1 only. The CWIP adjustment in paragraph 7 reaches both Unit 1 and Unit 2 as reflected on Schedule NC 3050-1. Is the omission of Unit 2 from paragraph 61 intentional?
Yes. And so when we think about a potential 1-year stay out, so absent a stay out, this MYRP would end at the end of 2028. So rates effective 1/1/29. If you think about the in-service date for Person County CC1 and the Marshall combustion turbines, that is also 1/1/29 for those units. For Unit 2, the expected in-service date is not until 1/1/2030. And so even if we were to stay out for that additional year, you would still have rates effective 1/1/30, which would coincide with the expected in-service date of Person County CC2. So
Thank
it
you.
was intentional.
I think that provides clarity. Thank you. Now, in the comprehensive stipulation, the parties agreed to remove the interconnection cost of large load customer B and C while retaining the interconnection cost of customer A. Without revealing the identities of these customers or any other confidential information, can you describe what difference between these customer interconnection costs and their associated benefits that led to B and C being removed and A being retained?
Yes. So, and this was similar to the approach that we took in the DEC settlement. For customer A, both the revenue and the plant was included in the case. So you had revenue from the customer and then plant for their facilities such that there was a net benefit. And so what we did in settlement was take that net benefit and allocate it to all customer classes so that all customer classes can benefit from that net benefit. For customers B and C, we had the plant numbers, but either not the revenue or the load reflected in the allocation factors, such that you weren't seeing the benefit. We hadn't captured the benefit of those customers in these cases yet. So we still believe there will be a benefit and it will be reflected in the next case, which is why there's a provision that in the next case, we have the opportunity to request the depreciated value of those plants when we can show that we have the benefits and the costs, netted in the case such that it provides a benefit.
Thank you. Now, Ms. Bateman, we have some questions on the PTC rider. Walk us through DEP's proposed PTC rider as mentioned in witness Sykes' direct testimony.
Yes, so it is very similar in the last DEC case, so not the current pending one, but the one previously, we reached an agreement to establish a nuclear PTC rider. And that rider was established for DEC. It had a fixed amount for the first 2 years, which were 25 and 26. And then starting in 27, so later this fall, we'll file a rider that starts the formulaic portion of the rider, where you take the PTCs that have been earned and monetized as of a certain date in 2026. We'll file those amounts, and it takes that balance minus any cost, net cost to achieve or incremental cost to achieve. And I can talk about that. Any amounts that have been previously flowed back through the rider, and it takes that balance, divides it by 4, and it flows it back over a 4-year amortization period with a weighted average cost of capital levelized return. And so that rider was established for DEC. In the pending DEC proceeding, we proposed to remove the nuclear piece and make it for all PTCs in that rider. And so that's our proposal in the DEC case. And for all of the riders in both of these cases, we've been trying to align the two utilities because we look forward to the future when they will be one utility. So in the DEP case, we have proposed a PTC rider that mirrors what's approved or requested for DEC. And for the first 2 years, we initially proposed a fixed amount of 40 million for 27 and 28. And then starting in 29, that same formula would kick in where you have the amounts that have been earned and monetized, minus the cost to achieve and the amounts that have already been flowed back through the rider. And then you start that tranche, that first tranche for 2029, it would be over a 4-year period with a levelized return at the weighted average cost of capital. So that's what we proposed. And then in settlement, we increased those $40 million amounts to $120 million in 27 and 28. And I think Witness Metz explained it as just a balance of, we're looking at near-term affordability and long-term affordability. And so it's just a balance of how much you flow back now versus how much is available to flow back in the future. For the incremental costs, I did want to note, because there were some questions about prevailing wage. And so in our initial application, so for incremental costs, I think Witness Sykes broke them out into 3 different categories: execution costs, and then there was prevailing wage costs for related to outages, and then the non-outage portion of it. So in order to maximize these production tax credits, the guidelines require us to pay prevailing wages, not just to our employees, but also for all of the contract companies that we use, for them to pay prevailing wages to their employees. And so in order to meet that criteria, our cost increased for our contractors. And so we had incremental costs that were not included in customer rates that were needed to optimize the tax credits that customers could receive. And it's a significant benefit compared to the costs that you would incur. And so for the outage related prevailing wages in our initial application, we included those costs in the rates that we were proposing. So once they're included in rates, they're no longer incremental. You no longer need to defer them. And so that's why for outage related costs, we were already planning to stop the deferral of those costs effective 1/1/27 once those costs were included in customer rates. As part of the settlement, we also agreed to take the non-outage prevailing wage costs and add them into this case. So those will also be reflected in customer rates effective 1/1/27. So now any prevailing wage costs for outage or non-outage related after 1/1/27, those costs won't be incremental because they'll be included in customer rates. And so there'll be no need to defer those costs going forward. We'll still have the previously incurred prevailing wage costs that are in that netted in that regulatory liability and will affect future rider amounts, but we won't defer those costs going forward. And then we'll still have the execution costs that Witness Sykes described that are not included in customer rates to the extent that they are incremental and they're needed to either achieve or optimize the credits. We'll still have those costs that will get deferred and netted in the regulatory liability.
Your very comprehensive response addressed several other questions.
Okay.
So we're going to skip those. Now, Ms. Bateman, these next questions are intended for your reflection and not to elicit any particular piece of information. You've heard the discussions on cost of service studies, rate design, separate rate classes, SEAC, ESAs, provisions during the course of this hearing this week. What additional perspective would you want to share with the commission about why this cost disaggregation with data centers is so challenging and so seemingly difficult to parse out?
Yes. So I think a few witnesses have addressed this. One thing I will say in the cost of service study, I think Witness Hager spoke to just how complicated it is and how long it takes to produce a cost of service study. And then the additional, to the extent that we don't have load research data, to get that load research data and those load profiles to develop allocation factors to allocate costs. So there's a lot in terms of the process. But I would also say for Duke Energy Progress, I don't believe there's any existing data centers on the system. And so we use a historic test period for cost of service. So you could create a column in the cost of service study, but if there's no revenue in the, depending on how you define that class, if there's no revenue from customers in that class and there's no load that would develop, that you would use to develop those allocation factors, so you would have zero allocated costs. So I think it would just be a blank column if you don't have that historic data. So I think it's two things: the time involved to develop that class and gather the historic data when you have it. And then I think for DEP, and again, depending on how you define it, if you have no customers in that class, you just have a blank column on your cost of service. And so, there's nothing to put in there if there's no revenue and there's no load to use to develop allocation factors to allocate costs. The other thing that I would just say that I think you have to be very careful in how you define that class in terms of getting the customers that you intend to be in that class. And so I think about, we've heard very large load and we've heard load factors, and we have industrial customers, we have data centers. Well, we expect to have data centers in the future at DEP. And then we also have the military bases. And so you could have a very large, like Fort Bragg is going to be large, but it's going to have a different load profile than a data center. And so I think there should be thought and intention into how that class is defined.
And a couple of follow-ups. Are there any solutions offered by the other interveners that you find to be particularly problematic or unworkable?
Yes. So I was very anxious listening to some of the interveners. To the public staff's large load panel, I heard several times like Duke will need to figure that out, or Duke will need to work that out, or Duke will need to use their discretion. That's a little overwhelming to just the extent of things that would need to be figured out or worked through without any guidance. So I would say that clear guidance is something that's important. I get very nervous about incremental costs for generation and transmission, because how do you define what generation is being driven by that large load customer versus the growth that we have in the residential class? And there's some other utilities that have very little growth other than new data centers that are moving into their service territory. That's not true here. We have growth in residential and other general service classes. So it's very hard to determine what is growth for this customer versus that customer. What plant are you adding for this customer versus the growth in this other area? I get nervous about, and we'll just need to figure out a way to do it. Tracking interconnection facilities and dedicated facilities or required facilities, whatever we're going to call it. I think about our asset accounting system. We haven't done this before. And so I think a lot of that gets lost when we do group depreciation and when we unitize this is getting very technical, but we unitize projects in our asset accounting system. They lose some of the characteristics that would identify them as driven by a particular customer or part of that dedicated facility. So, how do we do that and then somehow reconcile our asset accounting systems to maybe some separate database that we're using to track these items? So I think it's incredibly complicated. I think any change that we make, it's a significant change from how we've done it for decades. So I think we just need to be thoughtful. And I think we also need to understand that we need to have a way to technically do it. And that might take some time to work that out.
And what actions has the company proposed that you think are particularly important for establishing an appropriate balance of risk between the company, existing customers, and prospective ESA customers?
Yeah, I'm not sure that I have a lot to add over what the large load panel already addressed.
That's fine. And Ms. Bateman, witness Hager suggested that you may be able to provide some insights on this question. And that is this: could you help the commission understand what goes into designing a new rate class?
Yes, so I started to talk about that, where you create another column in the cost of service study. And probably the most challenging part is having the load research for that customer class that would then go into the development of your allocation factors. So you'd get a load profile. You need to know kind of, is it primary, secondary, transmission, what voltage they're taking at, and some load characteristics that in actual historical data that you would use to develop your test year allocation factors. And then from there, and if you have customers on a particular rate schedule, so what rate schedules go into that class, that's where you'd include the revenue, and then you'd use the allocation factors to allocate the costs into that column. So I think those are the main things. In having that historic data to develop the allocation factors and the load profiles, I think is probably the most challenging. I will say, and I think the prior panel alluded to this, if we have a separate rate schedule, so whether it's the high load factor rate schedule or a different large load tariff, if we have that rate schedule and then we have load research data for that rate schedule, we can, within our cost of service study, break out the rate schedules. So I think about large general service, and then we have an LGS TOU. So we file just a large general service column in our cost of service study, but we can provide breakouts, and we do, to the public staff of LGS and the LGS TOU tariff. And so we could do that if we had a large load tariff. We could provide that breakout of that large load tariff to see if it warranted a separate rate class.
Thank you. I think that covers all the questions from our commission staff. Let me see if my fellow commissioners have questions, beginning with Chair Brawley. Commissioner Tucker. Commissioner Vandervaart. Commissioner Gaida. You're the last panel of the day. There are now opportunity for questions on commissioner questions.
If I may be given a point of order here, just one final question, and this relates to an inadvertent misstatement from one of our earlier witnesses on the rate impact of the settlement. And given that we've had a few questions on the settlement, and in the interest of clarity of the record, we're going to be filing a late filed exhibit as Presiding Commissioner McKissick, you requested. And so all the information be laid out there. But just because we want there be no misunderstanding on that, if it'd be okay for me to ask Ms. Bateman very briefly to just reiterate the average and residential impact of the settlement, because that was a point of that confused, I think, on the record, and that was on us earlier in the record. So I thought at this moment in time, it'd probably be appropriate just to make sure that's very clear for the commission as we.
Ms. Bowman addressed that.
I believe that's correct. Yeah.
Okay, so I'm going to go ahead and permit that. Sure.
Thank you. Just very briefly, could you reiterate for the commission the average and residential impacts, rate impacts resulting from the comprehensive settlement?
Yes. Okay. For the average retail impact, it's 3.7% increase in rate year one, and then an additional 3.1% increase in rate year two. So that comes to an average of 3.4% over the 2-year period. For residential, the rate year one impact is a 5.7% increase, and the rate year two impact is an additional 3.6% increase.
Thank you very much. And I apologize about that error, and we appreciate the opportunity to clarify that. And we will be filing a late filed exhibit to memorialize those.
If you can, we'll look forward to receiving the late file exhibit. I did have my earlier notes from what was recited, as well as other information I'd received from other sources, but will depend upon the exhibit for providing finality.
Thank you.
Any other questions or commissioner questions? Well, let me thank you both for being here this afternoon. Ms. Bateman, as always, you come in well prepared and provide explicit testimony relating to all the questions that we asked. So we release you at this time.
Thank you.
Thank you.
It's a little sentimental. This, the last DEP rate case. I think I was a witness in the first one too, so.
And now you'll be a part of the new consolidated
Yes, yes.
DEP and DEA. Because it's going to be known as Duke and EQ Carolinas. Yeah, exactly.
I hope not.
We will have a strong presence here in Raleigh. That's not changing.
You didn't get the memo? Thank you very much.
Thank you.
And we're in the final stages of this hearing, and it's also approaching 5 p.m. Let me first take care of a little housekeeping. I know that Commissioner Vandervaart was out because he had some personal family matters that had to be attended to. We have normally in the past excused those absences and let people read into the record testimonies as long as it's not some long expansive period. And I know Commissioner Guido was out for a little time this morning. I know he was observing our proceedings on YouTube during that period, but are there any objections to either of them reading into the record what they might have missed during times they were not present in the hearing room? Let the record reflect that there were no objections stated relating to that. And we're going to go ahead now and go back to, of course, Mr. Felling and Mr. Snowden. Were you able to work out anything relating to the objection I was asked to rule on earlier relating to?
I hope so. So Presiding
Okay.
Commissioner McKissick, Mr. Felling and I have worked out a solution to address the public staff's concerns about completeness, and that is as follows. Microsoft would request to be admitted as our public staff large load cross exhibit 1, specific lines and pages from the DEC hearing transcript that that were referenced during the cross examination, and to redact the remainder of those pages. And I can give those specific lines and pages here if it would be helpful, and then we can.
If you could, I remember
Yes.
them being referred to, but for the completeness of the record, I think if you could eliminate
Yes.
any ambiguity at this time, it would be appreciated.
Absolutely. Okay. And so these pages are from Microsoft's potential cross-examination exhibit number 4, which is volume 14 of the DEC hearing transcript. So, and I'll start by giving the page numbers of the exhibit, and then I'll give the transcript page numbers that those correspond to, just for clarity. So it'd be the following ranges, pages 82 and 83 of the exhibit, and that corresponds to volume 14, pages 252, starting at line 9 and going through page 253, line 7. The second passage would be page 90 on page 96 of the exhibit. That's page 266 of the transcript, lines 10 through 18. And then the last passage would be on pages 111 and 112 of the exhibit, which corresponds to transcript pages 281, starting on line 15 and going through page 282, ending on line 22.
That is your motion, that that be?
That is my motion.
All right. With Mr. Felling, is that your understanding as well, sir?
Presiding Commissioner McKissick, that's correct. That resolves the public staff's concern regarding completeness, and we appreciate Mr. Snowden trying to find a agreeable resolution.
With that motion being into the record at this time, it is hereby allowed, and that is explicitly what will be admitted as part of the record.
Thank you. And we will file an appropriate exhibit per the commission's instructions. We'll confer with the public staff, make sure we have the right lines there.
That would be excellent. Thank you. Are there any other outstanding procedural matters? Yes, sir. Our friend from the Department of Defense and all other federal agencies.
Thank you, Presiding Commissioner McKissick. I have an inquiry. There's been several references today to the order requesting comments in the DEC case that was issued yesterday. And DOD FEA is not a party to that case. And so I wanted to inquire whether we should expect a similar order in this docket.
Yes.
Thank you.
Are there any other procedural matters?
Yes, thank you. And just sort of along those lines, will the record be left open for receipt into evidence of those comments at a later date? Presiding Commissioner McKissick?
Those comments will be filed, so I mean, they will already be part of the record at that time. I do not anticipate there being further testimony. But there will be, you know what I mean?
I do. Thank you.
Yes. Go right ahead.
I will add another procedural wrinkle here to that. Assuming we are, as President Commissioner, you said, the commission anticipates issuing a similar order in this case. If it's clear to the commission right now how the dates for proposed orders would be handled relative to that that stakeholder process, specifically with regard to any proposed orders, posting briefs on large load tariff issues. We would appreciate that guidance if you all can provide that right now or whenever it's available.
I would not be in a position to provide it at this time. I would not want to add to a cloud of ambiguity. It is in the process of being finalized, and the information should be forthcoming in the very near term.
Thank you.
And then Rita Coxton on behalf of the AG's office. I wanted to clarify something related to the testimony that we moved into the record for Mr. Casera, one of our witnesses that was excused.
Yes.
It does include confidential information.
It does include.
It does include
confidential
confidential
information. Okay. So for purposes of the record, let it reflect that that particular testimony included confidential information, and it has been duly noted and modified as a result of your comment at this time.
Thank you.
Any other procedural details or loose ends that we need to tie before we go ahead and wind things down? Before we do so, I do want to thank our staff at the commission. They've done an outstanding job for us as always, particularly Annika, who has served as the lead attorney on this case. I appreciated all of your ongoing work over the months that have preceded the hearing and during the course of this hearing. And of course, James West, our general counsel, as well as Josh, who's our deputy general counsel. We also have our paralegals who do an amazing job as well. Stacy isn't here right now, but she did a lot of work. And of course, Stephanie has been there helping, and she's pretty much new to the game, but she's come through for us. In addition, you know, our whole team on the operations side as well, from Freda to Nathan to Artie, Forsima, Sarah, Greg, John, Jen, and Lee. I hope I have not omitted anyone. We even have our folks upstairs that help us daily to get ready. Lavonda, Kathleen, we thank you as well. Most importantly, I want to thank our Chair Brawley, for permitting me to preside over this hearing, and thank the team that we have in our clerk's office, Kim and Kaylee, for assisting to make sure each and every day we have people here that are taking these transcripts that are the most important part perhaps of what we do. And I want to thank the regulatory bar. You guys you represent your respective clients in a very effective way, but you also work together collaboratively to get the schedules together and to do what's needed. So we as a commission can listen to the testimony, ask the questions, and more importantly, learn through the witnesses that come before us, the nuances, the details that are present in this case and every other case that come before us. So I thank each and every one of you. And on that note, just a few final words. Without objection, any pre-filed testimony and any pre-file cross and redirect exhibits which were marked for identification and for which I have not yet made a ruling on at this time are hereby deemed admitted. Post-hearing briefs and proposed orders are due no later than 30 days from today. If there's not any other further business to come before the commission at this time, and I'm not seeing any, we hereby stand adjourned. Oh,
I'm
excuse
so
me.
sorry.
Yes, go right
Zoning
ahead.
Commissioner McKissick, I just have a question for clarification. Is it 30 days from today or 30 days from publication of the final
It
transcript?
should be 30 days from the final transcript.
Okay.
That is what we normally do. However, in the information that was provided, it read otherwise. So I hereby stand corrected for purposes of this hearing. So thank you for clarifying that very, very, very important detail.
And our sanity thanks you as well. So thank
Yeah, well,
you.
well, otherwise we would ask you to prove your sanity. You'd have to bring in a certificate. On that note, we hereby stand adjourned. Thank you all.